My lord, may I be permitted to mention, I am the creator. No application for section 5 and no stay application has been filed, my lord. Without serving any copy, my lord, the court grants us this order. My lord, kindly see the order
No, then you have to apply for vacating. Yes.
for vacating, my lord.
My lord, kindly.
Yes.
This division bench,
Application for inclusion.
Please.
or to be let it appears to be mentioned, my
No,
lord.
no, no.
Lord,
Fair din.
Lord, I speak for my lord, kindly my lord to mention a review, madam lord, review of a judgment delivered by my lord with Justice Bhattacharya, but not we want to withdraw, my lord. So, my lord, if it could be listed before my lord, my lord.
My lord, may I permit to
application
mention?
Yes.
I'm grateful to Lord.
May I permit you to mention one application for hearing?
My lord, application for restoration and application for stay, my lord. May I permit to mention one matter?
My lord,
Stay
my
of
lord, since 2000,
modified lordship, appeal is pending before.
What are you mentioning? Application?
This application?
For?
Modification of stay order.
Please hand over.
On prosecution of 157.
this is hearing, my lord.
No.
My lord, 2000, my lord, since we have
No.
partition suit.
Yes.
Group 1 of your application.
Lordship permitted.
My lord, may I be permitted to mention for inclusion one can application?
Yes.
Lordship permitted to mentioning for restoration application, your lordship.
My lord, inclusion of a hearing matter.
No.
Lordship, inclusion for new motion.
No, the new motions automatically come. Need not mention. Yes, call on this.
My lord, sorry, my lord, I my lord made a mistake. My lord, the judgment my lord, of which my lord, we had applied for review was by Justice my lord, your lordship, sitting with Justice Uday Kumar, my lord. But my lord, we want to withdraw, my lord. That's why I'm saying, my lord, it should not be. There should be no difficulty in withdrawing, my lord.
So you're saying there will be a modification then?
No, I'm praying for withdraw of the review application. That's what I'm saying.
Regular
Yes,
basis.
yes. But it was, I'm grateful to your lordship. Your lordship judgment was affirmed. Your lordship passed a decree of eviction. No, that has been affirmed by Supreme Court. But we had applied for review only for the purpose of mean profits.
But you don't want to press that.
But in the meantime, they have given position, but on the condition that I'll not press for mean profits. So, Lord, we have withdrawn.
Yes. Call.
I'm for the respondent.
Let's check in.
Well, both the cans are already disposed of, my lord. By order dated.
Can we see them?
Because, my lord, I have not yet served the paperwork, my lord.
So you have filed paper books?
They have filed the paperwork. That's what I understood. That was the last order, my lord.
No, you mentioned this.
I have mentioned it.
For what? For what sort of order?
My lord, for they have not yet submitted the paperwork. That's what.
Ascertain from the department whether it has been filed or not.
Certain, my lord, they have filed the paper.
Take it from the department. Why mention the matter? No, another difficulty. You are Mr. Islam.
Yes, my lord.
You have filed a wakalatnama on behalf of the sole respondent. On scrutiny, it appears that Mr. Mohabub Islam signed in the said wakalatnama on behalf of the sole respondent, as he is the constituted attorney. But power of attorney has to be filed. Please file the power of attorney also in the report. Learned counsel for the respondent submits that the respondent has not been served with paper books, although those have been filed. Full stop. Next para. The learned advocate for the respondent is permitted to collect the paper books from the department. Full stop. Next para. Also, comma. The learned advocate for the respondent shall file a power of attorney indicating that the person executing the wakalatnama is the constituted attorney of the respondent. Thank you. Next.
Your lordship, this has already been dismissed for non-prosecution, your lordship.
So why did you mention it?
Did not mention it, your lordship. Possibly by mistake it has come, your lordship.
भूल करो ना कि missing slip.
August,
এটা ডেট কেটে কে করেছে? আপনি করেছেন। Since the matter has already been dismissed for default, no further order need to be passed.
Dismissed as non-prosecution.
Achha, since the matter has already been dismissed for non-prosecution, no further order need to be passed. The matter be reflected in the CIS as disposed of. Thank you. Thank you.
Lord, I appear for the respondent, and your lordship will kindly peruse my lord's order dated 18th of November at paragraph, Lord, 13, Lord. Therefore, Lord, I was only to indicate before your lordship whether, Lord, we want this appeal to be heard or not.
Oh, achha.
My lord, Mr. Thakkar is leading me. He's on.
Yes, we see Mr.
Yes,
Thakkar.
Permit me to appear.
So, my lord, it was for me to indicate whether, my lord, I am willing. My lord, I am always willing to have my appeal heard. Because, my lord, they are enjoying, my lord, the first floor of the property, which is a huge property, my lord, in Bankim Chatterjee Street, in the house where, my lord, where Mohabodhi Society is. The entire first floor. One, my lord, the ground floor, my lord, there is one, my lord, shop room of 220 square feet, according to their own plain case. One car parking. Your lordship has injuncted me, my lord, not to proceed against, my lord, a occupational charge of 1650, which was the contractual rate.
The application is still pending. It has been kept pending.
This application, my lord, which your lordship has, my lord,
Yes, apparently.
this application is,
Yes,
my lord,
lord.
pending. This
Pending.
application-
Injunction was granted since when?
Now, my lord, your lordship will kindly come to paragraph 12. As a condition of such injunction, that shall go on paying an
The
amount.
disposal of the application.
Yes.
We'll direct the application and the appeal to be listed together. Then the paper books
But
have to
the
be.
paper books are to be prepared by my learned friend, my lord.
Do it, my lord.
Because
Then we'll dispose of the application. Then we'll dispose of the application.
if
What's
your
the-
lordship was, my lord, if your lordship hears the appeal, my lord, once and for all.
So paper books. Yes,
This is
Mr.
a very
Thakkar.
old, my lord, suit. And
Mr. Thakkar,
somebody else is occupying, my lord, the property of the
No, but
society.
then the trial court records have to be. Everything has to come.
But if they do
If
have,
you are agreeable to prepare the paper books, then we can do that. Informal paper books.
I'll just take instruction.
You won't.
That I
No, no.
understand, Lord.
Lord,
But let's let prepare, Lord.
Yes, Mr. Thakkar will direct you to prepare paper books. You direct the. But
Yes.
what's the fun in keeping the application pending then? Because we have granted till disposal of the
But
application.
maybe I'll come up with, Lord, opposition to that for the purpose of mean profit, Lord.
Well, this was a suit for declaration of tenancy, not a suit for eviction.
Oh, there was no
I-
prayer for eviction.
No, there is a eviction suit pending, Lord, in the court.
That's different, Mr. Mukherjee. Then, but
No,
we'll
no,
dispose of the application. Let that be the in that on the terms as directed in that order. And we'll prepare paper books and you are appearing for the respondent one. Other respondents should be served. Or
my lord, 2 to 9 was not representing before the trial court. So, your lordship, in the last paragraph of your
dispensed
lordship,
service.
last paragraph 14.
Service of the application. Probably.
Paragraph 14, your lordship has.
Notice of the agreement. Very good.
But we'll file it in 10 days. If your lordship permits us 10 days, we'll expedite the hearing of the appeal. We don't want to keep.
We will direct you to put in the special messenger costs for the records within a week, and
Yes.
the everything is service is dispensed because
Yes,
already
yes,
dispensed. So paper books, if you have all the papers, Mr. Thakkar, you can prepare informal paper books.
We will do that. We'll do that. Well, we'll prepare informal.
But in
paperwork.
first appeal, Mr. Thakkar, first appeal that may be difficult.
Yes.
Don't take the risk. Don't take the
Mm,
risk.
yes.
Evidence.
Regular appeal now, my lord. It's not a.
Yes. Learned senior counsel appearing for the respondent number one submits on instruction that the respondent number one is agreeable for the appeal to be disposed of at the earliest. First of next para. Accordingly, can one. This was.
Can two.
Can 2 of 2025 is disposed of. Thereby extending the interim order dated November 18, 2025 till disposal of the appeal on the terms and conditions as imposed by the said order. Because of next para, as already recorded, service of notice of the appeal on the respondents is dispensed with. Push up the appeal be treated to be ready as regards service. Push up the appellant shall deposit special messenger costs for bringing the trial court records. Push up the appellant shall also prepare and file the requisite number of paper books within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
If your lordship fixes up a date, Lord, for hearing, Lord.
If the paper, nothing is ready, Mr. Mukherjee. Let the trial court records at least come.
Very well.
Deeply obliged.
Thank you. Port, yes. Yes, Mr. Vandavata, what is the matter?
4 and 5 are
4, 5
virtually identical matters.
4, 5 দুটো দেখে দিন. Yes, what is the matter? Why appearing as to mention, Mr. Vandavata?
I have personally no idea. Probably my junior mentioned because of the urgency.
400 poor workers, you are citing them,
Yes.
but you are the company. As if you are so bothered with the poor workers.
Certainly, my lord, it doesn't establish. It's a granite mining. Well, the lease was supposed to be
They
renewed
work,
for
they earn
1 term.
salaries. You earn.
It was extended by the learned single judge by the earlier order. Then again it was remanded back, it was rejected. Then the writ petitions,
What has been rejected, Mr. Bandyopadhyay, by the
prayer for renewal.
renewal of lease?
Lease.
But now a new regime has come in probably. This is what my minerals.
This is granite mining.
Oh, achha.
This is under the granite conservation rules, read with 2002 rules. Now, your lordship had also delivered 2 judgments, my lord.
So we'll put it in the hearing list, but
No,
not
this
any
is
preference.
application stage. It was never hard because of the urgency, because the lease expired.
You could have just mentioned the application, it would have come in the list.
Well, that is probably mentioned. That was probably mentioned, the application only. And that is now that was
The
running.
mentioning slip, it's written to be mentioned by the junior. That's why it is appearing to be
That's
mentioned.
Well, in fact, it was running in the list.
No, it was appearing in the application list. It
Yes,
was
it is
mentioned and brought
appearing.
in the.
It was appearing. Well, I was just praying some upgradations if it's not.
What is the application for?
Application for stay of and in fact the
No
application
scope of stay.
no applications for extension
Expedition.
of lease. It was once granted.
This is no scope, lordship.
You are moving this application, Mr. Bandyopadhyay. That is tantamounting to allowing the appeal.
Yes.
How can you do that?
Well, foreign.
You prepare paper books, all the respondents are appearing.
I appear for the state respondent.
State
Only
respondent.
state respondents. There are no other respondents.
State means all up to 5.
Yes.
Very well. You are for whom?
I am for the state. First item.
Item number 5.
I am. in
Oh, achha,
item
4 and
number
5.
four.
Well,
Okay,
in
very
fact,
Two
there's
matters.
nothing to. Only at the stage of
You prepare your paper books, how soon can you
No
prepare?
papers is there, only writ petition. That has been only that can be.
There was
filed.
no opposition, nothing.
No opposition, no
No
reply.
opposition, no.
Not called for even.
Use a short report or affidavit within 3 weeks, because
No, if they in the writ court you did not, then how can you prepare?
it was hard, we left and rejected.
No, we'll direct the application along with the appeal to be listed together. I will direct them to prepare.
Learned single judge, I'm just telling you, 2 minutes. Learned single judge initially found that the renewal was rejected on as per rule 61 and 62.
We'll put it on the hearing. How soon can you prepare the paper books? You say on these papers, then we'll hear. Very. Learned senior counsel appearing for the petitioner apparent submits that there is extreme urgency involved as the fate of 400 workers is at stake in view of the learned single judge having dismissed the prayer of the writ petitioner for renewal of mining lease. For sub next para, since all the parties are represented through counsel and due to the identity of the causes of action involved in the 2 appeals, let MAT 1865 of 2025 appear along with MAT 1866 of 2025 to be heard analogously in the monthly list of December 2025. Full stop. In view of in view of the ambit of the appeal being short, formal preparation of paper books is dispensed with, and the appeal shall be heard on the papers already on record. It will appear in December month hearing. As we are disposing of this can.
Yes.
Can 1 of 2025.
Only the papers are there only in the can.
Sir, can is.
No, we'll keep it on record.
Can to all of that.
Can is.
Just very well. Along with can. Along with
Let it be there.
it appeal hearing list. Along bracket can. Yes.
Great.
Thanks.
Item number 6, I'm sorry.
When does it expire?
30th
30th.
November.
What is the nature of the
This is the loss you can remember. Railway property. We
Right.
are
Encroachment on railway land
are you appearing, Mr. Dev, for all the
for all the respondents.
Union of India?
Union of India. That all of.
So we'll what about
So
the
can you
service?
see the last order? Lordship,
Yes,
in
yes.
this one.
Checking it. Where the writ petition has been annexed in this step. Was there any affidavit in opposition also in that?
Yes.
Madam,
Affidavit of
Affidavit exchange.
complete.
Everything is
No, all have been annexed here.
Filed here.
it has been filed on the last day.
In the
Oh.
repetition, there was no.
Oh, acha, in this. Acha, very well. Then we can hear the appeal itself on the.
Yes.
We'll extend the interim order till disposal of the appeal. We'll direct the appeal like the previous matter to appear in the next monthly. Monthly means next week.
Madam.
The interim order granted is extended till disposal of the application. First of the application shall be heard along with the appeal on the papers already on record and be listed accordingly in the monthly list of December 2025. First up, in view of appearance of the respondents through learned counsel, comma, service of notice of the appeal on the respondents is dismissed.
Man.
So it will it will appear under the appeal hearing list along with that.
Man.
Thank you.
My lord, in item number 7, my lord, I am appearing for the defendant appellant, my lord.
Yes.
My lord, the plaintiff filed a suit for eviction, my lord, and that was dismissed, my lord. It was against us, my lord. Then we prefer an
Wait, what is the defect? Let us see the defect first.
my lord.
You should have checked up the defect before moving the matter. Any matter when you mention for order 41, please check whether there is any defect. It is not our duty to point out the defects to every appellant. In every matter we are saying there is defect and you don't even know what is the defect. This is a ridiculous situation actually.
My lord.
Please wait for a minute. Let us check up. Name of the learned trial judge is not there. The classification of the appeal in words is wrong. You have stated memorandum of appeal from appellate judgment. It should be appellate decree. Just make these corrections, please. Check up the stamp reporter's report and make the correction. And you have not filed the appellate court's decree certified copy, only the judgment.
No, my lord, we have filed in the department, my lord. But I don't know, my lord, why it has
No,
come
no,
from
you have filed certified copy of the judgment and degree of the trial court in the department. But the decree of the appeal court has not been filed. It will go out of the list, you correct the defects and then mention. We find from the report of the additional stamp reporter that there are several defects in the appeal. Full-stop leave is granted to the appellant to correct such reports, correct such defects. Full-stop for such purpose, comma, the learned advocate on record for the appellant is granted leave to carry out the necessary amendments to the memorandum of appeal. Full-stop, the appellant shall also file the certified copy of the decree of the appellate court as and when the same is obtained. Full-stop, let the matter go out of the list with liberty to mention as and when all the defects are cured.
Lordship, in this matter, we are appearing for the caveated Lordship respondent, Lordship.
No scope of your appearance now.
Deeply obliged.
Give your name, Mr. Das. Give your name.
Lordship.
No,
My lord, item number 8, I am appearing on behalf of the appellant, my lord. My lord, as effective service has not yet been completed upon
Section 5.
Effective service.
Effective service of what? Section 5.
And stay application.
So the serve and come back. Let it go out of the list whenever.
It already served, my lord.
But it has not.
It is not. I have already served.
Not served. You have sent.
Yes, I'm saying.
When did you send?
Last week.
Last week. We directed you on 12th of November. Today we are on 25th of November.
Well, after passing the order, after 2-3 days after passing the order, I have already.
After 2-3 days, very well. Learned counsel for the appellant submits that service has not yet been effected on the respondent. So accordingly, let them stand adjourned till December 15, 2025. Next. Yes.
But I am the defendants in a suit for partition. But the order of injunction is under challenge. Generally, in partition suit,
injunction has been granted. That you have said.
But when in my case, specific defense was that the suit property, along with other properties, have been partitioned in other two suits. One is of 1948, another is of 1973. Where, my lord, the solemnum petition was filed and it was declared compromise in final form. Therefore, my lord, my predecessor got the entire property in plot number 247.
What was the finding of the court? Well,
court has said that whether
There
it
is
has
some-
been made by mates and bounds, that is not clear.
No, you produced decrease of court.
Decrease of court. It is my lord, third page.
Yes, third page from
From the pleadings and documents filed by it is admitted position that plaintiff and contesting both have acquired share in the suit property. From the documents filed by the defendants, prima facie appears that earlier two partition in the suit property were held only in respect of shares, but not by mates and bounds. Though in partition of 1948, specific portion is mentioned, but not by mates and bounds. It appears to this court that whether the partition
the final degree of partition was produced by you.
Yes, and not only that, the record of rights have been prepared subsequently.
But final partition degree has been produced by you.
Well, yes.
Please check up Mr. Mahato with the final degree. Anyway, we have to admit the appeal. We are admitting right now
Yeah.
and directing you to serve copy of the memo as well as the can. We'll hear it on the. No, there may be other documents also. What have you annexed here? Plaint?
I have annexed the plaint. I have not
No,
annexed the injunction application, objection, and the documents relied upon by me. But
Acha. Plaint, you keep a copy handy whenever.
Yes.
Plaint and written statement has been filed as yet by them. Written statement. You check up.
Statement. I shall check up.
So we'll direct you to serve copy for the time being. We are admitting the appeal. The
If
present
you
appeal.
admit, then it will be heard by the single bench.
No.
Division. Kindly fix a date, manner, so that I can.
The application will return. Make a returnable date for the application. Then you come prepared with whatever is there. We can direct the appeal to be. The present appeal has been preferred against an order of temporary injunction passed in a partition suit. Full-stop learned counsel appearing for the appellant submits that even in the teeth of final decrees of partition passed in previous suits, comma, which were produced by the appellants before the learned trial judge, comma, injunction was granted, comma, despite the property no longer being joint. Full-stop next para. The above appeal is the present appeal is required to be heard on the above questions and the other grounds taken in the memorandum of appeal. Full-stop accordingly, FMA 1142 of 2025 is admitted. Full-stop next para. The appellant shall serve copies of the memorandum of the appeal as well as can 1 of 2025 on the respondents, indicating that the application serve on all because partitions. The application shall be listed next on December 15, 2025, when an affidavit of service to that effect shall be filed by the appellant. There is no scope of appeal.
Defendant number December 3.
December 15th.
December 15th.
Today, to about 3 weeks out.
I'm good.
Thanks.
I appear for the appellate lawsuit.
Yes, Ms. Joja, what is the matter?
My lord, at the outset, I said there is an application for delay, my lord. But the matter is, this is the appeal challenging the ad interim order of injunction, my lord. A suit for actually restraining.
Delay has to be heard first. What
Yes,
can we do? So serve copies of.
My lord, a week's time may be given. I will serve and
Within a week, you will be able.
Yes, my lord. I'll serve and come back.
There is an interim application. We will direct you to serve lock, stock, barrel, everything.
Yes, my lord. I will serve.
Learned, the appellant shall serve copies of both the applications as well as the memorandum of appeal on the respondent, indicating that the applications shall next be listed on December 2, 2025, when an affidavit of service to that effect shall be filed by the appellant.
But can it be December 3, my lord?
December 3 go to
Deep replace.
If they appear, then take a chance. We can fix the appeal itself.
Lord, I beg to appear on behalf of the.
Yes, Ms. Maiti, what is the matter?
Lordship.
Yes.
It is an order passed by the tribunal directing the BLR to decide the matter regarding the correction of the record of right within a period of 6 months. And the Honorable Tribunal also held that there are so many litigations. But this is the subject matter of the property is a deed of gift, my lord.
Ms. Maiti, why are you aggrieved by that?
I am coming to that, your lordship. Kindly bear me for some time. So your lordship will find from the documents that deed of gift was executed by a husband, namely Girish Chandra Patro, on 1st May 1916. But thereafter, the Hindu Succession Act came into force in 1956, and a suit was filed, had to file by the wife who was gifted this such property in the year 1916 for the
1916.
16.
The same year.
No, 1961. I had to my
61.
si- si-
Gift deed was of 16.
the deed was of
Suit is of
1960.
61. Very well then.
I had to file as the property was not recorded in the name of Putimoni Dasi, who was
Putimoni is the wife.
wife.
Acha, suit against whom? For
Suit
what?
against government. They are the contesting party. The suit was decreed in favor of the Putimoni,
Thereby declaring what? Your title.
declaring my title,
And
position,
consequence.
title and possession.
Very well.
Thereafter, my lord, what has happened? My lord, property was recorded in the name of my only son, Sudhir Patro. Later on, I come to know, my lord. But in the 1965, I have gifted such property to my grandsons, 4 grandsons. All are sons of Sudhir, my only son.
Which year you had gifted?
I
Gifted,
deed of
Putimoni gifted when?
1965.
Gift to sons of Sudhir as well as others.
No, only 4
Acha.
sons. 4 sons of Sudhir, my only son.
Very well. Very well.
Later on, my lord, application was made.
But it was recorded in the name of Sudhir.
Record the name of Sudhir.
So then?
Then, my lord, application was made so that my name would be corrected there.
Your name? Who are you?
I am the wife.
Of?
Wife of
Putimoni. You are Putimoni.
Giris. I am Putimoni.
How can it be recorded in your name if you have gifted to sons of Sudhir?
No, before that, I have gifted them. My prayer was, Putimoni's prayer was to record her name in the RS record of right. Later on, I have gifted them, but Putimoni's name was never recorded.
If you have gifted to them, then your name cannot be recorded.
That was made at that time. After death, they have come to.
Who has come? Now, who are you?
4 grandsons.
You are the grandsons.
I am the grandson.
So, you have filed for what? For recording your name?
Recording my name?
Your father is still alive?
No.
So, why did they refuse?
4 sons, yes, our father still.
Sudhir is
alive,
still there?
Alive.
So, it is still in his name, recorded in...
Still alive.
The recording is also in his name, Sudhir's name.
Sudhir's name was recorded erroneously.
It is still in the name of Sudhir.
Sudhir.
You want to record your names.
My name.
Why was it refused?
But so many, first time it was not refused, but it was kept pending for years together. What prompted the appellants before your lordship to make an to move this Honorable High Court in the year 1981 for non-correction of the record of it. Mandatory order was passed within 6 weeks. That has to be corrected. No correction. BLO city tried over the matter. Again, Honorable High Court was moved in the 1988 within 6 weeks to execute the order, implement the order passed by the Honorable High Court earlier, 81. But no correction was made. So, in the meantime, what has happened? Contempt application was filed. During pendency of that, West Bengal Land Reforms and Justice Act came into force. So, I had to move the Honorable Tribunal. Honorable Tribunal directed to dispose of the representation within a period of 6 months.
So, you are agreed with that?
No, I was aggrieved. So, according to the order passed by the Honorable Tribunal, BLLO started a proceeding and dealt with the matter and rejected my prayer on the ground that Putimoni was granted limited interest. So, he has
not transfer.
No transfer. Whether after the Honorable High Court's order for 2 times, mandatory order was there, I have annexed also to your lordship.
So, 2 High Court directions to correct the name directly, not to consider.
Not to consider. Again, I am coming to that. After the order was passed by the BLR in 2005, I moved the appellate authority under section 54 of the Act. Appellate authority set aside the order passed by BLR in the year 2010. Since then, till date, no correction. So, now if an order is passed, directing the BLR to consider.
You went to the tribunal to ask for that correction to be done, implementation of the previous directions.
My lord. No, your lordship kindly have a look to last.
You have now approached tribunal, Ms.
Last
Maitri,
slide.
you have approached the tribunal to implement those orders, previous orders.
Yes. That was my prayer.
Very well. Last line.
Last line of the order, I am agreed, my lord. Subject to your lordship kind consideration. I am aged about more than 80 years old, my lord. 1960 161 to 65, those had happened, your lordship kindly have looked to that.
So you say merely the consideration of representation won't do. Now, tribunal was to direct implementation of that order.
Implementation and to correct the record of right, your lordship.
Acha, please show us the previous High Court order and the.
My lord. But your lordship will find, I beg pardon, my lord. First order, my lord, that is,
First order is page 46, my lord.
Page 46.
my lord. Page 46.
46.
Second is 83.
No, second is 51.
Second is 51.
Then LRTT 56.
ये number भूल लिखे
First order is 46. What are you saying?
Yes, my lord.
your lordship last
46 is the middle of this page.
Civil rule 9592.
No, that is the page is not telling.
Oh, pagination. Then, my lord, this is 46.
your lordship only relevant page is page 40, my lord, 50.
4950. Ordering portion.
4950. Hence, it is ordered the rule is made absolute. It is in the nature of manner must be issued, directing the opposite parties to act.
Telling, my lord.
Judgment and degree. Yes, it is not telling.
Not telling.
Not at all telling. Anyway, the last order we have found is writ in the nature of mandamus, directing opposite parties to act in accordance with judgment and degree passed in title suit.
My lord. Opposite parties.
Was this the first one or the last one?
Record of right. Next line, my lord. Opposite parties are also directed to correct the record of right.
Yes.
Incorporate the name of the petition.
This was the first High Court order.
This is first High Court order.
Your lordship's page would be 83.
Yes, 83 is the page.
Your lordship, next, my lord, your lordship, this is the order passed on, my lord, 16 August 1960.
Page
84.
Oh, very next page.
Page 55, your lordship, kindly have it to. Oh, pata dekho sir, last pata. 83 ho dekho.
88.
My lord, this is page 88, my lord. Last page is page 88, my lord.
Pages are not at all telling. We have found the page. So after this, yes, Mr. Kali, we are directing to implement. We are modifying this order and directing to implement. Setting aside this order actually.
Lord, may I, my lord?
Yes, twice this was directed.
Lordship, my lord. Lordship. My lord, the last order lordship has seen the impugn order before your lordship. We accordingly dispose of this matter, directing the BLLRO to dispose of the representation of the applicant, subject to suitability convenience authority.
We have seen that, Mr. Kali.
In terms of High Court's order and within the lordship. Now, my lord,
correct the records of right immediately.
my lord, the suit, my lord, the suit was by Putimoni Dashi.
Maybe.
She was challenging, my lord, the 10-2 proceeding under estate acquisition act.
That is not there.
Yes, my lord.
That is not there.
Kindly seize the kindly seize the, my lord, decree. Kindly seize the decree, my lord.
But name of the petitioners were directed to be implemented.
No, lord. My lord, that is different, my lord.
No,
Kindly seize the
not that
decree.
different. One second, Mr. Kali. Please come to. Don't know whether the pages will tell you. Who are the petitioners in the writ petition? Swaraj Patro and
Swaraj
others.
Patro.
They are the present petitioners.
Yes.
Their names were directed to be corrected. There is a High Court order that is attained finality at page 83.
No, my lord, in terms of
we
the
cannot look back. We cannot look back. We cannot look behind a High Court's direction.
No, lordship, they after High Court's direction, my lord. Kindly seize they have participated in the BLR's proceeding. Kindly seize, my lord, because on the basis of 2 High Court's direction were there, my lord.
Yes.
Now thereafter, my lord, kindly seize the now they go to the LRTT. Kindly see page 50.
Because you are not complying.
No, LRTT, kindly seize the LRTT order.
Which page?
Page 56, lordship.
56 won't tell me.
89, your lordship, kindly have it. 89.
Page 89.
Why is the pagination like this, Ms. Maiti?
My lord.
Should have been careful regarding the pagination.
Yes,
yes. It's an order dated 15 March, my lord, 2005.
কোনটা দেখাচ্ছে?
2005, my lord, 15 March 2005 is the.
Their representation was only to implement the writ court's order.
My lord, that it was Miller kindly see representation BLLRO Kharagpur is directed to treat the copy of OA as a representation of the applicant considering the same in accordance with law. In compliance thereof, Milord, the proceeding was initiated. Kindly comes to Milord the next page.
What proceeding can be initiated after the previous orders? Their application was merely to implement the previous orders. What proceeding? Under which provision? Proceeding? What are you
44,
saying?
Milord, the Putimoni, even when
Forget
the,
Putimoni, Swaraj and these people got this order, 2 orders from the High Court.
Milord, they are claiming title through the decree.
Mr. Galib, your client is in contempt. We'll haul him up for this.
Milord, kindly appreciate,
Absolutely
Milord.
squarely in contempt of the High Court.
Milord, it's 9 days, Milord, kindly, Milord, bear with me for a minute. Lordship, here, Milord, Putimoni was given the life interest. In the
You
decree,
cannot reopen that. After Swaraj's name was directed to be corrected. You cannot reopen that. These are orders of the High Court, Mr. Galib. Not an order of your BLLRO. These are orders of the High Court of a constitutional court. 2 orders not complied with. Ask your BLLRO to be present in court. Let him answer for himself. What Putimoni did not have title? You cannot reopen that. Specific directions by 2 benches of the High Court.
Lordship, Milord, kindly thereafter, Milord, the matter went on to LRTT, Milord.
It shouldn't have. Because of your non-compliance, it went up to the ART. They are running from pillar to post. This is from 1981. They are running from pillar to post. Your BLR will be present in court today, day after tomorrow. We'll keep it day after tomorrow. Today we are on Tuesday. Thursday we'll keep it just to be mentioned the first matter.
Lordship, Milord, the Lordship may give them in a mandatory direction, Lordship.
We are.
Lordship, Milord, instead of personal appearance, Lordship, kindly, Milord.
No. Appear personally and explain. He'll appear personally. These people don't understand unless they come to the court, Mr. Galib. We have understood these people to the court now, sitting in this jurisdiction. This case is a burning example of a travesty of justice. Full stop, next para. One Putimoni, the owner of the property by virtue of gift from her husband, had instituted a suit which was decreed in her favor, declaring her title. Subsequently, Putimoni gifted the subject property in the year 1965 to the present petitioners, who are her grandsons, who were her grandsons. Next para. Thereafter, the petitioners sought implementation of sought correction of the records of rights by recording their names by virtue of the gift deed. Next para. By an order dated March 2, 1984, passed in Civil Rule number 9592 within bracket W of 1981, this court had made the rule, a learned single judge of this court had made the rule absolute, and a writ in the nature of mandamus was issued directing the opposite party authorities to act in accordance with the judgment and decree passed in title suit number 262 of 1961 of the Second Court of Munsif at Midnapur. The opposite party respondents, opposite parties' authorities were also specifically directed to correct the records of rights, incorporating the name of the petitioners in respect of the lands described in Annex C thereto. Next para. However, the authorities, even after such direction, did not learn their lesson, which necessitated a further writ petition to be moved by the present petitioners by way of Civil Order number 9121 within bracket W of 1988, which was disposed of by another coordinate bench of this court on August 16, 1988, by specifically recording that in spite of the representation made by the petitioners for the purpose of implementation of the previous direction, the respondent authorities had not carried out the necessary corrections or the direction given by this court in the previous civil rule. As such, the writ petition was disposed of again by directing the respondents to carry out the direction of this court as given in the previous civil rule in accordance with law as expeditiously as possible, and preferably within a period of 8 weeks from the date of communication of that order to the concerned respondents. Full stop. The unfortunate petitioners, however, despite two consecutive directions of this court, did not get the fruit of the litigation and had to approach the BLLRO again for with a representation for implementation of the previous orders of this court. Full stop. However, the BLLRO, by arrogating himself to the status of a regular civil court, came to the conclusion that the said Putimoni, the donor in favor of the petitioners, had limited interest by virtue of her gift deed, and accordingly title did not pass to the present petitioners. Full stop. Obviously, such order was unceremoniously set aside in appeal. Full stop. However, even thereafter, the directions of this court were not carried out, compelling the petitioners to move the tribunal. Lastly, by the impugned order dated October 29, 2025, the first bench of the West Bengal Land Reforms and Tenancy Tribunal disposed of the original application of the petitioners merely by directing the BL and LRO, Kharagpur, Roman 2, District Paschim Medinipur, to dispose of the representation of the petitioners subject to his suitability, convenience and authority vested to him under the law, after extending opportunity of hearing to both the parties, as expeditiously as possible, taking note of the mandate of the orders of this court and the civil code, preferably within 6 months from the date of communication of this order. Next para. Learned senior government advocate submits that the said Putirani had limited interest, and as such the transfer itself is suspect. Of that apart, it is contended that a representation was filed by the petitioners themselves before the BL and LRO, and as such supports the impugned order. Next para. However, we are completely at a loss at what to say. We totally fail to understand as to why the learned tribunal, instead of directing the BL and LRO to correct the records of right as per the previous two directions of this court, again directed the BL and LRO merely to dispose of the representation, that too according to his suitability, convenience and authority vested to him under law, thereby reopening the entire exercise. Next para. We are of the considered view that the BL and LRO is prima facie in contempt of the previous directions of this court as narrated above, by not correcting the records of right as per those orders. Hence, there is no scope for further representation of any consideration of any representation of the petitioners. The only duty left to the BLLR is to correct the records of right reflecting the name of the petitioners as per the previous directions of this court, which have attained finality long back, being unchallenged. Next para. In such view of the matter, the concerned BLLR shall be personally present in court on December 27, 2025 at 10:30 AM, when the present matter shall be listed under the heading to be mentioned for November, as to be mentioned for passing necessary orders. The BL and LRO shall personally explain to court as to what prompted him / her not to comply with the previous orders of this court as indicated above on the said date. Affidavit is filed to be kept on record. Correct.
Good. But I have for the petitioner.
Yes. Yes, Mr. Vasu, what is it?
But the big riot is my vendor. But the land that has been sold to the father of the present petitioner in the year 1997 was a retained land of the big riot. BR form was submitted. A vesting proceeding was initiated. Ex parte vesting proceeding was initiated in the year 1995. My purchased land was vested. I preferred an appeal under Section 54 of the Land Reforms Act. The DLLRO divested the same. No appeal was carried out of the said proceeding. The order of the DLLRO attained finality. But may I place the order of the DLLRO? It's the 1.5 page order.
No, this is
Thereafter, Nothing was done for the period of 8 to 10 years. I filed a representation. There starts
8 to 10 years.
8 to 10 years. Nothing
Why
has
did
been.
you wait for so long?
My father was there. My father, after the order of the divesting being passed in the year 2004, my father was looking after the matter. My father died in the year 2008. We made a representation in the year 2010 and 11, around 2010-11, for execution of the order passed by the DLLR. The execution starts. The DLLR did not do anything. We approached the LRTT. LRTT directed the BLLRO to correct the record of rights as per the order of the DLLR on the basis of the appeal. Nothing was done. They were given, after the order passed by the LRTT, they gave a fresh notice of hearing, as if they are sitting on appeal over the order of the DLLRO. BLRO sent a notice.
Notice of hearing under which provision? Provision was quoted.
Provision, my lord, I will show to your lordship the notice that has been sent in page 98. A fresh hearing was sought to be initiated under the provisions of the. No, it says that appeal case number such and such which I have won before the appellate authority. Page 98.
In that appeal, in this case only that direction was passed by the dealer. This was
Yes, appeal court's order. I will show to your lordship.
Sure.
My lord, may kindly comes to the order of the appeal at page 90.
Yes.
Very short order. May I place it, my lord?
Yes.
90.
Starting from 91.
No. Kindly come to page 90. A very short order, but I may place it. This is an appeal under section 50 of the Woodburn Land Reforms Act challenging the vesting order of the OC vesting of English Bazar LR Circle in the vesting cell or investing proceedings number such and such. The case of the appellant as disclosed in the memo of appeal that the appellant purchased the land in question from the original from the owner Mohima Ranjan Das, who happened to be the big Rayat, in the year on 14th of February 1977, wide registered deed number such and such, measuring such and such. It is also the case of the appellant that he did not receive any notice of the vesting through, though continued to pay rent to the government of West Bengal, and the vesting order is illegal and unconstitutional. I carefully perused the purchase deed as well as the rent receipt. On scrutiny, it appears to me that the appellant never received the notice of vesting case. The vesting order was passed without holding any inquiry to the physical possession. The government also did not take possession, and the appellant is in possession, and they are financially poor farmer. I also hold an inquiry and verified the physical possession of the appellant and also examined the registered deed and the rent receipt. The plot number 177 of the Modak Jabgaji is an exclusive possession of the appellant of the satisfied to hold that the appellant is in possession and the appellant was not a party to the vesting proceeding and he is in exclusive possession. Hence, however, the appeal succeeds.
This was never challenged.
No. Kindly see the last paragraph of the order.
Yes.
Land be recorded in the name of the appellant by opening a new LR Khotian in the name of the appellant. This is the executive.
Never
portion.
challenged.
That was never been challenged by the state. It's attained its finality. Now, this was not been. This order was passed in the year 2004. Now, in the year my father died in the year 2008. Now, kindly come to page 93.
Yes.
This is my representation been given where from the execution starts. I made a representation in the year 2012 that this is the order of the tribunal, the appellate authority. You muted my name. This was a simple representation. Your lordship will get my prayer.
On this representation, this notice was given.
No, nothing was done. I approached the LRTT. Kindly see the order of the LRTT.
Where is that?
Page number page 101. Page 101. My lord, we kindly skip the first two paragraphs. We direct. Kindly come to the portion. We direct.
Yes.
We direct the BLRO to dispose of the notice issued under section 56, 57 in compliance with the appeal case number 40.
No, this is against this notice you have gone up.
Yes, but that notice is of 2003. 2000 notice is of your lordship will get the notice at page 98.
Yes, what is the date?
Date
8th August 2013.
We don't get the date on the notice itself.
No, on the second page. Second paragraph, দরখাস্ত নিরিখে আগামী 11/12/2012.
Second page.
Second paragraph of page 98.
Yes.
এত দ্বারা আপনাকে
What is the date of this notice? That is what
this
we are.
notice মানে
This is a returnable.
No, that ওটা এলআরটিটির ছাপ ওটা.
This is which year?
Well, the details of the notice will be apparent from the previous portion of the order itself. Though the notice date is not clear.
Previous portion of the tribunal's order?
Yes.
Let us go to the tribunal's order. So this challenge was preferred before the tribunal against this
Not a
notice.
challenge as such. It was contended before the tribunal that a process has been initiated under 56, 57. It has not been brought into conclusion. So a pure question of inaction, on which the BLRO was given a direction to conclude.
Let him complete.
After that matter, after the order notice been given, an order was passed by the BLLR that I have annexed in the supplementary affidavit.
What order?
The order that was passed by BLLR after the notice been given.
What sort of order?
What sir? Kindly see 15th of June 2024.
Read out just.
Today CR is put up along with the all documents before the undersigned. Go through the all documents and on scrutiny of retained land schedule of Riot with the consultation of the field inquiry report of the revenue officer and the report submitted by the concerned BLLR Habibpur that no free from encumbrance retained land schedule is available to consider such relief. That is, record is not available. Firstly, it is also mentioned here that the applicant failed to produce retained land schedule of the BR free from all encumbrances in exchange of the relief under section 14U3 of can be explored. When a BR form has been annexed in the writ petition, it was been produced by the BLLRO before the DLLRO. It is pertinent to mention that several cases have been instituted against the state of West Bengal before the Honorable High Court and the Honorable Land Reforms Tenancy Tribunal thereafter amongst one original application between 1722 of 2022 still lying pending before the LRTT. This original application is unconnected to my proceedings. The specific order of the DLLRO was to mutate by opening a new khutiyan. That order having not been challenged, the BLLRO on being subsequently approached by the petitioner before the tribunal cannot sit on an appeal over the DLLR's order and direct that the documents are not available, the written land schedule was not been produced. But this is in my dispute substance gross abuses process of law. If the DLLR order has passed an order,
it has been done in this order.
Oh, no, kindly see. No, they have said that documents is not available.
Only that.
Written form is not available. I will show to you, Rashid, the written form that was produced by the BLRO before the DLRO in the earlier proceedings. Kindly come to the page 77. Schedule of the land, my lord, page 77.
77, yes.
Schedule of the land allowed to retain in the name of the Riot from whom I have purchased. Mohima Ranjan Das, son of Monmohan Das, village such and such. My name comes in the second schedule. Jabgachi, Khotiyan number 286, plot number 177. So it was a retained land of the, so there is no question of vesting. The big Riot has retained the land in his own possession. That retained land was sold to me. And possession was not taken. At any material point of time, the dealer has come to a finding to that effect.
What is the present challenge? The tribunal did what? What did you challenge before the tribunal? The inaction.
But this order was my respective submission before your lordship. The earlier I have approached the LRTT.
So what are you challenging before us?
Challenge is before us I have preferred an appeal before the DLLRO challenging the order of the BLLRO. The entire abuse of the process of the court. I am bringing to your lordship's knowledge.
At best we cannot prejudge the appeal. If you have preferred an appeal against this order, why did you prefer an appeal against this order? Nothing has been done by this order. Nothing. Just approach the tribunal for implementation of the previous order.
That I could have done, but the petitioner was under the impression that if an order has been passed by the BLRO, the appeal lies. I could have approached the LRTT.
You drop the appeal, you will record that the appeal is dropped. Your appeal, you are not pressing your appeal, and will direct the BLR to correct the records of it, subject to sharing alone. Yes, what do you say?
Yes, my lord, my first point, my lord has seen the facts.
Yes, you have also seen.
Yes.
But the appellate authority's order has attained finality now.
Yes. My lord, there was a fact of, my lord, the order being revised at the instance of the state government, my lord. That was a fact in the interagnum. But, my lord, that will be on merits of the matter. My lord, I invite your lordships firstly to consider whether this petition before your lordships is at all maintainable or not.
Why do you say that?
My lord, will kindly come to the prayers. Their main prayer at page 11 is mandamus by directing upon the respondent to show cause. Page 11, my lord. As to why judgment and order dated so and so, passed in so and so, should not be executed. So this is
you should go before the tribunal actually.
Yes.
But kindly done with liberty because I have preferred an appeal before the DLLRO challenging the order of the BLLRO.
So
Why
once
did
that
you
is
do
over,
it?
probably-
But since the order of the DLR has attained finality, nothing remains open for adjudication.
What has been adjudicated by the BLR?
No, the DLR in the earlier proceedings, my lord, has
Yes, that has
that has come to a conclusion.
But,
So
wha-
they had no other option but to mutate by name by opening a new khotia. That having been not been
My
done
lord,
from
may I-
2004 up to 2024, my lord.
indicate this, my lord, if your lordships hold that this application is not maintainable, my lord, I will fervently pray before your lordships, my lord, not to make any, my lord, my lord, observation which might, my lord,
We'll have to record their
influence.
submissions.
My lord, the questions of, my lord, I say this, my lord, with all humility. If this petition is itself not maintainable, then, my lord, probably going into the facts, my lord.
We'll have to record their submissions. Made it
Yes,
for-
their submissions, but, my lord, as far as your lord.
record the submissions in a very exhaustive way.
Yes, but, my lord, I will invite your lordships, my lord, pray your lordships, my lord, not to make any, my
We'll
lord,
record the submission
observation.
of your talk.
Yes.
So that fairness is not hampered.
Yes.
We'll record your submission that since it
Because,
is
my
not
lord,
maintainable, we should not make any observation on merit.
otherwise, my lord,
And we'll record his full submissions.
yes. Otherwise, my lord, firstly is this that execution is should be before the tribunal itself.
So lucky that he has not gone before the tribunal and the tribunal refused and he has not come up against that.
I knew, my lord, when
Not
the
you,
previous
your client.
when the previous matter was being taken up, my lord, I knew that I was extremely lucky on that ground.
But why should we relegate him to another the tribunal?
That is the thing, my lord. That's why
My
I
lord,
approached before.
yes.
This is 226 jurisdiction.
To answer that, my lord, this
226 jurisdiction.
to answer that, my lord, your lordship, it is for your lordships to consider. This tribunal is a tribunal under 323B, which has been set up by taking away the powers of 226 court. This is not an alternate remedy. This is a substituted remedy. Once that is formed,
Right.
the powers of this court is limited only to judicial review of the orders passed by tribunal.
We'll record that. We'll record everything.
My lord, I will invite your lordships to hold that this is not maintainable, and my lord, I leave the rest on your lordships.
Learned counsel for the petitioner submits that the petitioner, one petitioner or several, the petitioner purchased the subject property from a big riot out of the retained land of the said big riot. Who's the next para? Subsequently, the BLLRO having vested the property, comma, a challenge was preferred before the concerned appellate authority, that is the DL and LRO. Push up. By an order dated, what is the date of this order? Illegible, page 90.
My lord, page 90, it's I'll
Date,
tell you, lordship.
date.
My lord, it is 8th of September 2004.
Is it September?
Yes. My lord, will you kindly see the next page?
Dated,
Next page.
by an order dated September 8, 2004, comma, the DL and LRO recorded that on scrutiny, it appeared that the appellant within bracket present petitioner never received any notice of vesting case, and the vesting order was passed without holding any inquiry as to the physical possession. First of the government also did not take possession, and the appellant was still in possession and is poor farmer? Seasonal.
Yes, my lord.
And he is a seasonal poor farmer. First of the DLR further recorded, further held on inquiry and having physically verified, comma, the possession of physically verified the possession of the petitioner, and also having examined the registered deed and rent receipt, comma, came to the conclusion that plot number 177 of Mouza Gabgachi is in exclusive possession of the present petitioner. Full stop. On such premise, comma, the DL and LRO set aside the order of vesting passed by the BL and LRO and directed that the land involved in the appeal be divested to the petitioner. Full stop. Next para. The DL and LRO, comma, being the appellate authority under section 54 of the West Bengal Land Reforms Act 1955, comma, further observe that the land be recorded in the name of the appellant within bracket present petitioner, bracket closed, by opening new LR Khutian in the name of the appellant. Full stop. Next para. It is submitted that such order attained finality, comma, having not been challenged before any appropriate forum. Full stop. Next para. However, comma, the BL and LRO did not comply with the same, and when approached by the petitioner, comma, the BLRO merely recorded that on scrutiny of retained land schedule of riot with consultation of field inquiry report, and reports submitted by concerned BL and LRO, no within bracket, no within double inverted, free from encumbrances, retained land, double inverted close, schedule was found available to consider such relief. Full stop. It was also recorded that the present petitioner had failed to produce retained land schedule of BR within bracket free from all encumbrances, bracket closed, in exchange of which relief under section 14 within brackets U, bracket closed, our open bracket 3, close bracket, can be explored. Full stop. Next para. Against such order, comma, another appeal has been preferred before the appellate authority, that is the concerned DLLRO, which is still pending. Full stop. Next para. In such backdrop, comma, the present writ petition has been moved, comma, seeking appropriate directions for the order of the appellate authority being executed. For sub next para, learned counsel for the respondent authorities rightly points out that this court does not have jurisdiction under Article 226 to directly pass directions as prayed for in the writ petition, comma, since by operation of the West Bengal Land Reforms and Tenancy Tribunal Act, comma, the power previously vested under Article 226 has now been conferred on the concerned Land Reforms and Tenancy Tribunal. Full stop. Next para. As such, comma, we are of the view, comma, by imposing self-imposed restriction in view of the provisions of the West Bengal Land Reforms and Tenancy Tribunal Act 1997, comma, that the appropriate forum for the petitioner would be to move the concerned tribunal. Full stop. Next para. However, comma, it is expected that in view of the nature of the narrative as spelled out above, comma, the appellate authority would dispose of the appeal expeditiously. Full stop. Next para. At this juncture, comma, learned counsel for the respondent authorities submits that since the writ petition has been held not to be maintainable, comma, no findings on merits ought to be returned by this court. Full stop. We agree to such contention of the respondent authorities and make it clear that the appellate authority shall act on the records as available before the same and shall adjudicate the matter accordingly. No address to cost. Liberty is accordingly WPLRT 186.
Within a fixed time.
No, we cannot do that. Even that the DRT has, the WPLRT. Accordingly, WPLRT number 186 of 2025 is disposed of as not maintainable by granting liberty to the petitioner to take appropriate recourse before the tribunal, if the petitioner so deems necessary.
Grateful, Your Lordship.
Next. পেন্সিলটা মুছে দেবেন আমি এটা নাকি পাতা চেঞ্জ করে চেঞ্জ করে পড়ে গেছে আপলোড হয়েছে কারেক্ট করে ও ঠিক আছে দুইটা করে দিতে হবে ঠিক আছে বস ঠিক করেছি ওটা
filing the affidavit of service. I am for the respondent, Lordship. In this matter, there was a land in the name of my predecessor, my father. Now, all of a sudden, I noticed that the record has been changed to some other strangers, and I make an RTA application asking the BLRO, how have you changed this? And in reply, at page 59, your Lordships will see that the BLRO has replied that the Khotian creation source cannot be traced. And according to his records, there is nothing to justify that change in the recording. In terms of the information received at page 60, I make a representation. In this representation, the Lordships will find at page 61, I specifically referred to one government order. At page 61, your Lordships will find as per government order being such and such issued by the government of West Bengal, LR department, if block and land reforms officer receive any complaint that someone got his name recorded in the record of right by furnishing fake or forged deed, upon receipt of such information, the block land reforms officer shall refer the matter to the registration authority, and on confirmation received from the authority, he will make an inquiry and register case. I have annexed the government order. It's at page 63. Your lordships will see it's refers that if in case of there is nothing on record, the matter shall be referred to investigation, and in under no circumstances, and the last paragraph, the second last paragraph, under no circumstances the affected party shall be advised to file appeal under section 54 that would greatly aggravate the suffering of the actual riot. Now, in terms of that representation, now the BLRO passes an order which will start from page 64. What he does, he starts a case under section 50. He does not undertake any inquiry proceeding. In this case, he specifically refers that I have produced my chain deeds in the first page of the order sheet. And if your lordships kindly takes up page 65, he even records in the second paragraph from the top, as per the inquiry report of the revenue inspector, the petitioner possesses the subject land. I am in possession. And then at the bottom of the same page, your lordships will find he records in the meantime, he records the deeds and etc. He records a finding in light of the above stated observations. It appears that the petitioner failed to establish chain of transfer. He becomes a civil court and adjudicates my title. Now I challenge this order directly before the tribunal.
Not maintainable.
Not maintainable. I have
held that.
Tribunal has held that despite I have me producing a judgment of the Honorable High Court which says that it has to the tribunal has to make an inquiry and endeavor to understand whether it will cause any undue hardship or not.
No, this is a question of hardship. You have to prefer an appeal. Here an appeal is maintained.
I understand that, but in view of the government order which says it will cause hardship, the tribunal proceeds on the fact that it will
government order is on a separate footing. This is on a separate footing. You are asking for actually two reliefs. One is your name has been, somebody else's name has been recorded. So that has to be corrected.
That has to be
Section
corrected.
50 was rightly initiated. No difficulty in that. An order has been passed.
Government order says even that. It takes care of even that. If your lordship sees the government order, may I place it once?
Yes, that no case under section, he will not be forced to.
No, the paragraph before that. BLRO shall also cancel the mutual proceedings initiated on the basis of the forged fake document.
No, that is on a different footing. We are telling you. The BLRO, as per this government order, the BLRO, if there is an attempt, there is an allegation that there is a forged deed. You have not alleged any fake or forged deed. You have said that we don't know why this name was changed.
BLRO himself is saying there is no deed present.
There is no deed is completely different from fake or forged deed. If there is a fake or forged deed allegation specifically, then BLRO will refer it to the registration authority. And if that it is held in the affirmative, then he will cancel. So that is a different process altogether. But now your remedy is rightly as BLRO initiated this proceeding under section 50. And
in my case, the BLRO says that the Khotian creation source cannot be traced.
If
there
it
is
cannot
no
be
record.
traced, then there is first of all you have not alleged that there was any fake or forged deed. You have said I don't know the source.
Based on the information that I have received.
Yes, there is no allegation by you that there is any fake or forged deed. So this government order does not come into play. And even the BLRO says that he does not have the records. If he had the records and there was a deed, then the question of sending that for ascertainment before the registration authority.
There are two parts. In the BLRO's order, he also decides my title, that he has not been able to establish the...
That you have challenged already before that you should challenge before the DLRO. That is what we are saying. There are two components to your allegation. One is this government order. We are of the view that this government order is not applicable here because there is no allegation of fake or forged document. You cannot just say that might have been fake or forged. You have not alleged fake or forged.
That I have not.
Nor is there any record, any deed. If there was a deed, you found that you could have alleged, definitely. Here is no deed. So this is a situation typically for your name to be corrected. That proceeding was rightly initiated. You say held wrongly. That has to be challenged before the DLRO. You will not interfere. We will grant you leave. That leave has been given probably.
That leave has been given, but the statutory period of time has expired by now.
So we'll put in something in our order so that you get the advantage of section 14. We'll do that. The present petitioner approached the BL and LRO with the grievance that although the subject property was all along recorded in the name of the petitioner, comma,
The petitioner's predecessor.
the petitioner's predecessor in interest, comma, the same was subsequently recorded in the name of a stranger all on a sudden. Full seeking to know the premise of such alteration, comma, an application was filed under the Right to Information Act, upon which it was disclosed that the records of the case are not traceable. Full next para. The petitioner thereafter made a representation before the concerned BL and LRO referring to a government order bearing number 213-1 capital S stroke 10 stroke 2020 dated January 17, 2020, whereby the Principal Secretary and Land Reforms Commissioner, Land and Land Reforms and Refugee Relief and Rehabilitation Department, State of West Bengal, had put in circulation that there are reports of attempts to get names recorded in the records of rights by furnishing fake or forged deeds, and those allegations should be taken seriously. The said government order subject is geo capital, further mentioned that immediately on receipt of such information, comma, through written complaints or otherwise, comma, BL and LRO shall refer the matter to the registration authority concerned. Once confirmation is received from the registration authority that the deed is fake or forged, comma, penal action shall be initiated against the wrongdoer by lodging FIR with the local police station. So next para, the government order further mentioned that the BL and LRO, comma, in such case, comma, shall also cancel the mutation proceedings initiated on the basis of the forged stroke fake document. If mutation is already done, comma, the same shall be treated as void ab initio, and the BLLRO shall, comma, on application or on his own motion, comma, promptly restore the record to its original position under section 50 within bracket 1 within bracket small f of the West Bengal Land Reforms Act. Next para, a further caveat was put into the said government order to the effect that under no circumstances, comma, the affected person shall be advised to file appeal under section 54 of the West Bengal Land Reforms Act, as that would only aggravate the suffering of the actual Rayat who has already been victimized by the misdeeds of someone else. Moreover, comma, it was mentioned in the government order, comma, such rectification of record does not necessitate invocation of section 54 of the WBLR Act. Next para. Thereafter, comma, the BLLRO took up the matter under section 50 within bracket 1 within bracket small f of the West Bengal Land Reforms Act 1955 and proceeded to hold that since the petitioner has failed to establish the chain of transfer from the recorded Rayat, comma, the petitioner's claim was turned down. Next para. The petitioner, comma, however, comma, instead of preferring an appeal under section 54 of the 1955 Act against such order of the BL and LRO, comma, directly approached the tribunal on the grievance, primarily on the grievance that the reference to the government order regarding fake and forged documents was totally ignored by the BL and LRO, and the BL and LRO, comma, dehorsed the representation and the law, comma, took up the matter under section 50 within bracket 1 within bracket small f, despite the bar in that regard in the government order dated January 17, 2020. The tribunal, comma, however, comma, was of the opinion that that an appeal was maintainable against the order of the BL and LRO and accordingly relegated the petitioner to such appeal. Next para, being thus aggrieved by the order of the tribunal dated August 21, 2025, comma, the present writ petition has been preferred. Next para, heard learned counsel for both sides. Next para, it transpires that there are two components to the matter. First, comma, the petitioner alleges that despite the petitioner's name, petitioner's predecessor in interest's name having featured in the records of rights, comma, a complete stranger apostrophe s name has been incorporated, comma, in which regard the petitioner seeks relief by entry of the petitioner's name in the records of rights. Full stop. Next para, the second component is whether the government order is applicable and comma, if so, comma, whether even without a reference under section 50 within bracket 1 within bracket small f, comma, the records of right ought to have been automatically corrected. For the next para, however, comma, insofar as the second component of the petitioner's grievance is concerned, comma, we are unable to agree with the petitioner. Full stop. First, comma, the petitioner never made any complaint or allegation as to any forged or fake document being the basis of the entry in the current entry in the records of rights. Full stop. Next para, secondly, comma, the BL and LRO was himself of the opinion that the records were not available, comma, thus obviating the scope of any specific allegation that the recording was done on the basis of a forged or fake document. Full stop. Next para, in the absence of any document, any foundational document to support the recording, comma, there could not be any allegation of forgery or the document having been fake. Full stop. Hence, comma, the government order dated January 17, 2020 is not applicable in the facts of the present case, and as such, comma, the bar of not taking up the matter under section 50 within bracket 1 within bracket small f of the 1955 Act is not applicable at all. Full stop. Next para, thus, comma, the BL and LRO rightly took up the matter for consideration under section 50 within bracket 1 within bracket small f of the 1955 Act in view of the prayer of the petitioner, request of the petitioner regarding non-recording of the petitioner's name and the recording of a stranger's name in the records of rights. Full stop. Next para. However, comma, what the BL and LRO did thereafter was to decide the said proceeding against the petitioner and refusing to correct the records of right in the name of the petitioner. Full stop. The petitioner alleges that the BLRO arrogated itself to the status of a civil court by deciding the title of the parties. Full stop. Next para. However, comma, in view of an equally efficacious remedy by way of an appeal under section 54 of the 1955 Act against the said order of the BL and LRO, comma, we desist from making any premature comment at this stage on such challenge. Full stop. The remedy of the petitioner was not before the tribunal as correctly laid down by the tribunal in the impugned order, but by way of an appeal before the concerned DL and LRO, that is the appellate authority. Full stop. Next para. We fully appreciate the agony of the petitioner who is running from pillar to post, and taking into consideration that the petitioner may not be well conversant with the nuances of law, comma, we take into account the pendency of the challenge before the tribunal and before this court, comma, which according to us is a bona fide delay coming within the contemplation of section 14 of the Limitation Act. Full stop. Next para. As such, comma, if an appeal is preferred against the order of the BLRO, comma, such facet shall be taken into consideration by the appellate authority while deciding the appeal. Full stop. Next para. In view of the above, comma, we do not find any illegality in the impugned order. Hence, WPLRT, what is this, 188 of 2025 is disposed of without interfering the impugned order dated August 21, 2025, passed by the first bench, West Bengal Land Reforms and Tenancy Tribunal, and granting liberty to the petitioner to challenge the order of the concerned BL and LRO, which is that page number?
63.
63.
It starts from 64.
Dated May 22, 2025, passed in Bakura, passed in miscase number 65 of 2025, comma, which was impugned before the tribunal, comma, before by way of a properly constituted appeal before the appropriate appellate authority. Full stop. If such challenge is made within a reasonable period, comma, preferably within uh, 3 weeks from date, comma, the concerned appellate authority shall take into consideration the pendency of the present writ petition and the application before the tribunal as bona fide on the part of the petitioner. Full stop. We further make it clear that we have not gone into the merits of the contentions of either of the parties, and it will be open to the appellate authority, comma, if an appeal is preferred, comma, to come to its own conclusions and decide the matter as expeditiously as possible. No less. Thank you. Yes, what is the matter?
My application.
Yes. What is the matter?
Well, it is the inaction on part of the concerned VLR for correction record of rights. Well, it is my lord, I made representation that in terms of the order passed by the civil court and my lord, the mutation case which was mutated in favor of the my lord vendor. So in terms of that order, the direction I seek for direction.
Tribunal has given that direction.
No, well, it is my main things. Well, they filed my status report. The state department. He said that it post vesting purchaser. So in terms of the status report, the order was passed that in terms of the status report, the representation to be disposed of. I am objecting that the status report, it is said that it is vesting post vesting purchaser.
We'll do this subject to hearing, Mr. Gali.
My lord.
Status report has to be considered because they will place that before the BLLRO. But we'll give you liberty to controvert that and produce your own documents also, and BLLRO will give a.
It is not mentioned here in terms of the.
No, we will modify the order to that. We'll do that, Mr. Kali. Status report definitely you are entitled to present.
But in terms of the order, civil court's order, the civil court's
so
order.
We'll give you liberty to. We will say that you will also be entitled not only to controvert the status report, but to produce your own documents and to have a hearing.
And Lordship may take note of Lordship the entire genesis is milled on the basis of the decree passed in a suit where vesting was under challenge. Like 57B2 also is to take care of. Lordship has his Lordship's judgment is there, Lordship. This aspect milled also milled the entire.
No, it will not prejudice the merit of the case. Every aspect will be open to both sides. The thought grievance of the petitioner is that when the petitioner, challenging the inaction of the BL and LRO in non-consideration of the representation of the petitioner regarding correction of the records of rights, approached the concerned tribunal, the tribunal, while directing the BL and LRO to dispose of the representation of the petitioner within a period of 3 months from the date of communication of its order, included a rider that such disposal shall be in terms of the status report dated May 19, 2025, passed by the BL and LRO, authored by the BL and LRO himself. For some next para, upon hearing learned counsel for the parties, we find that the said observation, without any further clarification, would tantamount to prejudging the disposal by the BLRO, since the status report was furnished by the BLNLRO himself, who would be the adjudicating authority in terms of the direction of the tribunal. Next para. Accordingly, WPLRT 189 of 2025 is disposed of by modifying the impugned order dated May 20, 2025, passed by the 4th bench, West Bengal Land Reforms and Tenancy Tribunal in OA 1120 of 2020, bracket LRTT, bracket closed, to the extent that the BLNLRO, while disposing of the matter in terms of the direction of the tribunal, shall not only consider the status report furnished by the said BLNLRO, but also grant adequate opportunity to the petitioner to controvert the contents of the said status reports, as well as to produce documentary or other evidence in support of the petitioner's case before the BL and LRO. Next para, it is further made clear that the BLNLRO shall give adequate opportunity of hearing and production of document to all concerned parties before coming to a conclusion in terms of the direction of the tribunal. Full stop. Next para. However, comma, since the time limit of 3 months as stipulated by the tribunal has already elapsed, comma, partially due to the pendency of the present challenge, comma, we extend the time for disposal of the matter by the BLNLRO in terms of our above observations till January 31, 2025. Full stop. The BLLRO, comma, while so disposing, comma, shall not be influenced on merits of the matter either by the observations made by this court or the tribunal in any manner whatsoever. No address to question. Thank you. Next.
মানে affidavit of service book.
আগেরটা affidavit of service.
For 15 minutes.
Yes.
Well, sir, only 2 points involved in this matter. Well, I post-vesting purchaser. Well, I file an application to consider our application as per 40 new of the Land Reforms Act. Well, is a that application, well, in action against the inaction, I filed a original application with the tribunal. Well,
post-vesting purchaser, do you have a right?
40 new, well, right, not yet taken possession. Malad, this tribunal says that land was vested in a state acquisition act. Malad, kindly see the contention is the state acquisition, though the proceeding was initiated state acquisition act, Malad disposed in 1985, then Malad then clubbed together the 7AA and Malad 7A and Malad 14T. Malad, kindly see the notice, Malad, the
State
order,
Acquisition Act.
Malad, page 27.
This 27th of August order?
No, page 27, Malad.
Page
Subject
27.
case, Malad. 52 9K under section 14T 61 and 5A. Kindly see, this is a 14T 61 and 5A. Malad, that Big Riot case, State Acquisition Act proceeding as well as Malad Land Reforms Act proceeding is a club, it is a joint proceeding. Malad, then Malad, page 28, Malad, the land schedule rule which was taken for the proceeding. Malad, kindly see that the pond, Pukur, Park, Pukur, all these.
Mr. Mukherjee will come back in 5 minutes and Mr. Dev will just come back. Yes, Mr. Mukherjee.
Malad, as per Malad, the notice says that the proceeding Malad, the State Acquisition Act as well as Land Reforms Act. And also Malad, the land schedule which was taken in the said proceeding, page 28, Malad, most of the Malad, the pond was taken in the consideration of that proceeding. Malad, the State Acquisition Act, if any proceeding is initiated against on the basis of a State Acquisition Act, Malad, the ponds cannot be taken because Malad, State Acquisition Act, Rayat is entitled 25 acres agricultural land, 15 non-agri, 5 homestead. In a Land Reforms Act, Malad, all this land can be taken by the block land and land reforms.
Under the State Acquisition Act, there is a bar.
There is a bar.
There is no any provision, my lord.
No, yes, but as per as
What?
1990, my lord, I rely a judgment in the Supreme Court says that the ponds is excluded.
Yes, my lord, all the ponds excluded. But this is not the pond. This land is not the pond.
No, this is not
subject land.
No, this is
subject land is not the pond. my lord.
this is not my argument. My argument says
his argument is that
my application was
by slipping.
No, my application was rejected on the ground that the land was vested in a State Acquisition Act.
And there is no any provision.
my contention is this is not only State Acquisition
So
Act.
it was a composite.
Composite proceeding. If the land is vested under the Land Reforms Act, then 14 use provision is my application be considered under as per provision of section 40 new. That is my contention. Only the tribunal rejected my application on the ground that the land vested in the State Acquisition Act. As such, your application cannot be considered.
And for that, you to say it's a joint, you rely on joint proceeding. You rely on which page?
Page Malad, kindly see Malad, page 27. 27 Malad, kindly see under section 14T, 6.1 and 5A. But then Malad, the land schedule, all these Malad, the ponds is taken in the consideration. As such, but this proceeding
if it's a composite one, then if Land Reforms Act is there, then post vesting is immaterial.
Immaterial.
Let us hear Mr. De. Yes, Mr. De, what do you say?
My lord, as because my lord, in the year that is 1967, my lord, that proceeding was completed, my lord, in 1967.
No.
That proceeding was completed.
This is 85 probably.
85. Kindly see.
After that, my lord, that is the started proceeding.
Proceeding started 69.
And my lord, 69, that land was vested to the state, my lord, according to our my lord.
So what about this notice 28th of August?
That is after that, my lord. I am coming with all the requirement, my lord, if your lordship will see.
But that proceeding stayed in terms of the High Court's 1970.
So what do you mean, Mr. De, that this proceeding was
my lord, that is a
vested under
that is vested in the year 1969. After that, my lord, that proceeding has stayed, my lord, that reopened to the. But according to us,
but tribunal does not consider these also. If tribunal had to go by this notice only, then you have to remand it to the tribunal for and not only that, Mr. De, one other aspect also is disturbing us because they approach the tribunal only for inaction. Tribunal pre-decided in a sentence that post vesting, therefore you are not. We'll relegate it to the BLNL.
Yes, my lord.
So all the papers you can produce there, we won't prejudge the issue.
Yes, my lord.
Because both of you will be losing a forum, state as well as Mr. Mukherjee, we are relegating to the BLNL. The limited grievance of the petitioner is that the petitioner challenged the inaction of the BL and LRO in disposal of a representation, in sitting over the disposal of a representation by the petitioner seeking benefit.
My lord, may I be permitted to take leave, my lord?
Oh, absolutely, yes.
My learned friend will.
Sufficient. Benefit under section 14U3, U within bracket 3 of the West Bengal Land Reforms Act 1955. Full stop, next para. It is learned counsel for the petitioner contends that the notice issued previously was a composite notice both under provisions of the 1955 Act and the West Bengal State Acquisition Act 1953. Full stop, next para. However, in such original application seeking expeditious disposal of the proceeding before the BL and LRO, the learned tribunal decided the issue by observing that since the petitioner was a post-vesting transferee, comma, the application of the petitioner was not maintainable. Full stop. Next para, it is argued by the petitioner that in view of the notice being composite, comma, both under the 1955 and the 1953 Act, comma, it could not be said that a post-vesting transferee is altogether barred from taking out such an application. Full stop. It is submitted that although the 1953 Act might contain such bar, comma, the 1955 Act does not contemplate any such absolute bar. So next para, learned additional government pleader seeks to rely upon certain documents to argue that the vesting took place in the 1960s. Full stop. Next para, such contention is controverted by learned counsel for the petitioner. Full stop. Next para, be that as it may, comma, we find that the limited grievance of the petitioner before the tribunal was the inaction on the part of the BL and LRO, comma, which was the appropriate authority to take up the issue, comma, in disposing of the representation of the petitioner. Full stop. While deciding such an original application, comma, the learned tribunal traversed beyond its jurisdiction in deciding the issue itself on merits, comma, thereby usurping the authority of the designated forum under the statute, that is the concerned BL and LRO. Full stop. Accordingly, WPLRT 190 of 2025 is partially allowed on contest, comma, thereby setting aside the impugned order dated August 27, 2025, passed by the second bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 2757 of 2016, bracketed LRTT, and remanding the remanding the matter to the BL and LRO Khorgram, comma, Murshidabad, to decide the representation of the petitioner upon giving adequate opportunity to all concerned, comma, including the petitioner and the respondent authorities, comma, both as regards hearing and opportunity to furnish documentary or other evidence in support of their respective cases. Full stop. Next para, the BL and LRO shall complete the entire exercise of such disposal without being influenced in any manner by any of the observations made on merit in the impugned order or in this court, as expeditiously as possible, comma, preferably within 3 months from the date of communication of this order to the concerned BL and LRO. No rest.
Item number 16, my lord, I am for the petitioner.
Yes.
Sir, beg to upon the state.
Pardon? Yes.
Yes. This is a proceedings under 14T3, my lord, read with 14N and O. I should not say read with 14N and O, because the authority, revenue authority, has not done that determination under section 14N, which is a prior prerequisite going before 14T3. Which one is irrigated, which one is non-irrigated. That determination has to take place by the revenue authority. Here, in our case, the revenue authority has not taken that step. When challenging the revenue authority's order, we preferred an appeal. Then appeal was disposed of, affirming the order of the revenue authority. Then challenging the appellate authority's order, I went before the LRTT. LRTT has admitted the petition, but and also condoned the delay, but not granted any injunction or stay upon the revenue authority not to create any interest in respect of that land. Challenging that, my lord, I have come before my lords. Now, my lord, this is the overall view. Now, my lord, kindly.
Does the tribunal has that power?
Yes.
Otherwise, as a tribunal, it has the power to grant an injunction.
Yes, yes. Only not to settle this in favor of
third party.
Third party. Otherwise, multiplicity of proceedings, everything will take place.
That is a limited challenge.
Yes.
Mr. Gali, what do you say to this?
My lord,
before hearing Mr. Dharan at length, I mean, preliminary.
My lord,
why shouldn't it be granted?
May I respectfully, my lord, invite your lordship to the order and
let him complete. Yes.
No.
Yes.
Now, my lord, the petitioner owns 14.22 acres of land. And on the date of vesting, that is Chapter 2B under West Bengal Land Reforms Act, cut-off date is 15th February 1971. So the family, the constitution of the family would be taken into consideration. That is the cut-off date, that is 15th February 1971. As also, if the land is irrigated or non-irrigated, that also be taken into consideration as of the date of vesting, that is 15th February 1971. Now, my lord, kindly come to section 14KC. My lord, kindly come to 14KD. Sorry.
It is ways pending, my lord. It is only against.
Prima facie, my lord, I would like to show the provision. I'm not inviting my lord to decide it on merit. Now, my lord, kindly come to chapter 2B. That is, my lord, section 14K, my lord has got it. Yes. Now, my lord, kindly straight away come to the D. Irrigated area means an area specified as such by the state government by notification in the official gazette, being an area which is or is in the opinion of the state government capable of being irrigated at any time during the agricultural year commencing on first day of Boishak 1377 BSS or thereafter from any state canal irrigation project or state power driven deep tube well or shallow tube well or any other state irrigation project or state river lift irrigation project. Now, not kindly come why it is necessary. Now, not kindly come to 14 KD, then F. Standard hectare means after D. Well, standard hectare means in relation to an agricultural land, an extent of land equivalent to 1 hectare in an irrigated
It's obvious it will make a difference in the ceiling.
Yes. 1.40 in respect of non-irrigated and for this 1. Now, let kindly come to section 14M, ceiling area.
Yes.
This would be at the on the date of cut-off date of vesting. What would be the family constituents holding that? How many members are there in the family? The ceiling would be determined. Now, my lord, kindly come to 14N, determination of irrigated area. If any question arises as to whether any land is or is not within an irrigated area, such question shall be determined by the prescribed authority in such manner as may be prescribed. And 2, the state government shall prescribe such authority as it may think fit for the determination of the question referred to in subsection 1. Against this decision, my lord, I have a forum of appellate authority that is under section 14O. Appeal is also there. And rules has been also there to deal with this 14N, how 14N would be dealt with. That is 14B of the West Bengal Land Reforms Rules 1965. Well, I'm not placing that at this moment. The authority, the present petitioner had a family on the date of vesting of the family members were 2 daughters and wife and him. So altogether 1, 2, 3, 4, including him, 4 family members on the date of vesting. And my lord, since the revenue authority has not done this exercise under section 14N, my lord, I was deprived of the statute. Now, my lord, kindly come to the ordering portion of the tribunal, which is the order impugned. Tribunal only has held that only mere apprehension will not do. Order. Kindly come to the impugned order. That is on passed on 11th September 2025. Manoj has got it.
Yes.
এটাতে বলেছিল তো এফিডেভিট দিতে বলেছিল এফিডেভিট
The learned advocate for the applicant submits that there is an urgency issuance of interim order of staying the order dated 30th November 2022 passed by the appellate authority and DLLR Paschim Midnapur, LRA such and such. For the applicant expressed his apprehension that if the order under challenge is not stayed, there is a chance of settlement of the vested land by way of patta. Then learned GR has submission of learned GR has been noted. Then, my lord, the next paragraph, peruse the order under challenge. Learned advocate for the applicant has failed to produce a single scrap of paper which goes to indicate that there is overt act on the part of the statutory authority for the purpose of settlement of vested land by granting pattas. Whereas
Affidavits were not exchanged.
my lord, there was a direction on the previous occasions. My lord, kindly come to page.
They have not filed affidavit.
They have not filed.
Please show us your way.
My lord.
Starts from.
No, it starts from.
Have you ever anywhere that they're
60. Yes, 61. My lord, kindly come
that
to the,
they may transfer or something like
my
that?
lord, prayer portion. My lord, it's in the record of rights. It's written court cases, even in the record of rights. My lord, I have given those.
No, so what? I mean, no, that they're trying to give a patta and all. Have you stated anywhere?
In the OA.
In the way, because you have to make out a prima facie case also for grant of injunction. The tribunal proceeded on the basis there is no urgency, no overt act on their part to grant a
In
part.
writ petition, yes. Para
No, writ
30,
petition won't
31,
do,
32.
because we have to see whatever was before the time. Let us see.
This I could not find out.
And
I've gone through the entire.
And throughout the appeal proceedings, there was a stay. Throughout the appellate, before the appellate authority, stay was granted.
Page 36. Page 36.
Doesn't appear to be.
No, not at least not in the way, my lord. In the, my lord, kindly come to page 36 once. Extension ta kotha.
45.
My lord, kindly come to page 36.
Yes.
On page 36, the appellate authority, their lordships were further pleased to direct the petitioner to file an application for interim relief before the appellate authority, and the appellate authority was directed to dispose of the application for interim relief, but the order passed by the honorable.
Here you had specifically filed an application for interim relief. That is difficult. Because express sheet cannot be faulted. The order saying that they did not plead even. Document you could not produce, you can understand you might not have produced. How could you get a document of document produced? In the allegation should have been there. The rudiment, the foundation of the allegation should be there. Have you even prayed for the interim order of injunction?
Yes. Interim order there is. Number one prayer is injunction.
Yes, it is there.
But I must be candid, my lord, pleading is not there, but prayer is there. And throughout the appeal proceedings, there is a stay.
Yes, Mr. Gali, what do you say?
My lord, may I respectfully invite your lordship, my lord, first the my lord, relevant provision of my lord of the 1997 Tribunal Act regarding grant of injunction or interim order. Kindly, my lord, have a look.
You don't have it. Tribunal Act আছে দেখুন তো।
It is a part of LR Act.
LR Act এ থাকা উচিত। Yes, you're right.
Lordship may kindly go at
We
the
have,
back,
we have.
towards the back, my lord.
Yes, which section?
May I, my lord, respectfully invite you, Lordship, my lord, section 10, my lord, subsection 7.
Yes.
My lord, notwithstanding anything containing any other provision of this act or any other law for the timing in force, no interim order, whether by way of injunction or stay, or in any other matter, shall be made on or in any proceeding relating to an application made under subsection 1, unless copies of such application and all documents in support of the plea for such interim order are duly furnished 7 days in advance to each of the parties. An opportunity of being heard is given, provided the tribunal may pass an interim order as an exceptional measure, if it is satisfied for reasons to be recorded in writing that it is necessary so to do for preventing a loss. So, my lord, my learned senior friend has referred to the original application at page 62. My lord, my learned senior friend has also referred to the prayer clause, that is, my lord, at page 78 of the writ petition, where a simple interim order has been prayed for without any supporting plea. So, my lord, the golden, my lord, trinity of, my lord, for granting injunction, this prima facie, balance, and central, could not be satisfied. Secondly, my lord, my learned senior friend has preferred an appeal, certainly from the 14th proceeding. My lord, kindly may I respectfully show your lordship that the memo at page 107. If your lordship, my lord, kindly have a look at the, my lord, the memorandum of appeal, my lord, kindly sees the ground. I have gone through, my lord, very meticulously. Throughout this memo of appeal, Lord will not find the grounds which, my lord, my learned senior friend has alleged, my lord, in this particular petition before lordship while challenging, my lord, the order of rejection by the learned tribunal. What is that? 14N, 14O, 14P. Neither in 54 appeal nor in the original application before the learned tribunal. But for the first time, I find, my lord, in ground 1, 2, and 3 before your lordships. 14N, 14O, 14P. My third respectful submission, my lord. So, my lord, he could not satisfy the, my lord, golden, my lord, trinity with regard to, my lord, grant of injunction. Secondly, 14NOP plea for the first time taken before your lordship, neither in OA nor in the 54 memo of appeal, nor even before the vesting proceeding, before the prescribed authority, the revenue officer proceeding also. Order sheets are there before lordship in this particular. My lord, thirdly, my lord, this so, my lord, since this, my lord, is devoid of any, my lord, merit, lordship may kindly consider this.
If we come to the first ground of the memo
and 14N, my lord, my
ground of the memo, Mr.
lordship,
Gali,
lordship,
we come to page 112. We don't know whether there are two page numbers. 112 and 49, both page numbers are appearing.
No, 112, my lord, let us consider.
112. See the first ground, not taken in a very happy manner. For that, the BLLR erred in law in determining all the lands as irrigated lands, and as such, the whole determination is void as per records. So they touched irrigable lands. This adjudication on that. But you are right, specifically not taken that this was not decided.
Because, my lord, for the reason subject to your lordship's correction, if your lordship may kindly, my lord, respectfully, my lord, have a look, my lord, in the language of 14N, it says, if any question arises. So, my lord, question should have had been raised before the revenue authority when the 14T3 proceeding was on. That was in the year 2007. Yes, government should not go by the notification that these areas, these districts are irrigated. So we should know that is not sacrosanct. I fully appreciate. But if your lordship goes through the entire vesting proceeding, the order certified copies, my lord, are annexed.
Ground 1 covers broadly 14.
Lordship, but prima facie, my lord, here, my lord, we are on, my lord, the golden, my lord, trinity. Prima facie.
It's your favorite phrase.
Then my lord.
There's a golden trinity of usage of the word by you. Thrice you have used, so.
So, my lord, these three, my lord, ingredients, my lord. My lord, 2007 was a vesting order.
But
That will appear from.
they enjoyed a stay order throughout the interim order throughout the
I can't say it is on record.
appeal.
I can't say, I can't stand on that.
Tomorrow, if you grant a patta, do whatever, dispose of the property, settle in somebody's favor, who will prevent? I mean,
No, that I
isn't
can't,
it
my lord.
implicit in this because they have lost in both the forums. Now there is nothing to prevent you from doing that.
No, I leave to your lordship, my lord. These are my humble submissions, my lord.
No, those are
My lord,
justified submissions.
2007 was the vesting order completed. And this appeal was disposed in the year, I believe, in my lord 2022. And my lord 2025 comes, my lord, this order for prayer for injunction or stay, my lord, whatever. So, lordship, I leave to your lordship, my lord.
Grant. The present challenge has been preferred against an order passed by the West Bengal Land Reforms and Tenancy Tribunal, to the extent that by the said impugned order, no injunction stroke stay order protecting the interest of the petitioner by restraining the respondent authorities from settling or granting patta or transferring the subject property in respect of third parties has been granted. For the next parallel, senior counsel appearing for the petitioner submits that throughout the pendency of the appeal from which the tribunal application arises, there was a subsisting order of stay. For the next para, the matter arises from an order passed under section 14 capital T of the West Bengal Land Reforms Act 1955, determining the ceiling area. It is submitted by learned senior counsel that the provision of section 14 within 14 capital N of the 1955 Act was given a go-by by the respondent authorities, inasmuch as there was no determination as to what part of the subject acquired property, vested property, was irrigable land. For next para, it is contended that such a prior adjudication is mandatory before determining the ceiling area, particularly in view of the aggrieved party having a right of appeal under section 14 capital O of the said act against an adjudication made under section 14 capital 9. Thus, without giving a go-by to such provisions, the determination has been made. However, both the revenue officer as well as the appellate authority have confirmed the findings against the petitioner, prompting the challenge before the tribunal. Next para, learned senior counsel takes the court through the relief sought in the original application before the tribunal by way of interim injunction, as well as the order passed by the appellate authority in that regard. Next para, the learned senior government advocate appearing for the state controverts the submissions of the petitioner and submits that nowhere in the grounds taken in the appeal preferred before the appellate authority was the present argument of the petitioner taken. Next para, learned senior government advocate seeks to take the court through the appeal filed before the appellate authority in support of such contention. Next para, secondly, it is argued that under section 10 within bracket 7 of the West Bengal Land Reforms and Tenancy Tribunal Act, 1997, no interim order shall be made in any proceeding unless copies of the application and all documents in support of the plea for such interim order are duly furnished 7 days in advance to each of the parties against whom such application is made or is proposed to be made. Moreover, an opportunity of being heard is to be given to each of the parties against whom such application is made. Next para, in the present case, it is submitted that there is absolutely no averment in support of the prayer for injunction in the original application filed before the tribunal, and as such, the learned tribunal was justified in not granting any ad interim protection to the petitioner. Next para, upon hearing learned counsel for the parties, it is evident, and we find from the proviso to section 10 within bracket 7 within bracket small b of the 1997 Act that the tribunal may pass an interim order as an exceptional measure if it is satisfied for reasons to be recorded in writing that it is necessary so to do for preventing any loss being immediately caused to the applicant. Full stop. Next para. Thus, comma, the bar under subsection 7 of section 10 to grant of interim order under the parameters stipulated therein is not absolute, and discretion is vested with the tribunal to ascertain whether under exceptional conditions, comma, an interim order is to be granted. Full stop. Next para. Although the learned senior government advocate is justified in arguing that in clear terms, comma, no averment has been made that the property is being attempted to be transferred, comma, we find it equally justified that an order ought to have been granted, comma, since throughout the pendency of the appeal, comma, against the order of which order passed in which the tribunal application has been preferred, comma, there was an interim protection granted to the petitioner. Full stop. Next para. In view of such interim order having always been enjoyed throughout the pendency of the appeal by the petitioner, comma, by default, comma, there ought to have been similar protection granted by the tribunal in order to prevent the tribunal application from being rendered infructuous. Full stop. Next para. By virtue of the interim order, interim prayer being sought in the original application itself, comma, it is implicit that the conditions for such grant of interim order were pleaded, comma, if not expressly, comma, in an implied manner. Full stop. Next para. As regards the argument of the state that the specific ground under section 14 specific ground regarding section 14 capital N having not been complied with being not taken before the tribunal, comma, we find from the very first ground in the memorandum of appeal that, comma, although not very happily couched, comma, the said ground broadly covers such objection. Full stop. The said ground mentions that the BL and LRO erred in law in determining all the lands as irrigated lands, and as such the whole determination is void ab initio, because as per record of rights all the lands of the petitioner are not irrigated lands, and as such the petitioner is entitled to retain more lands as prescribed under the 1955 Act. Full stop. Next para. If read as a whole in proper context, comma, the said ground would be sufficient to provide the foundational basis of an argument being made on the ground of non-compliance of section 14 capital N prior to determination under section 14T of the 1955 Act. Full stop. Even otherwise, comma, the grounds of an appeal before the appellate authority under the 1955 Act, as mentioned in the memorandum of appeal, are not set in stone and can very well be deviated from at the time of arguments. Full stop. The question which is to be ascertained by the appellate authority is whether ample grounds have been made out by the challenger against the order passed by the revenue officer, and not whether such grounds have been specifically pleaded in the appeal. Full stop. In fact, comma, such pleading is not mandatory in law at all. Full stop. Next para. In any event, comma, since the foundational basis of such pleading is there in the appeal, comma, we find such argument of the state to be unacceptable. Full stop. Next para. Even otherwise, comma, the learned tribunal, comma, while passing the impugned order, comma, did not refuse ad interim injunction on the ground of non-compliance of clause small a within bracket of subsection 7 of section 10 of the 1997 Act, or clause small b within bracket thereof. Full stop. The premise of the impugned order was that the applicant had failed to produce a single scrap of paper which goes to indicate that there is an overt act on the part of the statutory authority for the purpose of settlement of vested land by granting pattas, and that it is too difficult to issue any order on the basis of mere apprehension or conjecture. Full stop. Next para. We find both grounds not tenable in the eye of law. Full stop. Insofar as the first ground is concerned, comma, it is not expected and might very well be that the petitioner is not equipped with any specific document indicating the intention of the state to transfer the property or settle the same by way of grant of pattas in favor of third parties. For such act is implicit from the circumstances of the case, comma, since both the authorities have turned down the plea of the petitioner and during pendency of the appeal, comma, an order had been granted by the appellate authority for protecting the petitioner from such transfer, which by necessary implication indicates that the appellate authority was satisfied as to the necessity of passing such order. Thus, comma, with the disposal of the appeal, comma, when the said protective order was taken away, comma, the tribunal proceeding being a continuation of the same, comma, there could not be any reason why a similar apprehension could be taken into consideration by the tribunal. Next para, insofar as the perception of the tribunal that an injunction order, comma, if passed, would be on the basis of mere apprehension or conjecture, comma, it is the very premise of a prayer for injunction that there is a reasonable apprehension on the part of the petitioner that the property in question may be transferred in favor of third parties. Full stop. In the event the act apprehended is done, comma, there would not be any reason or scope to grant any injunction any further. Full stop. Thus, comma, it is at the stage of reasonable apprehension when the injunction is to be granted and comma, which is always on the basis of some amount of apprehension, comma, if not baseless conjecture. Full stop. Thus, comma, we are of the opinion that, comma, particularly since an interim order was prevalent during the pendency of the appeal, comma, the learned tribunal ought to have granted an injunction as prayed for by the petitioner. Full stop. Next para. In such view of the matter, comma, WP LRT 191 of 2025 is allowed on contest, comma, thereby setting aside the impugned order dated September 11, 2025, passed by the 4th bench West Bengal Land Reforms and Tenancy Tribunal in OA 1170/2023 within bracket LRTT and restraining the respondents by an order of injunction from giving any effect to the orders impugned before the tribunal, comma, both of the appellate authority and the revenue officer, and further restraining the respondents and their men and agents from disturbing the peaceful possession of the petitioner in respect of the subject property and or creating any third party interest in respect of the subject property during pendency of the original application. Full stop. Next para. It is, comma, however, comma, made abundantly clear that this court has not entered into the merits of the respective contentions of the parties, and it will be open to the learned tribunal to decide the original application independently of the above observations and or the observations made in the impugned order on its own merits. No address to cost. Affidavit size filed today.
Any time period maybe?
You have gotten injunctions, so they will ask for a time.
Till disposal.
Yes. Yes.
My lord, this is also, my lord, the refusal to pass an ad interim order of order by the tribunal. Now, my lord, what happened, my lord? The lands, my lord, of the few petitioner, my lord, was permitted to be returned, my lord, under the Estate Acquisition Act. Now, my lord, since, my lord, again notices were issued, my lord, for fresh vesting proceedings. Now, my lord, we challenge this. We challenge that.
Under what? 14P?
Under, yes, under West Bengal Land Reforms Act. Yes. Yeah. Under now, my lord.
Hard Bazaar.
Hat Bajar, yes, yes.
Estate acquisition.
Estate acquisition act. Now, my lord, that issue is also pending before consideration before the my lord, bench of the Honorable Chief Justice. Now, my lord, what happened? We, my lord, challenged the notice. Now, my lord, during pendency, my lord, of the original application before the tribunal, the my lord, authorities, my lord, proceeded.
Challenge the notice before the tribunal.
Now, my lord, during pendency of the that original application, the the authorities have proceeded with the miscellaneous case and had disposed of passed the final order. Now, challenge final order. We have filed a miscellaneous application for stay before the tribunal, praying for stay of that final order.
Final order is appealable otherwise.
Appealable.
For an appeal and pray for your.
No, we have challenged the notice itself. We say the notice itself could not have been disposed, issued.
But that has merged in the order now.
That is there.
Pray for a challenge, we will give you liberty to pray for stay there.
The problem.
This has been rendered infructuous.
Milord, whether that can be done, Milord, the issue is still pending. Milord, if it is.
Mr. Bhattacharya, what we can do is, because an order has been passed, final order has been passed
on 9th February 2020.
On the basis of the notice. So what we can do is we can say that this, in view of the notice having culminated in an order, this way has become infructuous, but we'll keep it open for you to take the points taken in the way, also challenging the notice, which was the genesis of that, in the appeal. We can keep that open and give you liberty to pray for stay there. Mr. Galavi.
Only Lordship will take care of the limitation part also.
Problem
is 51A4 proceeding was completed 9th February 2020.
If your Lordship would wants two things,
take care of that, Lordship will take care of the limitation.
Every case we cannot take care.
No, Lordship.
For the petitioner.
No. Kindly comes to page 122.
Sufficient care of many petitioners.
Kindly comes to page 122. Because since my miscellaneous application was not heard, I came up before this Honorable Court. Kindly see, the
miscellaneous application under what?
For stay. Miscellaneous application, MA, for stay of the final order. Kindly see order number 3, para 3. Orders impugned in the present writ petition did not decide the right, title and interest of any of the parties before us. Finally, it appears that there is a miscellaneous application pending before the learned tribunal which requires consideration. The learned tribunal required such application to be listed on July 22, 2025. In the facts and circumstances of the present case, in our view, interest of justice would be served up by requesting the learned tribunal not to give unnecessary adjournment and to any of the parties, and endeavor to dispose of the miscellaneous application fixed on the July 22nd, 20, either on such date or within a period of a month thereafter. Now, Milord, kindly see the last page.
It has been decided now.
No, kindly see the last page of your Lordship's brief. Kindly see, it has been, MA has been fixed on 3rd of, Milord, page
3rd of March.
3rd March 2026, the order dated 22nd July 2025 by the tribunal.
No. That, yes, Mr. Gali will direct that MA, then we will not go into this. We will direct that MA
these exceptions and are exchanged in the MA or in the
MA.
Exceptions and this report.
Only report. And
these are exchanged in MA or in OA?
In MA.
Because
and in the original OA, no affidavit has been
extended. I failed to understand from the pleading, Miller. These
1 minute.
Exceptions, reports.
Please. Learned advocate for the exceptions supported by an... You filed an exception against a report.
So these are all in respect of MA or OA, Lordship. I don't.
Representatives liberty to file reply. Liberty is granted. That is immaterial. This is in respect of a report filed by you.
An exception also filed by
exception to the report, and you seek liberty to file affidavit in reply in respect of that exception.
Since Milord, MA is still pending, so whether these pleadings are in relation to OA or MA, it's not
whatever.
Clear.
We are not interested in that. MA had to be disposed of. No, is it your case that MA has been disposed of?
No, and it is not my case. Because only I find from the prayer
application, last line of that order. Milord, another thing, Milord, kindly comes to page 124. Milord, kindly see this, Milord, kindly see the name of the petitioner, Gopal Chandra Rana. He is, Milord, a Rayat of my contiguous land. Now, Milord, what happened, Milord, in his land, which is, Milord, 37, my is, Milord, 378, and his is 378 by 1020. Now, my lord, the state authorities, my lord, the Jela Parishad had started construction. My lord, he filed a writ petition. Kindly see, my lord, what is the specific stand, my lord, why I am entitled to an interim order. My lord, kindly see the specific stand of the state. Kindly see the petitioner content that they have purchased a portion of plot of 378 by 10 measuring
This is the adjacent plot.
Adjacent plot, Bata plot, adjacent plot, measuring about such and such in Mouja Protapdigi within the jurisdiction of the Shirampur Gram Panchayat. The petitioners have annexed the relevant sale deed in support of this claim. It is further alleged that the petitioners that the Potashpur 2 Panchayat Shomiti by a tender notice dated October 9, 2025 had invited tender for the construction of a market complex on the said plot. Said plot means 378 by 1020. Which they claim to own, along with several other adjoining plots. The learned advocate appearing on behalf of the state submits that the proposed market complex will be constructed on plot number 378, which is under challenge before the tribunal, which is a vested plot of land belonging to the state. The tender notice, however, explicitly includes reference to plot number 378 by 1020. In view of the foregoing circumstances, an order of injunction is issued restraining the respondents from undertaking any project work for a period of 3 months from the date following the tender notice dated October 9, 2020 in respect of the plot 378 by 1020 allegedly owned by the petitioner. It is clarified that the Panchayat shall, however, be at liberty to proceed with the project, excluding the portion of 378.
Where is the notice you are challenging?
Yes. Kindly comes to my lord, page 91 and 92. Kindly see at the bottom, dag number 378.
That was 380.
No, 378.
378.
And next, my lord, next page, 378 by 1017. And that is Rana's case is 378 by 1020. And it is the specific stand of the state that construction is going on, my lord, 378. And my lord, from the last, my lord, Saturday, my lord, I could not bring it on record, my lord, this is the situation.
This was a notice under the Land Reforms Act. পশ্চিমবঙ্গ ভূমি সংস্কার আইন 1955 57 ধারা
after the order of the honorable 51A4 after the order of the honorable chief justice, which is stayed in a review petition.
No, this is you have challenged these
yes
these notices before the tribunal.
Yes
Initially that is the
yes
challenge
that is the order, there is the challenge before the in OA.
Yes,
in OA. Thereafter, final order has been passed. I filed an application for staying of the final order.
Yes, Mr. Galit, this page 124 order is, I mean, it clearly shows that you are planning a project regarding that, and that liberty has been given to you.
This has started already.
No, we cannot look into
this is from Saturday,
we don't know. We cannot differentiate it from your house and that plot. Page 125 is very crucial. I mean, this may lead to the entire matter being infructuous.
Lordship, what I find is my learned friend has challenged this 91 onwards, these notices. And thereafter he participates in the proceeding. Kindly see 115 onwards.
Yes.
The proceeding started from 2023, my lord. Kindly see order sheet number 1. He continues to participate and finally the order was passed. Kindly see 119. 9 February 2024.
Is it apparent that it objected to that due to pendency of the?
Never did he
participate. I participated.
He participated.
Get an interim order.
He participated. So that was on 9 February 2024. He never proceeded for 54 also for statutory appeal.
When Justice Boshak's order was passed, what was this? That order had been passed already.
Because that is, kindly see Justice Boshak's order. It was,
my rescue commission let this may be taken care of first.
No, not that. Not that.
Paragraph 3.
No. When was the final order passed in connection?
2023.
This 51A4. Lordship, kindly see 119 on 9th February 2024.
9th of February 2024.
Even after that, you are proceeding with that way.
That is
You participated in the proceeding.
but participated
All
because
through.
all throughout we could not get any interim order because my lord,
In the proceeding, did you challenge this notice?
in the original application we
No, no,
challenged.
before the revenue officer.
No,
You participated in the proceeding. Did you say that the notice was faulty? Yeah, that chapter is over. This way has become infructuous, Mr. Bhattacharya. We can do two things. One is that we will observe that in view of your participation at that having culminated in an order, this way has become itself has become infructuous, and I will dispose it of from here, grant to liberty subject to limitation to prefer an appeal. Or we can give you the liberty to withdraw this writ petition before us.
That kindly, if your lordship would kind enough to see, my lord, the revenue authority, my lord, takes care of my pendency of OA. Kindly see, my lord, the 9th February order at page 119. The final order. Second paragraph, the Surjonaran Nando Goswami and others submitted an order passed by Honorable LRTT in OA number 3672 of 2023 in the matter of Surjonaran Nando Goswami and others.
Yes, there was no interim order.
There was
It
proceeded.
This has become infructuous. There is no scope of any stay of the notice. How can there be a stay of a notice which has already culminated, merged in the final order?
Oh, my lord, if,
Can we grant a stay?
if the notice goes, my lord, subsequently all will go.
If the notice goes, subsequently all will go. But as of today, that notice has culminated in an order.
And where he participated.
Yes, yes. We had no other option because all throughout we have been pursuing
Maybe
for
that-
interim order. We did not get it. That's why.
No, no, we'll hold that this has become infructuous and we'll permit you to.
My lord, so long, my lord, the appeal is preferred, my lord, I am entitled to, my lord.
No, no, you are not entitled as a matter of right. If you are within limitation, we would have granted you that protection to a limited extent, provided you prefer an appeal within that
No, my
period.
lord, I'll get benefit of, my lord, the section 14.
Section
benefit.
14, but even this, when was the way filed? Way was filed before that.
OA was filed at the notice stage.
Benefit of this writ petition?
Benefit of writ?
No.
No, leave, my lord, 1 week.
And that way was pending at that point of time
23,
already.
23. 23.
Yes, Mr. Kali, what do you say?
I don't stand in that way. If he has to challenge this order.
No, that will give him liberty, but whether an interim protection should be given for limited.
No, I leave to lordship. I don't.
Because we, otherwise we would
Well,
not
both
know
of us
unless,
have
my lord,
present the entire
that Rana's writ petition would have, my lord, come, my lord, and state take it, my lord, my lord, we would have not, my lord, known, my lord. If
We are actually short of fingers, so you'll have to give us the pages.
Yes, my lord.
Justice Bosak's order, which page? 122. Probably.
122. Yes, my lord.
Yes, yes.
And Justice Chandra's order is at 124.
The petitioner before this court, one petitioner or several?
Several.
The petitioners before this court have preferred a challenge before the West Bengal Land Reforms and Tenancy Tribunal against a notice issued under sections 57 read with 51 capital A within bracket 4 of the West Bengal Land Reforms Act 1955. Full next para. During pendency of the said application, comma, the petitioners also applied for stay stroke interim orders, comma, which was registered as a miscellaneous application. Full next para. However, comma, since the said application was not being taken up for hearing by the tribunal, comma, a writ petition was moved before this court, which was disposed bearing WPLRT number 69 of 2025, which was disposed of by an order dated May 16, 2025, whereby the tribunal was requested not to grant any unnecessary adjournments and endeavor to dispose of the miscellaneous application fixed on July 22, 2025, either on such date or within a period of a month thereafter. However, comma, learned counsel for the petitioner submits that despite the said order, comma, the tribunal has kept the said miscellaneous application pending and, comma, by the impugned order, comma, without considering the prayer for ad interim injunction stroke stay, comma, fixed the miscellaneous application for hearing on March 3, 2026, thereby putting the petitioner to the peril, exposing the petitioner to the peril of the original application being rendered infructuous. Full stop. Next para. Learned counsel, the learned senior government advocate appearing for the state submits that in the meantime, the said notice, which is impugned before the tribunal, has culminated in a final order passed on the basis of such notice by the revenue officer. Full stop. It is further submitted that the petitioner participated in the said proceeding and as such cannot resile from such position and persist with the challenge before the notice itself. Full stop. Next para. As regards the interim prayer for stay stroke injunction is concerned, learned senior government advocate opposes the prayer and submits that since the notice has already reached its culmination and merged in the order passed by the revenue officer, the appropriate remedy before the petitioners lay in an appeal. However, such appeal has also become time barred by now. As such, the prayer for interim order is opposed. Next para, learned counsel for the petitioners, in reply, places reliance on an order dated May 16, 2025, passed in WPLRT 69 of 2025. Sorry, it places reliance on an order dated November 6, 2025, passed in WPA 16704 of 2025, where, in connection with a writ petition in respect of plot number 378/1020, which is a butter plot adjacent to the present plot within bracket plot number 378 bracket closed, it was recorded by a learned single judge of this court that a tender notice was issued by the respondent by the Potaspur Roman II Panchayat Somiti inviting tenders for the construction of a market complex on plot number 378/1020. Full stop. It was clarified by the learned advocate for the state in the said matter that the proposed market complex will be constructed on plot number 378, which is a vested plot belonging to the state. Full stop. Thus, it was clarified by the learned single judge that the Panchayat shall be at liberty to proceed with the project, excluding the portion of plot number 378/1020, which was under the possession of the petitioners in WPA 16704 of 2025. Next para. Thus, it is explicit from the observations in the said order that a market complex is proposed to be constructed on the subject matter of the present proceeding, that is plot number 378, for which tender has already been invited. As such, it is submitted that unless immediate protective orders are granted, the challenge before the tribunal preferred by the petitioner as well as any prospective appeal, if filed against the order of the revenue officer, would be rendered infructuous. Next para. Upon a perusal of the materials annexed to the present writ petition, we find that the state is justified in submitting that the notice which has been impugned in the original application before the tribunal, from which the present writ petition has been preferred, has culminated in final orders being passed in miscellaneous case number 589 of 2023, where the petitioners participated. Full stop. Next para. Thus, the original application before the tribunal, which was a challenge to the notice, which has since merged into the final order in a proceeding filed pursuant to such notice, has been rendered infructuous. Full stop. Accordingly, there is no scope for grant of any interim order or hearing any miscellaneous application in connection with the original application itself. However, the remedy of the petitioners would lie in an appeal preferred against the final order passed in miscellaneous case number 589 of 2023 by the empowered officer under the under section 51 capital A within bracket 4 of the WBLR Act, that is the concerned BL and LRO. For sub next para, we take into consideration the delay occasioned by the petitioner due to pendency of the original application at the behest of the petitioners, who might have been under the misapprehension that in view of the genesis of the proceeding before the revenue officer itself being under challenge in the original application, comma, if the original application was allowed, comma, the entire proceeding would be quashed automatically. Full stop. That apart, comma, the pendency of the present writ petition also consumed some time. Full stop. We find sufficient bona fides attributable to the petitioners in laboring under such misconception, comma, which might have been a plausible view. Full stop. Next para. Hence, comma, liberty is granted to the petitioners to prefer an appeal against the final order passed in miscellaneous case number 589 of 2023. Full stop. If such appeal is filed within a period of 3 weeks from date, comma, the benefit of section 14 of the Limitation Act shall be given to the petitioners due to pendency of the original application and the present writ petition during such period, in the interregnum. Full stop. Next para. In order, we are also sufficiently satisfied in view of the order dated November 6, 2025, passed in WPA 16704 of 2025, that a strong prima facie case for grant of interim order has been made out in view of tenders already having been issued for a proposed market complex in the disputed plot. Full stop. Accordingly, comma, for the ends of justice, comma, we grant stay of operation of the
9th February 2020.
no, the final order passed in the notice we want.
9th February.
Operation
February
of order number 9 dated February 9, 2024, passed by the BL and LRO. BLRO of where?
That is
BLN and Empower Officer. Miss case. No. Millard, on the page 115, Millard, kindly see the seal and stamp, Land and Land Reforms Officer, Potashpur.
Block land BL and LRO, Potashpur, hyphen Roman 2.
Potashpur 2. Roman 2.
1 minute. Hyphen Roman 2 in miscellaneous case number 589 of 2023 for a period of 6 weeks from date or until further order passed by the appellate authority, comma, if an appeal is filed within the above stipulated period. Full stop. Next para, it is made clear that it will be open to the appellate authority, comma, if an appeal is filed within the period stipulated by us, comma, to vacate, vary, modify, and or extend such interim order upon giving an opportunity of hearing to both sides. Full stop. Next para, in view of the above observations, comma, OA 3672/2023 bracket LRTT bracket closed, along with the connected application bearing MA 1166 of 2024, stand disposed of as infructuous. Full stop. Next para, we further make it clear that it will be open to the present petitioners to raise objections against the notice, comma, which was the genesis of miscellaneous case number 589 of 2023 in the appeal preferred against the final order passed in the said miscellaneous case. Full stop. We have not entered into the merits of the matter, and it will be open to the concerned appellate authority to decide the appeal, comma, if preferred by the appellants within 3 weeks from date, comma, on its independently on its own merits upon giving adequate opportunity to all parties in accordance with law. No arrest to cause. Affidavit of service filed to be kept.
Good.
Next.
Irrigation.
Next matter, my lord. I beg to represent the petitioner, my lord. The state is, my lord,
Yes,
My lord, it would take some time.
we'll take it after the recess.
Lordship.
Start after the recess from this matter.
Yes.
Yes.
Milord, may I respectfully hand over the affidavit of service, Milord. Milord, here, Milord, two orders are under challenge, Milord.
Right.
The first order, Milord, is the order which has been passed under the original application. Thereafter, Milord, a review was preferred by the state, review rejected, and the contempt was also filed by the petitioner for non-compliance. So on the same day, Milord, upon rejection of review, the contempt was also allowed on contest. And next date fixed, the contempt was directed, you come with the compliance. So first,
challenging the review contempt order as well as the original.
As well, in the one petition it has come up.
Can it be done?
Cannot be done. Cannot.
Direct you to put in
Cannot be
additional
done.
court fees and.
Cannot be done. But my learn.
Will direct you to put in additional court fees and.
Yes, yes. Cannot be done. Yes, Lordship. So may I respectfully place the case, Lordship. My Lord.
Before we forget, let us just give a right. Since two separate orders have been challenged by the self-same writ petition, the petitioner is directed to put in additional, petitioners are directed to put in additional court fees commensurate with two separate writ petitions by tomorrow.
Sure.
Yes.
My Lord,
before my learned friend starts, the previous occasions, there was another round of WPLRT. The entire records was placed before the Land Reforms Tenancy Tribunal. That has not been annexed. I have the copy, my lord. I can,
if necessary, we'll take. Yes.
May I shorten the, let us try to shorten the issue,
Yes,
my lord.
yes.
My lord, the bird's eye view is this, my lord. The father of the petitioners. They are the post.
Father of the petitioners.
Father of the petitioners.
Which is the central government.
No. OA is at 105. Kindly take guidance from, we may take guidance from the OA lordship. OA is at 106. This Narayan Chandra Bhomik and Nishikanto Bhomik.
Yes.
Lord,
father of the petitioners.
Petitioner Narayan Chandra Nishikanto Bhomik. Their father,
yes,
they were the purchasers from the ex-intermediary in the year 1957 by 3 sell deeds of a land.
Their fathers means father of petitioner numbers.
Vijendranath Bhomik was the purchaser.
Sole purchaser.
Lordship. By dint of 3 sell deeds in the year 1957. Post-vesting purchaser. Land sold was by the intermediary. The land sold was not the retained land. Was not the retained land of the expedient. So, my lord, so after being the post-vesting purchasers, there were multiple litigations, as many as 5, my lord, original applications. My lord, the common thread running through all these litigations were that, yes, the record of right has to be corrected. In the maze of these particular 5 these litigations, in one of the litigations before the learned tribunal gives liberty to the petitioners that you approach in a reference proceeding under section 57B3. That is before the SD LRO. On the basis of that particular liberty given by the learned tribunal, my lord, these petitioners approach the reference proceeding before the SDLO. What the SDLO does, he, while initiating the proceeding under sections 57B3, also reopens the case under section 6, subsection 1 and 5 of the Estate Acquisition Act. This is where it pinches the state government. That order lordship you will find at page 115 of the writ petition. So he goes on, what does he, my lordship, kindly don't go through it. So, my lord, what does he do? Having had initiated the proceeding of section 57B3, read with section 1, section 6, subsection 1 and 5, he allows the deceased intermediary that yes, you are hereby allowed to retain that part of the land which has been sold to the father of the petitioners. So upsetting the entire section 4.5 proceedings. While the 4.5 proceedings was on, the deceased intermediary did exercise B form but unsigned. So this Kagdeep SDL in a proceeding under 57B3, he allows the retention of the deceased intermediary, that to the lands which have been purchased by the father of the petitioners. So our humble submission is that this part of the exercise of the SDLR is without jurisdiction. So far as 57B3, yes, you can, but this 6 subsection 1 and 5 you cannot reopen.
57B3 of which act?
B3, Lordship.
The Estate Acquisition Act.
Estate Acquisition Act.
6 and 57.
Yes.
So he reopened the 6 while undertaking 57.
While undertaking exercise of 57B3, he uses the word also that read with. Kindly sees 115 page once.
Yes.
Kindly sees page 115, Lordship. Proceedings under section 57B3 read with section 6.1 and 6.5 of the SOC. May I respectfully read out section 57B3.
Yes.
Any dispute referred to in clause B of subsection 2 may be decided by the revenue officer, not below the rank of an assistant settlement of a special aim for the state government in this behalf, who shall dispose of the same in such manner as well. This was the pursuant to liberty granted by the LRTD. Provided that in deciding a dispute under this subsection, the revenue officer shall not reopen any matter which has already been inquired into, investigated, determined, or decided by state government or any other authority under any project. So this reopening of already decided investigated matter cannot be reopened. That is section 4.5. So this is exactly what he has done. So but my first full summation is this particular order is is a nullity being without jurisdiction. Kiran Singh Miller, I would like to rely upon. So this is where it pinches. So my first Miller defense and contention in support thereof, may I, Milord, show your lordships, Milord, internal page 6 of the Milord order under challenge. May I trouble your lordships, Milord? Lordship may go towards the last part of the, I will show the certified copy of the orders. That is dated 20th June, Milord. Lordship will get it after page 154.
Yes.
May I, Milord, respectfully invite your lordships, Milord, straight away, Milord, internal page 6. Milord, second paragraph starts, sentence starts, being aggrieved, the applicants file an MA being 242202 before this tribunal. As per direction of this tribunal, the matter was deheard by the BLR through a missed case number, so and so again rejected the claim of the applicants. In disposing of the MA number 242 of 2002 by the Honorable Tribunal, liberty was granted to the applicants to make a reference before the SDLRO under section 57B3 of the West Bengal State Acquisition Act. In compliance, the SDLRO initiated proceeding being number so and so, coupled with 615, 61 and 65, and disposed of same on 18th October 2004. Wherein the intermediary was allowed to retain 25 acres agricultural, including so and so, including the purchased lands of the applicants, 2.so. The applicants filed an application before the BLR Namkhan on the strength of so and so. So, Milord, here the first disputable summation is that order itself of the SDL is without jurisdiction, hence a nullity. Challenge, no challenge. Although it is an appealable order, if your lordship kindly goes through 57B4, state has the power to appeal. Not yet appeal against. Secondly, my lord, this retention power, it is assignable, not heritable. It is heritable, not assignable. So deceased intermediary, this proceeding of 57B3 was initiated at the behest of the post-vesting purchaser.
But what is the scope of 57B3? I mean, 57B3 is any dispute referred to 2B. 2B is dispute involving determination of the question whether a riot or an intermediary is or is not entitled to retain under the provisions of the Act. So why didn't you challenge the SDLR order?
Certainly a lapse. 57B4 was the remedy that the state should have had taken.
The proviso was operative ab initio whenever that reference was made. Because the reference, scope of the reference.
May I take that point with your lordships now? Nullity, challenge, no challenge. Kiran Singh.
All right.
Lordship. And as on date, they can also have, they have not. So, Lordship, this is my first respectful submission. Nullity may challenge, may not challenge. And second problem is, my lord, with regard to the
SDLR order is a nullity in the reference in the first place, 57B reference.
Lordship.
Very well. Yeah.
Now, reference was not bad. Decision of age is bad.
Reference on what? The scope of adjudication on the reference would be entitlement to retain.
Yes.
So if proviso is operative, it was operative at that point of time also when the SDLO referred.
Yes. So learned tribunal's direction.
This dispute can be resolved only if it is not previously decided.
Lordship.
So when the moment at the point of time when the reference was made, at that point of time itself a dispute had already an adjudication has already been made.
Lordship.
So therefore the reference itself was bad because there could not be a re-adjudication on the same thing.
Lordship.
Retention is the scope of say 4, 5, 6, whatever. So retention, the proviso was operative when the reference was made itself.
Yes.
This can only be for the first time. And the scope of 57B is when it is taken before a civil court, basically. No civil court shall entertain, and if it relates to,
it can be taken up by assistant settlement officer also. But there is a proviso.
Very well.
So this is where, my lord, internal basis, this part is, my lord, my first contention with regard to the main judgment passed in OA. Now, so far as if your lordship is not with me in this, that no, I consider it as a valid. Now, my lord, may I cruise on to the, my lord, second for content part. Lordship kindly see the contempt, the very next order, my lord. After completion of this, Lordship kindly sees, my lord, the contempt order. Just after completion of this OA judgment, Lordship kindly sees the contempt order. Order passed in the contempt proceeding.
First review or both together?
Both on the same day. 15 September 20, your lordship got it? 15 September, the judgment part.
Yes.
Not the pronouncement, but the entire text of the judgment. 15 September, kindly, my lord, kindly comes to me internal page 10 and 11.
Yes.
Lordships, may I respectfully invite your lordship to the concluding. Hence, the contempt petition is allowed on contest.
This quotation is from Ramayana.
Yes, some scriptural quotations are there. Dharma protect at page 9. Manusmriti, lordship.
No, he says Ramayana.
Now, Dharma protects those who upholds it. Manusmriti at page 9. Internal.
At page 10, you say.
At page 9, there is a kindly see. At page 9, summing up under the heading Dharma protects those who uphold the Manusmriti. So, lordship, so internal page 10 at the
Dhar was arguing the matter for them.
Lordships.
Mr. Dhar was arguing the matter for them.
I think Mr. Dhar was.
Yes.
So, my lord, so contempt allowed on contest. In view of the following discussion, this tribunal passes the following. A review application filed by a state in MA 3 is rejected on contest by malafide so and so, and contempt is allowed on contest same day. And kindly, my lord, may I respectfully invite your lordships to page 11.
Apart from the Manusmriti and the Ramayana, was any law quoted?
My lord, law.
Yes.
He has
Those parts not been.
This is a summing up portion.
Summing up. No, entire history of litigations have been quoted. Entire facts have been quoted. There were as many as 5 litigations, 5 ways.
What was your ground of review?
Ground of review is, my lord, my review application, my lord, is at pin, my lord. Review application is at page
What is this in pursuance of a direction of the High Court? This was passed.
Yes.
What
Page
was the-
50, my lord. Review application.
What was the previous direction of the High Court?
এটা লাগায়নি তো।
It has not been annexed.
কিছু দেয়নি, তোমরা আগের 5টা রাউন্ডের লিটিগেশন দাও।
Oh, in the review, it is stated. I
Yes.
tell the paragraphs.
Approach the tribunal 5 times.
Previous WPL.
16 কি অর্ডার হলো সব বলা
বলা আছে লাগাওনি তো।
The entire thing has been narrated in the review application, lordship. Like kindly sees me lord page 56, page 58, my lord, kindly sees page 58 is a part of the my lord review application, my lord.
No, the original order which you placed before us, that was a challenge against what?
Against OA is against an OA which is at page my lord 105.
You tell us what is the challenge?
That is for application is made inaction on the part of the respondent number 3 for non-implementation of the order dated 11 September 2017 passed by this honorable tribunal in OA 762 and 645.
What was that direction?
What was that direction?
What was the representation about?
For correction of record of rights?
In terms of the SDL, the adjudication.
Yes.
So the SDLRO first directed this section 57B. 57B was taken up by the revenue officer along with the other sections, section 6 and all, and re-adjudication and whatever you said was held. That order was not being implemented. For that, a representation was given, which was not being considered, due to which this OA was filed. Right?
Lordship.
So in the OA, direction was given to the BLRO to correct the records of rights in respect of, in terms of that adjudication.
Lordship.
So the main adjudication of the BLRO was not challenged by you also. After that is also a nullity. SDLRO is a nullity, BLRO is a nullity. SDLRO directed the BLRO to have a hearing
And
under
the tribunal directed the SDLR. Pursuant to the liberty, they preferred 57B3 proceeding before the withdrawal.
No, please give us the chronology again.
57B3 proceeding
Yes.
was pursuant to the liberty given by the learned tribunal.
In connection with what? What was challenged before the tribunal?
For correction of record of rights, my lord.
So correction of records of rights was sought before the BLLRO
Lordship.
by them.
Lordship.
Then what happened? That was there was inaction.
Inaction as well as 5 litigations.
Inaction, therefore tribunal.
Lordship.
Now in that proceeding, tribunal directed section 57B.
In one of the ways, my lord, not in which way I can't see. In one of the ways.
I don't know.
In one of the ways, my lord, it goes before the SDLR. Liberty was given by the learned tribunal. Pursuant to the liberty given to the petitioners applicants, they approached the SDLR.
No, tribunal directed SDLR to have a consideration under section 57.
Yes, that directed the given liberty to the petitioners that you approach before the SDLR with a reference case under section 57B3. Now, SDLR, while exercising 57B3, he exercises power with read with 6, subsection 1 and subsection 5 of the Act. So here on that issue, Miller, it's a nullity, he cannot reopen it.
So SDLR reopened. Pursuant to that, they gave a representation before the BLRO.
Lordship. Then last, this is the way.
So first, correction of records of rights was sought by them. Inaction, tribunal. Tribunal gave liberty to file a reference case before under 57B before the SDLR. Then
in one of the ways, my lord.
Whatever. I mean, this is not the chronology. What is the chronology?
Chronology, kindly have a look.
Tell us just.
In 2000, in the year 1957, I bought this land. Thereafter,
We'll have the chronology only, then you will hand over to him.
I'm just telling you the chronology.
1957,
then my name was recorded.
1957, then purchased.
Purchased. Date of purchase is 1957.
Yes.
Then my name was recorded. Khajna was paid in the year 1964. Then 1969, they started with a BR case proceedings holding my vendor was the big riot. And hence the entire land of that big riots was vested. What was the reason? Reason that my vendor did not file B form. Did not file B form. Then 2001, I again filed an application that surreptitiously you have struck off my name from the record of rights. You have not invited me, such and such. Kindly record my name. BLLRO did not do anything.
No, the vesting order was not challenged by you.
No, I was not aware. I was not party to that vesting proceedings.
Your predecessor in interest was?
Yes. My predecessor, by then, my predecessor in interest had sold the land in favor of me. 7. And vesting started in 1964.
But you were not notified.
I was not notified. Then 2001, my first way. In that way.
No, what did you do then? You did not know of that 1969 vesting?
Yes.
You asked for recording your name?
Yes. Then BLLRO did not do anything.
Ask for recording your name means your name you saw that it was changed. It was already
Yes.
recorded.
All of a sudden, my name was struck off from the record of rights without giving any notice. Then I went before the tribunal that BLLRO is not doing anything.
Then whatever he said.
Then tribunal has passed a direction within a certain stipulated time period to BLLRO to dispose of. Then BLLRO had disposed of by saying that I am a post-vesting transferee, hence I do not have any right. Again, BLLRO has rejected. Challenging the same said order, I filed a second way application before the tribunal. That was the second way. Well, first way in the year 2001, then second way in the year 2005. In that 2005 proceedings, the tribunal has said, upon hearing both the parties, you better go before the SDLLRO by invoking under section 57B3. They have not challenged that order. I went before the BLLRO seeking for application, filed application under section 57B3.
It would be better if you had prepared a release.
But I have prepared.
And
it's handwritten. I'll type it and I'll give it.
Because that is extremely necessary here.
Very necessary because tribunal has recorded all these facts.
To prepare a list of dates.
I'll do it. I'll do it.
Just hand over a copy to Mr. Galib and come.
Yes.
Without
I have given the previous WPLT petition as well as the order. As well as the order of the
take it back, you hand over tomorrow when you take up when you next. Affidavit of service filed to be kept on record. So, at the time of hearing, it transpires that the matter has a checkered history. As such, we request learned counsel to furnish a list of dates to enable us to properly adjudicate the matter. Accordingly, let the matter stand adjourned for the day. Come back with whoever prepares a list of dates, give it to the other side. Give it to the other side. The checker history already here. Already direction.
Sorry, my lord, we could not assist your lordship.
Your lordship, for item number 19, I am the appellant. It is the impugned order is of 21st March 2018, and it was passed by your lordship, Justice Bhattacharya.
Justice Supratim Bhattacharya.
Yes, your lordship. So, your lordship, I am kindly place it may not be heard by this bench, your lordship.
Since the judgment and decree impugned in the present first appeal was delivered by one of us within bracket Supratim Bhattacharya J, right close, comma, we release the matter from our list on personal ground. First up, liberty to the parties to seek an assignment before the Honorable the Acting Chief Justice to a different bench.
Grateful, your lordship.
Malad 20 I am for the appellant. Malad senior is out of the station. Malad.
No ground. Then it go down. Why did you mention the matter then?
Malad I don't have any.
Let your senior be out of the out of station. Have you served copy? Was there a direction for service?
Malad I don't know the matter. Malad I am just only praying for the next week.
An adjournment is sought for at the time of call. Full stop. Since the matter was enlisted on the mentioning of the appellant and learned counsel who seeks adjournment is unable to assist the court, comma, let the matter go out of the list.
Grateful, Malad.
Give your name only. Only your name, not your senior's name.
Item number 21.
Lord, I beg to appear for the respondent. Lord, the Legal Services Committee has appointed me to appear for the wife respondent.
You are appearing in person.
I am appellant in person.
Suit for divorce.
You are all along appearing in person.
No, sir. My lawyer is busy. Another court.
You cannot appear before the court. Please take a back seat. If you have a lawyer, you cannot appear before the court. You don't have a right. Please take your seat there.
I am appellant.
The appellant cannot appear. You don't have a right of hearing. They are wearing a robe for a reason. You cannot just come up and appear because your advocate is not here. If you have an advocate, if you have given a vakalatnama, you have no right of hearing. Sorry.
I am permission from the honorable lordships for pleading.
You have an advocate.
I have an advocate.
You don't have a right to appear before the court if you have an advocate, unless you take a no objection from him. Sorry.
No, I am.
Who told you that you can appear at will?
I am appellant in person.
Appellant does not have a right to appear before the court, sir. Under the Code of Civil Procedure, you are debarred from appearing before a court if you have an advocate. Only advocates have that right, not litigants. We can give you liberty if you don't have an advocate only.
Liberty.
Please take a back seat. Please take a back seat. Yes, what are you saying? You don't have a right of hearing. Who told you to stand here? These are meant for advocates. Please go there. You cannot just at your will come up and argue a matter. Those chairs are meant for advocates. Please sit on the back seat. Who told you you can come up whenever you like? You have an advocate, sir. If he is not there, you are not entitled to appear before a court of law. You are only entitled to appear before a court of law if a court of law permits you. If you don't have an advocate, you have an advocate, he is not here, you are appearing here. Just because we are being lenient, you are taking a, no. Whatever you want. Please don't address us. You don't have a right to address us directly. Come to your advocate. Yes, Mr. Banerjee, what is the matter?
Respondent in the suit for divorce and as well here. My lord, I have taken out an application for maintenance pending utility. My lord.
You have served a copy on the other side.
At that point of time, my lord, I had approached the learned advocate who was representing. She has said that she had issued a no objection. Thereafter,
the person is not saying. You have taken a no objection from your advocate.
No objection of our advocate.
Have you filed the no objection vakalatnama in the department?
Department.
হ্যাঁ ডিপার্টমেন্ট মানে
Yes, department.
ডিপার্টমেন্টে আপনি কি ফাইল করেছেন ওকালতনামা নো অবজেকশনটা?
Yes.
আপনাকে তো জিজ্ঞেস করলাম আপনি নো অবজেকশন নিয়েছেন কিনা, আপনি বলছেন না কেন? ঠিক আছে, আপনি যদি নো অবজেকশন ফাইল করে থাকেন কবে ফাইল করেছেন, ফাইলিং নাম্বারটা কত?
Filing
my lord, subject to correction, probably subject to correction.
Yes,
another advocate has been appointed. Probably no objection grant given. Another, I checked the official.
আপনি নো অবজেকশন নিয়ে অন্য কোনো অ্যাডভোকেটকে দিয়েছেন?
নো অবজেকশন না, অন্য কোনো অ্যাডভোকেট দিইনি।
আপনি ডিপার্টমেন্টে যে ফাইল করেছেন নো অবজেকশন ওকালতনামাটা, সেটার একটুখানি নম্বরটা নিয়ে আসবেন কালকে, আমরা কালকে নেব ম্যাটারটা। Appellant seeks to appear in person. Full stop. However, there is a doubt whether a no objection has been obtained from his advocate. Full stop. In order to enable the court to consider whether to permit the appellant to appear in person, the appellant is directed to furnish the filing number of the no objection vakalatnama, if filed, when the matter is next called on for hearing. Full stop. Adjourn for the day. Please come back tomorrow. আপনি যদি ওকালতনামা নো অবজেকশন নিয়ে ফাইল করে থাকেন এবং আর কোনো অ্যাডভোকেট না দিয়ে থাকেন, তাহলে আপনার পারমিশন দেবো আমরা। আপনি ওকালতনামা নো অবজেকশন যে ফাইল করেছেন ডিপার্টমেন্টে, সেই ওকালতনামা কোথায় কি করেছেন নো অবজেকশনটা নিয়ে?
I pray to Lordship.
আপনি বাংলায় বলুন ওকালতনামাটা নিয়ে কি করেছেন আপনি?
ভোকালতনামাটা ওনার কাছেই থেকে গেছে, নেওয়া হয়নি ওটা। আমি কালকে না বলছিলাম এটা, যে আমি একটু হার্টের পেশেন্ট, আমি ব্যাঙ্গালোর যাব, এটা যদি জানুয়ারি মাসে ফিক্স আপ করেন খুব ভালো হয়।
না,
ডিসেম্বর,
আপনাকে একদিন সময় দেওয়া হলো, আমরা অ্যাডজেন্ট করেছি একদিনের জন্য।
ডিসেম্বরে এটা রাখুন লর্ডশিপ।
একদিন সময় দেওয়া হলো, কালকে আপনি হয় আপনার যদি অ্যাডভোকেট থাকেন অ্যাডভোকেটকে আসতে হবে, যদি নো অবজেকশন ফাইল করে থাকেন নিজে আর কোনো অ্যাডভোকেট না অ্যাপয়েন্ট করে থাকেন তাহলে সেটা ক্ল্যারিফাই করবেন, নো অবজেকশন যে ফাইল করেছেন ওকালতনামাটা ফাইলিং নাম্বারটা ডিপার্টমেন্টে নিয়ে আসবে। আর যদি কোনো অ্যাডভোকেটকে অন্য দিয়ে থাকেন বা নো অবজেকশন না নিয়ে থাকেন তাহলে সেই অ্যাডভোকেটকে আসতে হবে।
প্লিজ ফিক্সড অন ডিসেম্বর।
কাল থাকবে, কাল, বাংলায় বললাম তো। নেক্সট। None appears for the parties at the time of call. Let the matter go out of the list.
Item number 23. Lordship for the appellant.
Yes. Mediation has failed.
Mediation has been failed, and as well as the admitted fact is paper book is already ready, and this is also the admitted fact that both the husband and wife are living separately for more than 20 years.
You are for the husband or the wife?
And for the appellant means a husband.
So, wife obtained your divorce suit was dismissed.
Yes, and we came before the now your lordship, there was an order dated 6/8/25. Now in this order there was as well as the mediation and to pay a 50,000 alimony. Now for this amount we have filed a modification application that with prayer to pay the installment of rupees 5,000 per month, because I have already annexed my pension slip, and that is 26,000.
That application is appearing before us today. What is the number of that application?
Number is CAN 3 of 25.
Hanti ache.
Now your lordship.
Have you served a copy of this application on the other side? Please file the receipt.
Yes. Your lordship, বলছি। Oh, your lordship. Lordship, I'm extremely sorry. This cannot be served because in the modification application, in the portion of the prayer, there is a mistake. A typographical mistake has been.
What is the mistake?
Different prayer has been in different prayer. In some other case, that case prayer has
Copy
been.
paste. You are granting liberty to correct the, yes. Please amend the prayer portion, do it during the course of the day and serve a copy on the other side. We'll keep it next Monday, next Tuesday. On the prayer of learned counsel for the appellant stroke petitioner, leave is granted to the learned advocate on record for the appellant to amend the prayer portion of CAN 3 of 2025 during the course of the day. Full stop. A copy of such amended application shall be served on the respondent, either directly or through the respondent's advocate appearing in this court, and a receipt stroke affidavit of service in that regard shall be filed on the returnable date. The matter shall next be listed on December 2, 2025. They'll give you a copy of this application after correction.
Matter, my lord, in respect of the application for maintenance, Lord, your lordship, Miss Honorable Justice Somenson and Justice, my lord,
We
directed
have seen
to,
everything. We have passed an order. Just
but
appointed from her,
mediation,
will appear on-
mediation also, my lord, conducted, my lord, failed.
Mediation has failed. We started from there.
But
We
my lord,
start from the
no maintenance, my lord, till today.
rightly. Next.
Copy modification correction.
Yes. You're for the respondent, Mr. Shen?
Yes. Lordship, I appeared for the respondent number 1 and 2 in item number 25
Yes.
for the bank.
25 only.
Only in 25, my lord. Item 24. This is 24, your lordship has called. But 24 to 27 are
27 not
Yes,
50.
two, all three together, right?
And I am the appellant in all the matters, opposite party before your lordship now.
So we'll hear you first.
No.
Yes.
I am the appellant, but the application has been filed by the other side.
So they also have similar, you also have a similar application as Mr.
No.
Malam, we have no.
My application. My lord, application is a very short application. My lord. The lordship has, while admitting the appeal, these are all three appeals from Order 7, Rule 11. One suit counterclaim has been rejected. Two suits of my learned friend plaint has been rejected. All under Order 7 Rule 11. Those are the three appeals.
So their suits as well as their counterclaims
Claim has gone. Insofar as this appeal is concerned, this is in relation to the dismissal of the counterclaim. So at that point of time, my lord, the evidence was going on. So your lordship felt that the evidence cannot go on since the appeal from the dismissal of the counterclaim is pending. So your lordship has provided an interim order on the second day that the proceedings be stayed. Now, my lord, we have filed an interlocutory application before the court below in respect of, my lord, the secured amount. Under the order of the Supreme Court, my lord, we have filed the security to the satisfaction of the learned court. The Supreme Court order said that we will have to take leave of the court for the purpose of operation and maintenance of an account or for withdrawal of accounts from the bank. So that is the nature of application on the basis of the Supreme Court liberty, which we have filed before the court below. Now the court below, my lord, says, my lord, that since the proceedings have been stayed, my lord, nothing can be taken up.
That clarification you want.
That is the only clarification, that interlocutory application can proceed. This is the short prayer, my lord, if your lordship. But I was praying this, my lord, your lordship had already recorded while admitting the appeals that on the basis of the papers here, the appeal will be heard out. And my lord, just before the long vacation, the appeals were taken up. Your lordship said that since it's a three matters together, after the vacation, my lord, I think, my lord, the appeal, it's a very short point, my lord. Only their counterclaim has to be seen. My lord, I'll tell your lordship, my lord, the main point which we have taken.
Who are the counsel who are appearing? You and Mr. Mr. Mukherjee is also there probably.
Mr. Mukherjee is also there, my lord, but
that I also have someone, but we can.
Who is that someone? We want Mr. Jishnu Shah and Mr. Jishnu Shah is in all the matters.
Yes, is all the matters.
So not different counsel in different matters.
No.
Then we can think about hearing it.
Yes, but it is a related matter.
No. Related matters, Mr. Sen, you know what happens. Three sets of counsel, senior counsel, you won't be able to say no to either of them, and all of them will argue. And we'll hear it.
We are litigating a lot of.
We can hear the appeal itself.
We'll
keep it under the appeal hearing heading then. And this application we are allowing, Mr. Banerjee.
No, it cannot be allowed.
Why?
No, there are so many things.
No. Interlocutory application will only clarify that our stay order does not prevent, and that's the settled position of law. Stay of suit cannot operate as stay for interlocutory.
But I understand that. But the thing is,
we are not deciding the application.
But no such order was passed by the trial court.
What order?
What has just been submitted?
No, may not be.
But the trial court had never said, I will not entertain your application.
Even if the trial court does not say so, even if the trial court does not say so, if they have filed an application, they require a clarification. Why shouldn't you give it?
But kindly hears me for a moment, my lord. My lord, it is them who said before the trial court, we will bring an order from the High Court that this application is taken up. My lord, this is the order. I have it. My lord, now they are approaching before your lordship with the only purpose to get the appeal listed. I am not against that. My lord, no problem. My lord, that can be done. But what they are asking for is the final relief. They are the final relief in the suit by way of the interlocutory application. Second thing, my lord, the application that they have filed before, my lord, initial an application to give them the chance to operate the account. Trial court did not, trial court allowed that. My lord, against that, an appeal is also pending before your lordship in these lots. But all have to be heard together. My lord, kindly see the order passed by the trial court, my lord. The main that thing that they are asking, arekta copy dao, Judge Sahib. এইটাও জজ সাহেবকে দেবে দিচ্ছি গো এক সেকেন্ড but they on their own said we will bring a
what
order.
What is the occasion to go to the Supreme Court against what?
My lord, against the order
against
From an
the
interlocutory
injunction order being disposed of, but I can
In connection with these appeals.
yes,
Yes.
but I can show before not in this appeal,
In the suit.
in the suit. But I can show that Supreme Court's order also that is different from what Mr.
Okay,
Shane
it
has
is
just now
annexed to my
submitted.
application. I can show your lordship here.
But when Mr. Shane says, I never speak a single word, my lord. জজ সাহেব তো আমাকেও প্রশ্ন করতে পারবে অর্ডারটা দিয়েছিস তো তোমরা বলেছো আমরা কোর্ট থেকে অর্ডার নিয়ে আসবো
No, our intention was never to prevent interlocutory orders. That is the settled proposition of it. We'll permit the interlocutory application.
Malad
to be taken
kindly
up and decided by the
appreciates,
trial.
Malad kindly appreciates, my lord. There was no order passed by the trial court rejecting their plea or their application.
How can there be? Because of the stay order, the trial court cannot even take up the applications.
But
You
the
have to understand-
trial court never said so, my lord.
Whatever the trial court says, forget it, Mr. Banerjee. In view of a stay, for order of stay, trial court won't be able to take up the matter unless we clarify that the interlocutory applications can be taken.
Very well, my lord. Kindly takes up the appeals, my lord.
No, we'll
That will-
clarify that the interlocutory application, interlocutory order operates only regarding the final hearing of before the trial court, not interlocutory applications.
My lord, they want to take out the money.
That's on the merits
That
of
has
the
been,
application. Let it
yes,
be
that
decided
has
by the
been
trial court.
secured, my lord.
We
and-
cannot pre-adjudicate on that. Whatever happens, he oppose that application.
Yes. But there is a first miscellaneous appeal in connection to that before your lordship now pending.
Against what?
Malad, that order where the trial court had given a permission to take away, I mean, to operate the account.
Yes, argue that before the trial court when the matter is moved.
Yes. Malad,
What is your can
Malad,
number? Can
the
do?
only object is to
Whatever
frustrate the merits of the appeal.
Why?
Malad, they want the money anyhow in their hands right now before High Court
There is
intervenes.
no harm in their wanting that. And you want them not to get it. There is no harm in that either.
That court is adjudicating, my lord.
Nobody wants money in
Who
his
is
hands.
entitled to that money?
Who doesn't?
Who is entitled to that money? The court is adjudicating.
Banerjee, this is too much. I mean, you're opposing this. Learned Senior Counsel appearing for the respondent in FA 127 of 2024 submits that in view of an order of stay of all further proceedings of the suit from which the present appeal arises, comma, dated April 8, 2025, comma, passed by this court in connection with the appeal, comma, the learned trial court is unable to take up interlocutory applications filed by the respondent. Who's up next para? Learned counsel appearing for the appellants hands over a copy of an order dated August 25, 2025, whereby the learned trial judge recorded that in this case, next date, that is September 24, 2025, has been fixed for awaiting order from the Honorable High Court at Calcutta in view of the order by the said court, by the High Court, passed in FA number 127 of 2024, staying all further proceedings in the suit. Full stop. Thereafter, comma, the learned trial judge quoted the operative portion of the said order of stay granted by us. Full stop. Upon such observation, comma, the learned trial judge fixed September 8, 2025 as the next date for awaiting order from this court. Full stop. It was further observed by the learned trial judge that parties are to apprise the trial court as to whether there is any specific direction upon the trial court to comply with. Full stop. Next para. Thus, comma, it is evident that the order of stay dated April 8, 2025, granted by us in respect of the appeal, has been construed by the learned trial judge to mean stay of all further proceedings of the suit, comma, including interlocutory applications filed therein. Full stop. However, comma, we hereby clarify that the order of stay dated April 8, 2025, to the extent that all further proceedings in the connected suit bearing title suit number 314 of 2021 is concerned, comma, such stay operates only in respect of the final hearing of the suit and shall not prevent the learned trial judge, comma, in any manner, comma, from taking up and disposing of interlocutory application, comma, if any, comma, filed by the parties. Full stop. Next para. Although learned counsel for the appellants has opposed the opposes the application sought to be filed by the respondent in the trial court on merits as well, comma, we do not entertain such arguments, comma, since it will tantamount to prejudging the merits of such interlocutory application. Full stop. The only scope of the present application is to seek a clarification as to the scope of operation of the stay order, which we have discussed above. Full stop. Next para. Accordingly, Can 2 of 2025 is disposed of by making it clear that the stay order granted on April 8, 2025 in connection with the appeals shall operate only in respect of the final hearing of the suit and not impede the learned trial judge from taking up and disposing of interlocutory applications filed in connection therewith. Full stop. No address to cost. The appeal, did you record it that appeal can be heard on the basis of these papers?
The first order.
Yes,
I think, my lord.
Then all the appeals we are fixing together.
Yes, my lord. Lordship's order is April 8,
Very well.
2020.
The appeals shall be heard on the papers already on record as per our previous observation and shall be listed for hearing in the monthly list of December 2025. Next week.
My leader
Oblige,
is-
Your Lordship.
I'm sorry. I seem to be.
Thank God we finished before. No, this Mr. Shah does not take much time. We only inquired whether there are separate seniors in the three separate matters. Then we did not take
I'm
up the
sorry,
matter.
I seem to be making a habit of this.
No.
But only one thing, if my lords has the pleasure, my lord.
Yes, Mr.
But
Banerjee.
not being influenced by any observations made in the order, my lord.
Let them be influenced.
But
Some influence should be there. We are not having any influence anywhere. So at least some influence should be there.
Lordship is having profound influence, my lord.
On my barmaids when I was not beyond that.
I'm grateful.
Oblige, Your Lordship.
Thank you. 28, yes.
28, my lord.
You're for the respondent.
I'm for the respondent, number 1 and 2.
What is the application for?
Application, he filed an application for injunction.
Their application. No interim order has been passed
No interim order.
for the first time. You have got a copy of the application.
Yes, my lord, I have filed. I have got.
Appearance
The final degree was passed. Thereafter, my lord, my client, my lord, purchased, my lord, 3.5 decimals of land from
No, we are putting it out of the list. If none appears for the parties, we are clearing
thereafter,
the
my
list so that we can take up
but
matters.
in the lower court, my lord, the final report has been.
behalf of the appellant on record, advocate Nirmal Dhara, but I
final
am praying
report.
for not today, sir.
Refused.
Final report
Go out of the-
already, my lord.
Final report has been filed. This is against the final degree of partition. We have to stay the operation of the. Otherwise, the appeal will become infectious. We are allowing the application, directing them to. You want to put in special messenger cost or prepare the paper books, or they'll.
My lord, if you lordship.
No, we won't direct unless you ask for it because they may delay the matter. That's why we are saying.
Yes, if you lordship.
Should we direct you to? Yes. Very good. Can the present appeal arises out of an application, out of a final degree of partition? Push up next para. In view of questions of both fact and law being involved in the appeal, comma, we are of the opinion that unless the operation of the impugned decree is stayed, comma, the appeal might be rendered infructuous before being heard finally. Full stop. Accordingly, Can 1 of 2024 is allowed. You are the only respondent.
No.
There are others.
Others are there. But I am.
You are for the
respondent number
plaintiffs.
1 and 2.
1 and 2 plaintiffs. Did the other defendants contest the suit?
No.
Are you sure? Let us check up.
The suit may be hereby decreed on contest against the defendant number 1 and ex parte against the defendant number 2, 3, and 4.
Right. So they did not. They will dispense with service. কোনখানটা ছাড়লাম? Yeah. Can 1 of 2024 is disposed of by granting stay of operation of the impugned judgment and decree dated August 24, 2023, passed in title suit number 143 of 2022 by the learned civil judge, senior division at Kalna, district Purbo Bardhaman, till disposal of the appeal. Full stop. Next para. In order to expedite the matter, on the prayer of learned counsel for the plaintiff stroke respondent numbers 1 and 2, the trial court records be called for by special messenger, at the cost of the respondent numbers 1 and 2, to be deposited within a week from date. Full stop. The respondent numbers 1 and 2 shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the said respondents. Full stop. For such purpose, the office shall serve notice of arrival of the records on the learned advocates for the appellant as well as the respondent numbers 1 and 2. Full stop. Next para. Although the matter arises out of a partition suit, in view of the other defendants stroke pro forma respondent numbers 1, 2, and 3 having not contested 1, 2, and 3 defendants stroke other defendants stroke pro forma respondents having not contested the suit in the trial court, service of notice of the appeal on the said respondents is on the said pro forma respondents is dispensed with, and the appeal be treated to be ready as regards service. The appellant shall put in Tolobana of rupees in view of the service of notice being dispensed with, the office report indicating that Tolobana and postal costs have not been deposited may be ignored. Thank you. Don't give the name of your senior. Only your name. Only your name.
29 Lordship, Mr. Shubhradin Dhar is for the appellant Lordship state.
You start the
He's
matter.
I'm not in.
Not in the matter at all.
No.
Goes out of
not
the
his
list
state.
usual.
It is my application.
Oh, your
And
application
therefore-
cannot go out of the.
But
What is?
then your lordship can take it out day after tomorrow.
No, no. Right now we'll take a Mr. Dhar will be rushing in soon. You say, what is the matter about?
Kindly make it not today,
Why?
Lordship. Kindly take it up tomorrow. He's on his legs, Lordship.
Which court?
My code number 1, I think so.
He'll be coming soon. What is the matter about?
My lord, one acquisition proceedings was held. Learned LA collector, LA judge, passed an award. My lord,
State has challenged that.
state has challenged that. My lord,
This is an enhancement award.
yes, my lord. My lord, your lordship kindly see the award which was passed. My lord, thereafter, my lord, respondent filed their execution proceedings and claiming that 38,000 and 38 lakhs and what. My lord, they have deposit. Your lordship kindly see the order. Your lordship's order, paragraph 2 and 10.
Which order dated?
Order dated, my lord, 16th of December 2024. Paragraph 2 and 10.
They have not deposited?
No, my lord, only 6 lakhs they have deposited. My lord, your lord, you kindly see the execution application and page 23. In my application, present application. Page 23,
This was the total amount.
total amount. My lord, they have deposited only 6 lakhs and 30. देखिए कोई कागज तो- হেঁটে ঘ করে দিচ্ছে রে।
We are passing it over for some time because apparently you have a very good case for vacating the stay.
Yes.
But then we should hear Mr. Dhar. Please inform him that we'll take it up after say 10 minutes. Pass over.
Kindly make it not today, Lordship.
Why not today?
Kindly keep it tomorrow.
Why? He's on legs, he'll come.
It will take some time there, Lordship. Kindly make it not today.
State has paid the money. Then we'll grant time. No, no time. In these matters, no time. Sorry. 10 minutes pass over. Inform Mr. Dhar in the midst of arguments. If he does not come, we'll take up expertise and decide. 10 মিনিট পাস ওভার ওই মিনিট 10 বাদে ডাকবেন একবার জিজ্ঞেস করে নেবেন ডাকার আগে
Item number 30.
Lord, I beg to appear for the respondent.
Yes.
Will you
Lord,
kindly take it up tomorrow? Milord?
No.
19th of
No
November.
question of any adjournment.
Because my
Every day you are mentioning matters and we are not being able to accommodate.
has not come.
But you are very strict. No. We have to be uniform.
19th of November, Lord, 2024.
You are appearing in the matter.
Yes, I was there all along.
We are confident of your account.
30,000 Lord, occupational charge granted by my Lord, not deposited by them, so stay automatically vacated. That is not the issue. The
Appropriate order for-
application, no, the application is only for sending back Lord, the lower court records for carrying out certain corrections. And Lord, I have also initiated the execution so that I can proceed there. These are the
What corrections?
correction, Lord, in the name. Yes, name in the decree, Lord. Two names are to be required.
Problem
Which
I am suffering is it is incorrect that I have not deposited anything. Initially I was complying with the order, but Milord, thereafter when I brought the records to this court, Milord, because the LCR was called for, because of the same mistakes, the LCR could not be finalized and paperwork could not be filed, and my appeal has not been heard yet. Appeal has
That
been
doesn't
admitted.
stop him from making
No, I can't.
your lordship's order.
Then Lordship
Why
kindly
can't you pay for that?
But because it was being onerous at that stage, that's why my client could not continue paying.
He has vacated.
So I'm not.
You yourself determined that it is onerous and you stopped paying. There was a direction of the court.
Yes,
But then the stay-
it was a conditional. It was a conditional order.
Conditional, you have not complied.
I have not
Stay-
complied.
Will record that the stay stands
That's not
vacated.
their prayer, Milord. But only thing I am saying, if Lordship sends.
No, will that no prayer is required for that.
So that if they
We'll
don't
record that
So if the records are again sent back, then my appeal will never be heard.
for correction.
It was once gone, then came back. My appeal is stuck because of that only.
What are the exact corrections required?
Now, the corrections I have indicated, not page 15. Typographical error in the name, father's name of plaintiff number 4 and 5 was not written correctly. Not page 16, I have indicated paragraph number 4. These are the corrections required.
I am carrying the orders passed by Learned Master, which
In any
talks about a
event, they
mistake.
don't have a state
And why
today.
this thing is not Milord, finalized in the department, Milord. I can't file paper book. I can't proceed with the appeal.
Why?
Because if the paper book is not finalized because of the mistake in the records. It was when.
So then, in any event, it has to be sent back for
not
correction.
these mistakes. There are separate mistakes that Learned Master
You will
records.
direct all the mistakes to be corrected.
Maybe,
Whatever,
Milord, yes.
whatever.
Then the record should come back. That kindly also make that direction. It should not lie. Milord, if they.
Why should it lie there? After
Kindly,
correction, it will come back.
Lordship knows this situation. What happens in the court below, Milord.
No, we'll record that after correction of the after effecting the necessary corrections in the judgment and degree.
Yes.
Your corrections are also in the judgment and degree.
Yes.
So after carrying out the necessary corrections in the judgment and degree, but you have filed a section 152 at this stage.
Yes, Lord,
Yes,
that
filed
was
in the court
filed,
below.
Lord, in the court below.
The court below is that fine.
No, that has been filed.
No. At this, what is the correction?
Paragraph number 4. Page 16. This is the only correction, Lord, that's required. And because of that, Lord, the execution also is stalled.
Verification of the said execution. Oh, your plaint carries the correct name.
Yes. It's only the incorrect, Lord. That's why the execution is also stalled.
I will not show the correction that is required in this court. Because of this, it took 8 months to get those papers back in the High Court, Milord. And I am stuck with the second appeal where I am raising a question of jurisdiction of the first court, Milord. The valuation of, kindly see the valuation of the suit. Kindly see the valuation of the suit and Milord, how they have and where they have filed it.
This
It has been passed. So that's the point I'm taking.
2G suit. It has to be filed.
Yes,
in
how
city
they have
civil court.
filed and what is the valuation
So
of the
this
suit.
is an application of the respondent, plaintiff's respondent.
Yes, madam.
Can 2 of 2025 has been filed by the plaintiff in an appeal filed against an eviction decree. Full stop. In connection with the eviction decree, comma, an order of stay of execution of the decree was passed, conditional upon certain payments, certain occupation charges being paid, conditional upon occupation charges being paid at the rate of rupees 33,000 per month. Full stop. Next para, learned counsel for the appellant.
30,000.
No, not 33.
No, it will be 30,000.
30,000 per month. So it is submitted by learned counsel for the plaintiff stroke respondents stroke petitioners that the appellant has failed to comply with such direction of payment and has stopped making such payments. Full stop. It is pointed out that in terms of the order of stay dated November 19, 2024, comma, in case of default in payment of the said occupation charges, comma,
Para 17, Milord, page.
the order of stay would stand automatically vacated without further reference to the court, and it would be open to the respondents stroke decree holders to levy execution in respect of the impugned eviction decree. Full stop. Learned counsel appearing for the appellant submits that although initially payments were made, comma, subsequently some of the installments could not be paid. Full stop. It is further submitted that such payments have been rendered onerous, ONEROUS, onerous due to long pendency of the appeal. Full stop. It is further submitted that if the trial court's judgment and decree are sent down for correction, comma, it would take longer time to dispose of the appeal, comma, thereby putting the appellant to the undue hardship, Full stop. Next para. Be that as it may, comma, we find that the present plaintiff stroke respondents have made an application under section 152 of the Code of Civil Procedure in the in the trial court, seeking a rectification of the judgment and decree of the trial court to the extent that the father's name of plaintiff numbers 4 and 5 was not written correctly in accordance with the plaint. Full stop. Next para. It is also pointed out by learned counsel for the appellant that certain other corrections to the said judgment and decree are also required to be effected in terms of the office report of this court. Full stop. Next para. In such view of the matter, comma, since in any event there is no subsisting stay due to non-payment of occupation charges in terms of the order of this court by the appellant, comma, there cannot be any impediment for sending down the judgment and decree of the trial court for the limited purpose of correction. Full stop. Accordingly, can 2 of 2025 is allowed, comma, thereby directing the judgment and decree of the trial court to be sent down to the said court for effecting necessary corrections in terms of the office report of this court, as well as in terms of the application under section 152 of the Code of Civil Procedure filed by the plaintiff stroke respondents. Full stop. Such corrections shall be effected at the earliest, and the records shall thereafter, and the judgment and decree shall thereafter be sent back to this court. Full stop. It is expected that the entire exercise shall be concluded within a period of 2 months, 2 working months from date. Full stop. Next para. Any other direction is not required.
No,
Paperbook
direction of
directions
the-
and all were there.
There, but I
Not
can't
all
make
with
the, it is final. It is not being finalized by the department because of this with these records. Milord.
Corrections in any event then have to be correct.
Yes, sir.
Yes.
Obliged.
Grateful. Milord.
Thank you. Next.
Item number 31, my lord, Mr. Mayuk Nandi was to be appearing for
Mr.
this.
Mayuk
Mayuk
Nandi,
Nandi
yes.
was to be appearing for this matter, my lord, but he's suffering from fever. I'm just seeking for 1 week's accommodation.
Defects have been removed. You don't have it.
On the last occasion, Lordship directed to file copies of plaint and miscellaneous case that they had been
Suffering from fever, what can we do? Will not come to court then. Have to make an exception. On the prayer of the appellant,
may it be taken upon 3rd, Milord. I have a personal difficulty out of time, Milord.
on the prayer of the appellant, on the ground of ailment of learned counsel for the appellant, comma, let the matter stand over till December 3, 2025, when it will be listed under the same.
I'm grateful. Lord.
Great.
Please give your name only, not Mr. Nundi's name. Yes.
Lord, in item number 32, Milord, Mr. Kaushik is appearing for the respondents. I'm seeking a 10 minutes pass over, Milord. He's on his legs.
10-minute quota is already over. We'll call another matter in 10 minutes. So not
Your
this
lordship,
matter.
if your lordship kindly takes your lordship's last order,
Yes.
dated 7th of July 2025. There was a direction upon the appellants to file the paper book within 8 weeks.
They are the
period.
appellants.
No, we are the appellant. Your
All right.
Within
Within
8 weeks from the time of notice of arrival of the records of the that notice we have received on 21st, your lordship. And in the
This
interim,
month.
this month
So you have 8 weeks.
we have 8 weeks. So I'm praying for an accommodation so that we can comply with the earlier stipulation.
What is
and
this
file the paperwork.
application for?
Application.
Lord, CAN 2 is the stay application which they have filed,
Yes, and we are
and
filing
CAN
affidavit
5 is
in-
our application.
For? The application was not disposed of previously.
No, CAN 2, we are enjoying an interim order that is on board, and CAN 5 is a new application, I'm told, filed by the respondent for return of shares which are the subject matter of this appeal. So that perhaps would require us to file our set of affidavits in our affidavit in opposition to that. Because the entire subject matter of the appeal is these shares. Our contention is the direction by the trial court, the ultimate judgment, included certain shares which were not originally part of the schedule
It
of
was
shares.
your suit.
It was the suit by the respondent.
They claimed right title to the shares.
Absolutely. They claimed return of shares and some damages on account of differential price for not following their instruction in selling the shares.
Yes.
Now, we found from the records, and that was the basis on which we obtained the interim order before your lordship.
Your bank shares.
Bank shares. I'm the bank. And it was pledged with us. Now, we find that in the suit, the schedule of shares, which was mentioned in the original plaint, that was amended subsequently. And in the amendment, by way of amendment, certain additional shares were included. And this was never noticed. And I ultimately suffered a judgment in respect of shares which was never part of the original schedule.
But if there was an amendment of plaint, you should be aware of that.
No, we were never told. There was an ex parte proceeding.
Amendment application must have been allowed.
Amendment application was allowed. And
But
I
you
was not
did not
represented at that point of time.
So what can be done? It's a part of the record.
No, amendment application was allowed, your lordship. I will show when the matter is taken up on merits. Amendment application was allowed on mere formality. That is a formal amendment. I'm changing the actual
You must have
amendment
been given
application.
notice of that.
Yes, subsequently. Because
you knew that
I was not represented thereafter in the suit.
No, you are not given an opportunity to file additional written statement to that.
No, your lordship. No. In those circumstances,
there is no scope of filing any affidavit in opposition. Yes, this will grant the final relief in this suit.
My lord, this application has been filed.
Hand over the shares of the fiduciaries.
My lord, if we, my lord,
Have you put the decree into execution?
It has been.
That has been stayed.
That has been
So
stayed.
this virtually takes away the effect of that stay order.
Lord, what has happened, if Milord kindly takes up page 21 of the application, there has been in a letter as well as in an email, what the bank has said, Milord, at page 22, that the bank is willing to hand over the shares to my client without prejudicial basis, offered payment of 1 crore towards the remaining shares that have been deposited by your clients, for which our client has records. They themselves want to, without prejudice to the rights of.
So you are agreeable to pay that 1 crore?
This was in course of a mediation, in course of a settlement process.
That is cannot be taken note of.
And in course of the
mediation PAs.
Absolutely.
What are you saying? Mediation proceeding communication cannot be taken note of even in a court of law or anywhere. It's not binding on the parties at all. Mediation failed.
Mediation failed, your lordship.
Mediation proceeding records cannot.
So without prejudice proceeding.
We cannot look into that. Mediation proceedings is on a different footing. No, we'll reject this application right now.
My lord, kindly gives me 10 minutes passover. My lord, let me.
No, not passover. We'll give you 10 minutes to argue the matter. Not for passover. No passover business. Unless in the meantime, Mr. Dev falls sick and goes home, there's no chance of passover. We hope and pray that he does not.
My lord, we are only praying this because since they are agreeable to the fact that they want, without prejudice to their rights, they want.
No. This is during the course of mediation, we cannot take note of that. It is well settled. And that is the purpose of a mediation. I mean, you can open up, and sometimes these are private things. I mean, This communication should not
It's
even be used in a
confidential
court of law.
and
Should be
without
confidential.
prejudice.
No, this was communicated to them. So confidential, not in that sense.
Not in that sense.
Cannot be
Vis-a-vis
used in a
inter
court.
partes, but
Cannot
it
be
is
used in-
without prejudice.
Mediation proceeding, no communication can be used in a court of law. No right is created. Sorry, we are rejecting this application. The present application bearing CAN 5 of 2025 has been filed by the respondent. Respondent numbers 1 and 2.
Yes, respondents.
Only by the respondents seeking for a direction on the appellant bank to hand over the shares of the petitioners stroke respondents stroke petitioners which are available with the appellants as per their communications dated February 12, 2025 and May 28, 2025 respectively, without prejudice to the rights and contentions of the respondent stroke petitioners in the pending litigations. So next para, learned counsel for the respondents submits that by two communications referred to above, comma, the appellant bank had agreed in principle to hand over such shares to the respondents subject to a payment being made by the respondents. However, comma, it is rightly pointed out by learned counsel for the appellant that it will be evident from the communications themselves that those were correspondences made during a mediation proceeding and as such cannot be taken note of. Full stop. We fully agree with the contention of the appellants inasmuch as no correspondence stroke communication stroke interaction which has taken place between the parties during a mediation proceeding can be used in any court of law or can be even treated to be binding against the parties and or entitle any of the parties to claim an equity or right on the basis of such correspondences, etc. Full stop. Next para, as such, comma, the emails, the communication, the correspondence relied on by the respondents petitioners in support of the present application are cannot at all be a basis for grant of any relief in a court of law. Full stop. Moreover, comma, we cannot be unmindful of the fact that if the shares in question are directed to be handed over at this stage, comma, such direction shall be diametrically contrary to the stay order which has already been passed in respect of the subject matter of the lease, comma, which are the shares themselves. Full stop. Accordingly, CAN 5 of 2025 is dismissed on contest without any orders to cost. Full stop. Next para. CAN 2 is the stay application. CAN 2 of 2025 is disposed of by extending the stay order granted earlier till disposal of the appeal. Full stop. Since we are apprised by learned counsel for the appellant that Mr. Banerjee is in court.
Mr. Banerjee,
Mr. Ratnakar Banerjee will.
I'll have to obtain instruction. Your
Only
Lordship.
your names will be recorded. Yes, your names. Learned counsel, apprised by learned counsel for the appellant that the trial court records have already arrived and notice thereof has already been served on the learned advocate for the appellant, comma. We reiterate our direction on the appellant to prepare the paper books within 8 weeks from the date of such service of notice. Full stop. This much. Liberty to the parties to mention the matter for enlistment as and when the appeal is ready for hearing.
Only one thing, my lord, since I am suffering from Parkinson, may it be expedited, lordship.
We have already passed directions.
If it can be given some preference, lordship, because I tell you, lordship,
Let the paper books be ready. We have given you liberty to mention when the appeal is ready for hearing. When we will say no, but we have granted you the liberty.
May I hand up the affidavit in reply in CAN 2 for the.
CAN 2, any opposition was filed?
Yes, it was filed.
It was filed previously.
It was filed.
Or you are filing? Yes or no?
Yes, we have filed, man.
Then what are you searching for?
I'm handing up the reply.
Wait,
we have already served upon them. Maybe filed, man.
প্রথম লাইনে একটা করে affidavits in opposition and reply in respect of CAN 2 of 2025 filed today in court be kept on roll.
Very well. I'm deeply obliged.
There is a difference, Mr. Dey, between filed and served copy. There is a difference between sent and served. You know that better than many people.
No doubt.
Yes.
I'm grateful to you. Lord.
Pass over. 10 feet pass over.
As per item number 29.
The matter was passed over at the first call since an adjournment, since a prayer for adjournment was made on behalf of the appellant.
I'm for the appellant led by Mr. Supratim Dhar, learned senior.
Move it. Move the application.
My lord, I would like to place my objection, file my opposition against the application. My lord.
Refused. No scope.
File the
What is the application for? Please repeat
their
for him.
application, my lord.
Order.
What is the appropriate order? Repeat for him.
Appropriate, your lordship was pleased to direct to deposit the entire amount. My lord, 38,000 execution was filed, claiming 38 lakhs. My lord, in spite of that, my lord, they have
Come to this CAN application. The application. No, there's nothing called CAN application. Come to the application, page 24, 23, 24.
23, 20.
Please come there. Now, this is the entire decretal amount, enhanced amount, which we directed according to them,
According to them.
which we directed to pay as a condition of the stay. If you don't pay, stay will get vacated. They say they have not, you have not paid, so it has been.
My lord, they have deposited only 6 lakhs. Your lordship.
My lord. My lord, as per my instruction, the entire deposit has been made in accordance with the trial court's order, my lord. My lord, what is the difference they have done? My lord, kindly see the point number C.
Yes.
Along with solatium 30% per annum. My lord, this is not permissible under the law. My lord, it should be on the entire amount 30%.
We'll direct you to file affidavit.
My lord, yes.
Okay. You earned the right to file affidavit now. The present application is for within double inverted appropriate orders. Full-stop learned counsel for the respondent stroke petitioner submits that in view of the failure of the appellant's state to deposit the amount which was fixed by this court as condition for grant of stay, comma, the stay order ought to be vacated. Full-stop next para, learned counsel for the petitioner relies on the execution application filed by the respondent stroke petitioner, which is annexed to the present application, to submit that the total decretal amount is rupees 38,62,491 oblique dash. For the next para, learned counsel also hands over a copy of a challan indicating that only an amount of rupees 6,34,584 has been deposited by the state. For the next para, learned counsel appearing for the state opposes such contention and submits that the amount indicated in the execution petition is inflated and beyond the quantum which was directed by the referral court. For sub next para, accordingly, comma, on the prayer of learned counsel for the appellant stroke opposite party, we direct the appellant stroke opposite party state to file its affidavit in opposition to CAN 3 of 2025 within a fortnight from date. Full stop. Reply, if any, shall be filed within 3 days therefrom. The matter shall next be listed on December 16, 2025 under the same heading. Just disclose all your whatever you have. Give them in advance so that they can prepare a reply. We have given them only 3 days.
Thank you.
For the economy. I'm for the respondent number 1 to 3.
Yes, Mr. Ghosh. Mr. Bhattacharya for the
appellant. Kindly see your lordship's order dated 6th of February 2025. Your lordship had recorded a detailed order.
We hate these things to go through our orders again. So everything was dispensed with. What is the
yes, no, the factual aspect, if you're my lord, this is my lord, I'm challenging the defendant number 3 and 4 is the appellant before your lordship. Now,
yes, the present appellant you give us half a minute.
Yes, yes.
Yes, Mr. Ghosh, what do you say to this? We have recorded sufficiently.
My
But
lord, I like to say the three things. My lord, the documents
yes,
which were relied by me with my 3912 application and also the print. But that was not disclosed with your lordship's petition. Well, kindly allow me to file an opposition.
very well.
Because certain lordship, the record of rights are required to be.
On the prayer of learned counsel,
this is there, part of it.
আমাদের ধরে আমাদের just relied.
Record of right.
you must be for the plaintiffs responsibility.
Yes.
Acha, the defendants, other defendants, should we dismiss with service on?
We have served, my lord, affidavit of services. my lord.
All. Despite service, none appears for the. Addition,
4 to 26.
Very well. For the respondent numbers 4 to 26, push up. However, the primary contesting respondents, that is the respondent numbers 1 to 3, are represented through counsel. Push up. Learned counsel for the appellants relies on the observations made by this court in the order dated February 6, 2025, admitting the appeal, and contends that a strong prima facie case has been made out in the appeal, and as such, an order of stay ought to be granted. Push up next para, learned counsel for the plaintiff's respondent numbers 1 to 3 submits that there are several documents which were produced by the plaintiff's respondents in the trial court which have not been disclosed before this court. Push up. Accordingly, on the prayer of the plaintiff stroke respondent numbers 1 to 3, the said respondents are directed to file their affidavit in opposition, annexing all relevant documents which are placed in the which are part of the trial court records at the relevant juncture, within 1 week, Mr. Ghosh. Within a week from date, push up. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing on December 15, 2025.
Much
Application.
May please, your lordship.
Yes.
For the petition. Last question, lordship, heard the matter, my lord. For divorce filed in the year 2011, my lord, and marriage was solemnized July 2010. And my lord, husband filed this suit on the ground of nullity. Wife appeared contested by filing written statement, my lord. And my lord, 2023 March, my lord, case was transferred from first ADJ to second ADJ. That was not within the knowledge of the learned advocate. As a result, my lord, ex parte judgment was delivered, my lord. And it
There's
is
section 5 also.
Section 5 application, my lord, wrongly. And then one thing, my lord, one thing, my lord, in my application, wrongly I calculated the delay 204 days, but actually it is 175 days.
You have extended more than.
No, 175 days. What I mentioned in my application, 204 days.
What was the reason?
My lord,
Whatever you said before us just now. That was the reason for that you missed out the transfer of the suit.
Yes, my lord.
Administrative transfer to some other court.
From first court to second court. And my lord.
No, we have stated.
And my lord,
made some adverse comments. Let us see that.
And my lord, I served notice, my lord. Yes, my lord. Mr. Mondol appearing before the trial court, my lord, on behalf of the wife, my lord. I served.
Yes, against whom the allegations were made.
No, no allegation, my lord.
Yes,
my submission before in the application that it was not within the knowledge of the learned advocate. That is why ex parte judgment was delivered.
If he's here, we don't. We hope you have not set him up. He was actually there in the trial court.
Yes. Do you,
but they say that was my second brief.
In your practice life?
No. Yeah, in that match shoot in the trial court, filed on behalf of the wife filer. Thereafter,
No, during the relevant time, you were there.
Yes, my lord.
Yeah.
And
when these things happened, you were there.
Yeah.
Entire blame has been sorted cast, so you are there. That's taken care of. Source of knowledge of the dismissal of suit. What about that? Suddenly you came to know.
No, definitely came to know from the learned advocate. Well, that was
what
not
was the occasion for him? Because he did not know. So what happened on in November last week of
November? My client
with the large.
Yes, Mr. Sen, what about this? We'll go on this. Matrimonial suit.
Medical certificate. Doctor advised me to take rest for 8 weeks. This is the medical certificate.
Page?
Page 8, my lord. The medical certificate.
Doctor advised to take rest for 8 weeks.
Can do. For a medical certificate,
Can one.
has been obtained, my lord, only to get this order, my lord. This dated, my lord, 6th of January 2025. So far as the other wordings, my lord, if you find, my lord, the for 8 weeks, got certificate for 8 weeks from 4th January 2025.
Advised to take rest for
My lord,
8
January
weeks.
certificate is given after, my lord,
My lord.
it's cured, my lord.
No, he obtained the certificate for the purpose of the section. So
But predated, my
that
lord.
during that period.
But 6th it is issued, my lord.
Oh, okay.
Dated 6th of January.
Yes.
And my lord, advice rest for 8 weeks from 4th of January. Long period, my lord.
No, my lord, 4th January. 4th January.
2 days before.
4th January. After 2 days. After 2 days, certificate was issued. With the
Viral hepatitis.
from 4th
She
January.
was treated for viral hepatitis from
4th January.
4th of January.
And 6th January certificate
And
issued.
on 4th January, she was treated and she was checked up by this doctor and she was advised 8 weeks rest. So she obtained this certificate on 6th of January.
What is wrong?
In opposition, page 37 and 38, my lord.
But she was performing in the Olympics during that period.
My lord.
Well, nothing less will convince us to dismiss the application.
How medical certificate is to be issued, my lord, that is rules break down, my lord. Rule says, my lord, for such a long period, medical certificate cannot be issued. My lord, at least 4 weeks.
Not
after
long
4 weeks,
period.
they have
Not long
to
period.
re-examine,
My
my
lord.
lord. That is the order, my lord. We have annexed an order, my lord.
Which page?
Page 37, my lord, paragraph 2 of the affidavit in opposition.
What is this?
Well, medical certificate in question is not in conformity of rule regulation 1.33.
Prosecute the doctor for that. Prosecute the doctor. Heard learned counsel for the parties. Full stop. Next para. Learned counsel for the appellant wife submits that at the relevant juncture, comma, when the impugned ex parte decree of divorce was passed, comma, the learned advocate conducting the case in the trial court was unaware of the transfer of the suit from one court to another. Full stop. Next para. As such, comma, due to ignorance of such administrative transfer, comma, the appellant was not aware of the outcome of the suit. So subsequently, upon contacting the said learned advocate, comma, it came to light that the suit had been decreed ex parte in the meantime. For sub next para, in our order dated November 10, 2025, comma, we had recorded that since entire blame has been sought to be cast on the learned advocate appearing for the appellant in the trial court, comma, a notice ought to be given to the said learned advocate. Full stop. In fact, comma, the said learned advocate appears along with the learned advocate appearing for the appellant in this court today at the time of hearing and supports the contention made in the condonation application. First up, next para. We had also recorded in our order dated November 10, 2025 that the source of knowledge of the dismissal of the suit all on a sudden in the last week of November 2024 had not been disclosed. First up. However, comma, it is verbally submitted by learned counsel for the appellant that the occasion for such inquiry was that the appellant herself had met the learned advocate in the trial court and inquired about her matter. First up, next para. As such, comma, in view of the appearance of the learned advocate who was conducting the matter for the appellant at the relevant point of time, comma, we find the grounds for delay made out in the application being sufficiently credible. Moreover, comma, under normal circumstances, comma, unless malafidus can be attributed to the appellant, comma, a liberal view ought to be taken for condonation of delay. Full stop. Accordingly, Can 2 of 2025 is allowed on contest, thereby condoning the delay in preferring FAT 141 of 2025. Full stop. You have remarried, Mr. Shen, your client? Can 1 of 2025 is now taken up for hearing? Push up by the in the said application, comma, stay of operation of the impugned ex parte divorce decree has been prayed for. Push up next para. However, comma, since the impugned decree is a decree in the nature is in the nature of a decree in rem, comma, there might be larger ramifications, wider ramifications in the event the same is stayed altogether. Push up, however, comma, in order to save the appeal from being rendered infructuous, comma, we mold the reliefs sought in the application and pass an order of injunction restraining the respondent husband from contracting any remarriage during pendency of the appeal. Full stop, can 1 of 2025 is accordingly disposed of without any orders to cost. In view of the appearance of the respondent through his learned advocate, comma, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop, the appellant shall also prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you. Yes.
And I beg to appear on behalf of the plaintiff respondent.
I'm for the appellate dependent.
The service of notice returned.
Well, caveat is
you are appearing for the respondents.
I am appearing for the plaintiff.
Caveat is there.
The memo of appeal has not been served on me. My lord, the
What
stay
has not been
application-
served? Sorry.
Memo of appeal.
Memo of appeal.
No, memo of appeal also sub.
Anyway,
I have sub.
What is the impugned decree? Against what have you
My
prepared?
decree dated.
What is the nature of the decree? We just asked.
Recovery of possession and eviction.
Eviction of licensee?
No, section 2G.
No, my lord, it's not section 2G. It is actually against the trespasser. They were trespasser. They have encroached on my,
Trespassers.
they have encroached on my property from my adjacent property, and
Their
there was
predecessor was not your tenant.
they were not their tenant. Their predecessor, once upon a time, they were the tenant who has
Yes.
surrendered their
Once
tenancy.
upon a time,
They have surrendered their tenancy. Their grandfather was a tenant who surrendered the tenancy, who was over 30 square feet was been given to him. 11C, Ramana
Boils down to
Vishwas Lane.
occupation charges.
Occupational charges, there is Atmaram, but I'm just giving a brief background of the case. My lord, what has happened? My lord,
Grandfather surrendered.
surrendered.
Then what?
Oh no, my lord.
Then only there are
It's their case.
there are two.
But he's misstated.
It's stated in the decree itself. My lord, kindly go through the
My
decree
lord,
once. My lord will
My
understand.
grandfather died on 31st January 1997.
It was a case of a trespasser. Eviction
And he
for
surrendered in
trespass.
1998.
No, my lord, it was not surrendered. It was not surrendered by my father and my husband. My lord,
Not
originally,
totally confused. Your husband, father,
my lord, if your lordship will be pleased to take
not
the
going to this. You file a affidavit in opposition and you disclose the occupation charges and will pass
It's
an
a
order of stay.
900 square feet at Shialda.
No, you disclose in your affidavit in opposition so that we can have some material to pass. For the timing, we are granting unconditional stay, but then execution has been levied.
Execution has been levied. My
Title
lord, it is
execution
under
23.
process.
and it is 15th December is fixed.
No, we'll grant stay of that. The present appeal arises out of an eviction decree. Full stop, next para. Since questions of both fact and law are involved, we are of the opinion that unless the execution case levied pursuant to the impugned decree is stayed, comma, the appeal will be rendered infructuous. Full stop. Accordingly, there shall be stay of all further proceedings in title execution case number 23 of 2025 pending in the City Civil Court at Calcutta between the parties till disposal of the application. Full stop. Affidavit in opposition, if any, shall be filed by the plaintiff stroke respondent within Occupation charge, you have to disclose something.
My lord, within 2 weeks.
Within a fortnight from date, full stop, reply.
Even unconditional stay, my lord, occupational charge. If it
No,
is
no,
taken of
occupation charge,
50
if granted,
rupees,
will go back to the date of the decree.
from the date of the decree.
Try to understand what we are saying. In the meantime, let us pass the order.
Okay.
Within a fortnight from date, reply, if any, shall be filed. Within a week thereafter, the application shall be listed for hearing on December 22, 2025. Full stop. Next para, it is made clear that the question of imposition of occupation charges as a condition for grant of stay and the quantum thereof is kept open for being decided at the final hearing of the stay application. When we grant occupation charges, that will obviously be from the date of the decree. That is settled, you know that.
That is date of the decree.
So whenever we pass that today unconditional, tomorrow it will be conditional, that will relate back to that date.
But it
So in
is
that
a
period, he'll have to
decree against a trespasser, not the case what my learned senior field is actually trying to press your lordship.
22nd.
Application will come up.
Stay application.
On stay application will come up on 22nd.
On 20th, I am going to Bangalore for.
Well, we'll keep it before that. Then 22nd na kore 17, December 17. 17.
Please, your lord.
I'm grateful.
Thank you. Yes. Yes, Mr. Bhattacharya.
My lord, I am for the appellants. My lord, in terms of the lordship, I have served.
Plaintiff respondent.
Plaintiff respondent.
Section 5, I have prepared a affidavit in opposition.
1 and 2 both then. The opposition to section 5.
I have not received any copy.
You have not given a copy. You should have given a copy. It should have. All right. Affidavit in opposition filed by the plaintiff respondents against the application for condonation of delay today be kept on record. A copy thereof is served here and now on the learned advocate for the appellant. First up, the appellant shall file reply thereto within a week from date. The application shall next be listed for hearing on December 8, 2025. Affidavit of service filed today be also kept on.
My lord, instead of 8 million, any more. 9th million. My 8, I have some difficulty. Grateful, your lordship.
Much obligation.
Thanks.
দুটোই দিয়েছিস আমাদের দুটোই দিয়েছিস শুধু সেকশন 5
Item number 37.
37. Yes.
Your Lordship, I appear on behalf of the plaintiff appellant. In the
Service.
Your Lordship, the service has not been completed yet. I'm praying for a week's accommodation.
Very well. On the prayer of the appellant, since service has not yet been effected on the respondents, the matter is adjourned till December 2, 2025. Second December.
Grateful, Your Lordship.
Next.
Lord 38, my lord, I am appearing on behalf of the respondent.
I am
Yes, Mr. Gold.
My affidavit of service, my lord.
What is the matter about, Mr. Bodal?
Mr. This appeal arises out of a grant of probate, my lord. The appellants before my lord are the legal heirs of the son and the daughter. The appellant number 1 is the daughter, and the respondent number 2 to rest are the daughters, legal heirs of the deceased son.
And this respondent is someone else.
Respondent is a third party, my lord. Third party. Probate was the father of the respondent number 1 and the father-in-law of the father of the appellant number 1 and the father-in-law of the appellant number 2 and the grandfather of appellant numbers 3 to 5.
2 to 4 are the
legal heirs.
The
legal heirs of the deceased
wife
son.
and children of the
Deceased son of the deceased son of the
and
testator.
Asha Singh is the
Daughter.
Yes.
My lord, sir, past orders, my lord's orders are there in this matter, my lord.
The probate has been granted.
Probate has been granted, challenging the probate. This appeal has been filed.
Granted stay of operation.
My lord, stay of operation was eviction suit has been filed, my lord.
That has been stayed.
That has been stayed by the Justice Sen, my lord.
Justice Sen stayed there.
Yes, my lord.
We extended that or what?
Yes, my lord. My lord's order is that of 28th of April. My lord.
What is Can 5?
Can 5 is the stay application, my lord, of the eviction suit. My lord, my lord's
Can
order.
5, what are the previous applications?
The previous applications also has been disposed of, my lord. All has been disposed of. Leave to prefer an appeal, everything, appropriate order, paper.
Can 5, we did not pass any interim order.
My lord, that Can 5 was initially taken up by Justice Sen, my lord, wherein a limited stay was granted, and thereafter, my lord had passed an order on 18th of September 2025, my lord.
Oh. You got the order when the from Justice Chen when it had gone to that the
City Civil
determination-
Court.
No, the determination went to Justice Chen.
Justice Sen, my lord.
Justice Chen passed that order on 18th of September is Justice Chen's order.
Justice Sen's order, my lord.
What is that? Where is the stay?
My lord, the landed
What is the date of the stay order?
My lord, 18th.
শুনুন না এখানে না দেখুন এই কোর্টের অর্ডার
Well, 18th of September 2025. May I hand over the
18th of September. Which paragraph?
My last paragraph, the appellant shall enter appearance on the date fixed without prejudice to the rights and contentions, but no further proceedings shall take place without the leave of this court. Thereafter, my lord's order was there.
Where was our order?
My lord's order is that order dated. My lord's order.
Interim order, continue till disposal of the application. Yes, if you have the eviction degree in the meantime, then nothing will
We
be.
are the nephew niece. The registered will, the probate was.
No, on the merits will hear you, but if the eviction degree is passed in the meantime, nothing.
That we will proceed
Postal
with the
cost,
suit, we will
everything.
not, if the degree will pass, we will not proceed with the execution. That we are ready. As per, we will not proceed with the execution.
That is a
We will
fair.
not proceed with the execution.
That is.
I'm undertaking before.
No,
this
we'll pass an order.
Yes.
We'll pass an order to that.
We will not proceed
Let
with
the
the
suit be proceeded with, but no final degree will be drawn.
Yes.
Let that be the order. Participate there.
No, we are participating. We have participated. We have entered appearance.
We'll make it clear. We had granted stay. No, we had extended the interim order. Sorry.
My lord has extended the interim order.
And Justice Sen also said that he will appear there.
Yes.
Justice Sen,
But no further proceeding will
no
take.
further proceeding.
Without the leave of this court, we are disposing of the application. As he said, we'll permit them to proceed with the suit, but no final degree.
And the paper books, postal cost, everything has been paid off to bring down the lower court. LCR has arrived.
No, he's the only respondent, so
Only
he's appearing. LCR has arrived.
Yes, I have taken instructions that LCR.
So what? Then take notice and prepare the paper books.
Paper books we have taken.
Can 5 of 20? The present appeal arises out of the grant of probate in respect of a will executed purportedly by the predecessor in interest of the present appellants, whose learned counsel for the appellant submits that taking advantage of the probate decree and on the strength of the said probate, the respondent is proceeding with an eviction suit against the appellants. First up, it is
two different suits, eviction suits has been instituted.
Because
one is
there are
against
two-
Tasa Singh and the other is against the other respondents.
Ajay,
There are two suits.
two eviction suits. যেখানে বললাম eviction suit, সেখানে two eviction suits. So next para, it is pointed out that by an order dated September 18, 2025, a coordinate bench of this court had observed that the appellants shall enter appearance on the date fixed in the said suits without prejudice to the rights and contentions, but no further proceeding shall take place without the leave of this court. Such interim order has subsequently been extended with a order dated October 28, 2025. Next para. Upon hearing learned counsel for the parties, we are of the opinion that since, in the event the said two eviction suits culminate in decrees, in the meantime, the present appeal will be rendered infructuous. However, there is substance in the contention of learned counsel for the respondent that the entire proceedings of the said eviction suits need not be stalled, but no final decree may be passed in respect of the said suits prior to disposal of the present appeal. Accordingly, can 5 of 2025 is disposed of with the observation that it will be open to the parties to participate in the two separate eviction suits instituted by the respondent against the appellants on the strength of the probate which is under challenge in the present appeal. However, no final decree shall be passed in either of the said suits without the leave of this court. The above orders shall continue till the disposal of the present appeal. Since directions regarding paper books have already been passed, you have already passed.
My lord.
And dispensation of service you have also.
Yes, my lord, if my lord takes up the my lord's order dated 20th of May 2025, my lord. The last portion, last page, page 5, my lord. And at that relevant point of time, they were the
No,
respondent.
they had not appeared. So
They
that
had not appeared. I have
since relevant directions regarding paperbooks have already been given, comma, no further order need be passed to that effect. Full stop. Next para. In view of the appearance of the respondent through his learned advocate, comma, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards service. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Affidavit of service filed to the paper.
No, kindly come to the order dated 20th May 2025. Now, in respect of Can 2 of 24, my lord has passed order directed me to file the statements of account time to time. Well, I have obtained that order from the website, but I will take instruction that has not been filed. Now, kindly extend the same. I will file the statement of account. There was a direction, my lord.
Very well.
I will file.
Extension till when? I mean, we cannot indefinitely.
No, kindly give me at least 15
You have
days
not filed
time.
any of these?
No, because on the instruction, when we get the notice of the Can 5, when we got the knowledge that the
everything was
appeal was
served, my
filed.
lord. Everything was
Yes,
served.
but my lord, I will file, my lord. Kindly give me 15 days time. I will file up to
Property
date.
is entirely
This
tenant.
was long back.
Yes, my lord. But my lord, we got
May
the knowledge.
2020.
Wait. Yes.
We got the knowledge when we received the copy of the appeal Can 5.
When was that?
Can 5, my lord, we have received. Sir, my lord,
The
we
previous
did not-
applications were also served.
but my lord, we did not receive, my lord. On instruction, I am saying, my lord, and my lord, in the order also it has been
So on the
mentioned.
prayer of learned counsel for the respondent, comma, the timeline for filing of quarterly statements of accounts, comma, as observed in the order dated May 20, 2025 by this court, comma, is extended full stop accordingly, comma, the first of such quarterly statement of accounts shall be filed by December 15, 2025, and thereafter each quarter as per the order dated May 20, 2025.
I'm grateful.
Thank you.
Thank you. Grateful.
Yes, thank you.
39, my lord, I'm prepared.
Yes, Mr. Banerjee.
But copy has been served, my lord. There was a caveat.
My lord, Mr. Aniruddha Chatterjee appearing in this matter, he left the court today. Your lordship kindly accommodate for the day.
His choice, he left the court. What can we do?
As per resolution, I believe he has left the court.
We are not bound. Sorry. Yes, what is the matter about?
But I'm praying for, my lord, a stay of the execution proceeding in an eviction suit.
The appeal arises out of?
My lord, out of an eviction decree. My lord, the moot point is, my lord, that there was an agreement with, my lord, the original tenant and, my lord, the landlord and the original tenant, whereby in 1980, executed in 1980. Thereby, my lord, the legal heirs of the original tenant were supposed to be, my lord, it was, my lord, heritable, the tenancy right. Now, my lord, the original tenant died in 2010. The learned court held that since 2G has come into effect after 1998, therefore that clause in the agreement goes.
Clause was that heirs will be included.
Heirs will be included in the tenant. The tenants will be heritable. Well, kindly cease, my lord.
So was the finding. Agreement clause. Yes, page 11.
Lordship is looking
para
at
21. Judgment.
Yes.
Tell page 11, para 21.
One page?
No, but in terms of the agreement, the user of the tenancy has been restricted to the residential purpose of the tenant and the members of his family. Described in clause 6 of the said agreement. You don't come within them. Only to those heirs, it was restricted only to those members of the family.
We are the heirs. We come, my lord. We are the heirs, my lord. We are the sons and daughters right now. The learned
But
court,
you have to pay occupation charges.
occupation
Direct
charge.
affidavit
Yes,
in
yes.
occupation.
Let the mallet file an affidavit.
The present appeal arises out of an eviction decree, full stop, unless execution has been levied.
Execution has been levied. What next date cover?
Execution.
Mallet police mallet. So I didn't know. Mallet, I don't. I'm not carrying the order. But mallet, my
Even case number you have not given. You know the
mallet,
case
at
number.
that point of time, it was not
idea
levied,
about
mallet.
execution.
When the
I will have to take instruction about the execution.
police help order আছে।
Unless stay as prayed for is granted, comma, যেখান থেকে ছাড়লাম ওখান থেকে is granted, comma, the appeal is at the risk of being rendered infructuous. Full stop. Accordingly, there shall be stay of operation of the impugned decree as well as all further proceedings in any execution case levied in connection therewith, levied pursuant thereto, till disposal of the application. Full stop. The respondent shall file affidavit in opposition to Can 1 of 2025 within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall next be listed on December 22, 2025. Full stop. It is made clear that the question of imposition of occupation charges and the quantum thereof is kept open for being decided finally at the hearing of the stay application. Question of occupation charge kept open. You please disclose whatever materials you have so that they can also controvert. And when we impose, it will be from the date of the
From the
usual
that date.
Ataram.
Grateful, mallet.
It will be Khaja Chara when you take up the.
Mallet, Karnani properties, mallet. Recently, the Honorable Supreme Court held, mallet, that mallet, even after, if it is not, mallet, retrospective, mallet, my right, mallet, according to the tenancy cannot go. Mallet, that agreement cannot go.
You have a very good point in the appeal.
Mallet, grateful.
Very arguable point.
Item number 40.
Yes. Application for expeditious hearing. Allow করতে তো dismiss করা যায় না। None appears at the time of call, full stop. In view of the innocuous nature of the prayer made in the application, comma, we take up the same for disposal in the absence of the parties. Can 1 of 2025 is accordingly allowed, comma, thereby directing the appellant to put. You are appearing?
No, item 14.
Next. Directing the appellant to put in postal costs and other requisites for service of notice of the appeal on the respondent within a fortnight from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week, within a fortnight from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for hearing as an appeal for enlistment as and when the same is ready for hearing. Can 1 of 2025 dispose of policy? No address to cost. Thank you.
Item number 41.
May please your lordship, I am appearing
Yes.
for the appellant.
Yes.
My lord, here plaintiffs are the appellant before your lordships. This is my affidavit of service. On the last occasion, your lordships directed me to serve the copies upon the respondent.
Since nobody is appearing
Service is
today, you have a
defective.
resolution, we think I should.
Great.
Because if somebody appeared, you would have passed an order. Affidavit of service filed today be kept on record, full stop. However, comma, none appears for the respondents at the time of call. Full stop. As a last chance to the respondents to appear and contest the applications, the matter is adjourned for the day.
Great.
If you know who is appearing, intimate.
I don't know what to do. I'm for the applicant, my lord. As per your lordship direction, my lord, I have served the reply on the yesterday, my lord.
My lord, yesterday, my lord, at 3 p.m., my lord, the copy has been served. My lord, the copy of the reply.
You got more than 24 hours.
My lord, the
24 hours, 57 minutes.
In this matter, my lord, the Mr. Uttiyo Roy is.
Sir?
I am led by Mr. Uttiyo Roy, my lord, and my
If
lord.
he is not there, you move the matter. What can be done?
My lord, upon instruction, my lord, I am praying for my lord, no, only not today, my lord.
No. We are only refusing it.
No, my lord, only not today, my lord. If you not.
We are only refusing it. What is the matter about?
My lord, the challenging the degree passed in the additional session judge, my lord, Kagdi, my lord. Before,
What sort of a degree?
my lord, order dated, my lord, 3rd May 2024, my lord.
What is the suit for? What was the suit?
Matrimonial suit, my lord.
Divorce degree has been passed.
Divorce degree has been
Have
passed.
you remarried?
No, my lord.
This is for stay.
No, Mr. my lord, your lordship last occasion on 15th September granted the injunction. My lord,
Remaining.
that's why my lord, they are on the opposition.
Condonation of delay was allowed.
My lord, allow. No, within time I have filed, my lord. Appeal has filed within time.
Oh, there is the, acha, can one, that is the
My
claim.
lord.
You have to file an opposition.
Yes, sir, I have already filed, my lord. And the copy has been served, my lord.
Yes, filed on the last day.
Okay, my lord.
You have filed a reply to that?
Yes, my
Yes,
lord.
my lord, I have
Last day-
filed.
Last day it has been served
Very
upon.
well. Upon hearing learned counsel for the parties, comma, it transpires that the present appeal arises against a decree, arises out of a decree of divorce obtained by the respondent husband. Full stop. Unless the
Respondent wife.
oh sorry,
My lord.
obtained by the respondent wife. Thank you. Respondent wife. Full stop. Unless the respondent is restrained by an order of injunction from remarrying, comma, the appeal will be rendered infructuous. Full stop. Accordingly, can 1 of 2024 is allowed on contest, comma, thereby granting injunction restraining the respondent wife from contracting any remarriage during pendency of the appeal. Full stop. We have passed directions for special messenger cost and all. We have already
My lord,
passed.
deposited, my lord.
Paper book also we have directed.
My lord, deposit.
Very well. Liberty to the parties to mention the appeal as and when the same is ready for hearing.
Grateful, lordship.
Thank you.
My lord, in item number 43, my lord, I am not there in the matter upon Mr. Deepak Ranjan Mukherjee is appearing for the appellant. He's
Not from your
well.
chamber.
It is not from my chamber, my lord. He's not well. That's why he's.
Yes, order record করতে হবে না, not free.
Wait, my lord.
Item number 44, 45.
But I appeal for the respondent.
But I am appearing for the plaintiff appellant
Yes.
in a suit for declaration of tenancy right in respect of a premises. That suit was heard along with another suit filed by the defendant, my lord, claiming that we are trespassers. Both the suit heard analogously. Court held that I am a tenant. My husband was a tenant. But I am not the dependent of the widow as not dependent in view of the fact that my son deposed before the court that my husband was penniless at the time of her death. At the time of his.
Penniless, so what?
But not
Therefore,
only that,
I am not dependent.
Oh, acha.
Widow is not dependent. On the at the time of death,
Your source of income was shown.
I was all along dependent upon him.
No. Have they proved your source of income?
No.
but in the cross-examination, my lord, it has come out that the son is maintaining the mother, the appellant before your lordship. It has come out in the
On the
cross-examination.
But still, she was the
Widow, my lord, but she
she
doesn't.
was a dependent of her husband at the time of the husband's death. That
But
is the relevant
it is
point.
also it has also come out, my lord,
At
that
that
he
point of time, he was
was
maintaining.
penniless. It has come out, and not only that, my
My
lord,
lord, on
there
the,
is not
at
one
the
line,
time of
but there
death,
is not one line avowment in the plaint that the appellant was residing with the husband. Not one. The trial court has held that also, my lord. Not one line avowment in the plaint.
That is a presumption in a marriage unless you show that there was a strained relation or something like that.
Right.
my lord, all along, my lord, this was
dependency,
If there was a single line of evidence regarding the relationship in being strained or something, they being separated, we could have understood.
that, my lord, is not there. But my lord, this dependency, my
But we
lord,
are not expressing our opinion on the merits
but
of
this
the appeal.
penniless thing, my lord, and the fact that she was dependent, the son was maintaining the mother, that has come out in cross. I'm carrying that, my lord. I'm carrying
Son's ego has killed her. That he maintained his
those
mother.
things. have
only
come out.
one line, my lord, on the basis of cross.
But if I
So we
may,
consider that. But what is the application for now?
The application one for injunction, my lord, restraining them from executing the decree where I have held, and my lord, another application for analogous hearing of both the appeals. And my lord, so far as the second appeal is concerned, there is a delay of 3 days. And
that your lordship
putting-
has condoned on the last occasion, my lord.
my lord, perhaps
Let us check up just. You have not put in Taliban and written up notice form, but there you are appealing for the
respondent, my lord, just one respondent.
one.
So far as second appeal is.
Yes, you are right.
It has been gone down on the last occasion, my lord.
Therefore, my lord, both the appeal be heard and my lord.
We directed the appeal to be listed along with can 1 of
Can 1
can 2. What are those applications? 1 and 2?
But one
One
is for
and two
injunction and one is for analogous hearing of both.
of both the appeals. Since arising out of the same judgment and decree, my lord.
But only thing is, my lord, if your lordship is considering staying of the decree, but only considers one thing. 330 square feet area, my lord, in Taltola area, 60 rupees is being paid, my lord.
Your son is also a party?
Son, my lord, for the present.
Yes, he is a pro forma respondent, my lord.
My lord, 5 years have already lapsed, therefore we have not been maintained.
No. The son is not his pro forma respondent number 2. My lord, kindly
My lord,
see
for the present, my lord, suit was filed by both the son and the mother.
Therefore, the son has not preferred the appeal because he will not get it. That's obvious. But then the son can pay the occupation charges. That was what
He
we
considers only
considering.
that.
If he
60
boldly
rupees.
says in the statement and demolishes his case by saying, I am maintaining my mother and taking
I'm
pride
sure,
in
my
that,
lord, he can.
he should
He
pay the
can, of
occupation
course. Yes,
charges.
your lordship. He can pay, my lord.
He has to pay the occupation. So we'll direct you to file your affidavit in opposition to the application so that we can ascertain the occupation charges. And we'll restrain you from executing the decree in the meantime. When we impose occupation charges, that will be from the date of the decree. The other application, Mr. Mitra, I'm sorry, I missed out. The other application is for?
Analogous hearing of both the appeals.
That we are allowing. Which can is which? Can 2 is for analogous?
Can 2 is for analogous.
Can 2 of 2025 is an application for analogous hearing of the 2 appeals. Next para, since the appeals arise respectively out of a decree passed in a suit for eviction filed by the respondents, and the other appeal arises out of the dismissal of a suit for declaration of tenancy rights filed by the appellant, for the sake of judicial propriety and in order to avoid conflict of decisions, it would only be just and appropriate for the 2 appeals to be heard analogously. Accordingly, can 2 of 2025 is allowed, thereby directing FAT 275 of 2025 to be heard analogously with FAT 294 of 2025. In view of the appearance of the respondent through plaintiff in view of the appearance of the contesting respondent through learned advocate, service of notice of the appeal on the said respondent is dispensed with, since the pro forma respondent was a co-plaintiff with the present appellant in her suit, service of notice on the said pro forma respondent is also dispensed with. Next para, accordingly, the appeal is to be treated to be ready as regards service. You put in the special messenger costs. Otherwise, they will delay again. Paper books will you prepare or they will prepare? Whatever you say.
We will prepare, my lord, because
I think that will be because it's an
expediting the
Otherwise,
process.
again, he will have to come back.
But we will prepare, my lord.
Mr. Mitra, it's doubtful whether he will get his fees. So,
My lord will pass that direction.
on the prayer of the learned advocate for the respondent, the respondent is in both the appeals is directed to put in special messenger cost for bringing the trial court records within a week from date. The the respondents shall also prepare and file the requisite number of composite paper books for both the appeals within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the respondent. For such purpose, the office shall serve a notice of arrival of such records both on the learned advocate for the appellant as well as the learned advocate for the respondent. Next para, the respondent shall file affidavit in opposition to can 1 of 2025 within a fortnight from date. Reply, if any, shall be filed within 1 week thereafter. The application shall be listed for hearing on December 22, 2025. It is made clear that the question of occupation charges, imposition of occupation charges and the quantum thereof as a condition for grant of stay stroke injunction is kept open for being decided at the time of final hearing of the appeal. There shall be stay of all further proceedings, stay of operation of the impugned eviction decree as well as the connected execution proceeding, comma, if levied, comma, till disposal of the application.
Great.
আচ্ছা এফএটি বাবু এফএটি 453 যেটা বললাম ওটা থাকবে ওই অ্যানালগাস লিডটা আর একটা যেটা বলেছি সেটা এফএ 320 অফ 2025 হয়ে ও দুটোতেই এফএ হয়ে গেছে সরি তাহলে যেখানটা দুটো এফএটি নাম্বার বলেছি একটু নাম্বারটা বলে দিচ্ছি এফএ নাম্বার 320 অফ 2025 to be heard analogously along with FA number 453 of 2025 ঠিক আছে একটু তাহলে ফাইলটা চেক করে
Great.
থ্যাঙ্কস
Number 46.
বাড়াতেই হবে ছেলে বড় গেলে ক্লেম করে মাকে হারিয়ে দিয়েছে বলে কি জানিস বিগ পয়সা
I'm for the
apparent respondent.
respondent, my lord. I praying only not today, my lord, because Mr. Saha is my leader. Almost
You are there.
my lord, the
No.
due to full court, he left the court. That's why.
No, left the court, that's your choice. If you was in court and left the court due to not to attend, we are unable to help you. Yes.
That's why I praying,
this,
lord, only
this is
not
an
today.
appeal, my lord, against by preliminary decree, my lord. The suit for partition and declaration, my lord.
We'll pass usual order.
My lord.
It will continue and
Well,
can the present appeal arises out of a
suit-
preliminary
my-
decree of
my-
partition.
Yes, my lord.
My usual order means, my lord, the suit will
That the appeal is allowed. Usual order is that the appeal is being allowed.
allowed. The suit will be proceed, my lord.
No, the appeal is being allowed. We are setting aside the impugned degree. That is the usual order in this court.
But my
The
prayer
present
is, my lord,
appeal has been preferred against a preliminary. Hey, Babu,
Hearing
order
করছে, কিছু করছে না, কেন?
The present appeal has been preferred against a preliminary degree of partition. Push up next para in view of the appeal involving questions of both fact and law, comma, the same is required to be heard on merits. Push up accordingly, a prima facie case has been made out. Push up. Thus, can 1 of 2025 is disposed of with the observation that the learned trial judge shall continue with the final degree proceedings but shall not draw up any final decree without the leave of this court till disposal of the appeal. Push up next para. In view of the appearance of the respondent through his learned advocate, comma, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards service, the trial court record shall be brought by special messenger at the cost of the appellant, deposited within a week from date. Push up the learned trial judge shall retain skeletal records for the purpose of proceeding with the final degree proceedings. Push up next para. The appellant shall also prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the matter, mention the appeal for enlistment as and when the same is ready for hearing.
Only one is not to dispose of and sale transfer of the undivided share, 1/3 share.
You have made an application.
Yes, yes, my lord. Can one is that, my lord. My lord, can one is that, my lord. Only that prayer is, my lord.
Will grant status quo to both parties.
My lord, my lord. That will suffice my purpose, my lord.
আরেকটা লাইন হবে ক্যান ওয়ান অফ মানে নো অর্ডার্স টু কস্টের আগে আর কি মানে শেষের প্যারাগ্রাফটা both parties shall remain restrained by an order of status quo from selling, transferring, alienating and or creating any third party interest in respect of the suit property and or changing the nature and character thereof, also till disposal of
My
property.
lord.
Okay. Next.
Item number 47.
47, my lord.
যদি কোর্ট না টাইম দেয়
My lord, I am being informed, my lord, by the clerk that Mr. Shukanto Das, my lord, he didn't come today to court, my lord, for his daughter's doctor appointment.
Not today. No order need to be recorded. You are not in the matter.
No, I'm
just not today. Not recording any order.
Item number 48.
Not today.
Item number 49.
Lord 49, Lord Mr. Kushal Chatterjee is appearing for the appellants, my lord.
Yes.
Lord, the service is incomplete, my lord.
So we'll keep it when?
Any day as your lordship pleases, my lord.
1 week?
1 week, my lord.
That counsel for the appellant submits that service has not yet been effected on the respondents. Accordingly, let the matter stand adjourned till, we are giving 2 weeks, till December 8, 2025.
As your lordship please.
You are Devrup Chaudhary?
Yes, my lord.
Only your name will be recorded. Give your name, not
My
Mr. Kushal Jha.
Yes.
Let him enjoy the not to attend. Yes.
Item number 50,
Not today.
51,
Your Lordship, I'm for the appellant in this case, Your Lordship. This is an appeal under Section 24 of Hindu Marriage Act for granting alimony pendenti lieti. Wide order dated 10th of April 2025, the learned trial court below ordered the
In fact,
ordered
wait a second, please. No, the appeal arises, you are the
I'm
wife.
I'm the wife, Your
So,
Lordship.
ex parte divorce decree was granted in favor of the husband.
Was granted in the favor of the husband, and I am coming for an appeal for an application under Section 24.
No, you are not paying for stay of the decree. If he remarries, then the appeal will become infructuous.
I'm praying for the stay for the decree.
You have not made an application for stay, only one application for alimony.
Then, Your Lordship, if you may kindly allow me, not today, I'll take instruction from my senior.
No, not today. We are directing to serve copy of this application on the other side.
Grateful,
Let that stage be over.
Grateful.
But please file immediately. Otherwise, if he remarries, nothing remains in the appeal.
I will, Your Lordship.
The appellant shall file, serve a. This is appealing for the first time.
Yes, Your Lordship.
The appellant shall serve a copy of Can 1 of 2025 on the respondent, indicating that the application shall be listed for hearing on December 15, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Grateful.
Thank you. What is your name?
Neelam Kumari, Your Lordship.
Neelam Kumar.
Kumari.
Acha, prothom line ekta din to, Miss Neelam Kumari, appearing for the appellant, submits that the present appeal arises out of a divorce decree obtained by the respondent. বলে তারপর যেটা বলি বাচ্চাগুলো অ্যাপিয়ার করলে নাম একদম কম্পিটেন্ট call on the next.
Lord 48, I missed it. Lord, only Lord, I pray for direction for service section 5 and leave.
No, if you have missed it, you have missed it. Nothing.
52,
I appear for the appellant, my lord. The husband is the appellant arising out of a refusal to pass a decree under Section 9. My application is only with regard to expeditious disposal of the appeal because I could not have preferred. Only one thing, may I serve and come back because I want to avail the service of mediation if that's possible. Otherwise,
very well. The present appeal arises out of the dismissal of a suit for restitution of conjugal rights, which of learned counsel appearing for the appellant husband candidly submits that a direction may be passed for service of copies of the application and the memorandum on the respondent in order to explore the possibilities of mediation. Full stop. Accordingly, the appellant shall serve copies of the memorandum of appeal as well as Can 1 of 2025 on the respondent, indicating that the application shall next be listed on December 15, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Since it is restitution, that is why.
Absolutely. We agree with you fully. This is a very intelligent approach.
Okay, I'm great.
Yes. Not today.
Grateful, my lord.
For what?
My lord, I was on behalf of respondent number 2.
Give your name, ma'am. Yes. And the item number also.
Yes, my lord, I'll write in the chat box. Grateful, my lord.
Next. It is not today. Nothing. Not.
55,
I'm for the appellant, my lord.
First time?
Yes, first time, my lord. 2 applications, one for section 5, another, my lord, my lord, for final degree of the partition suit to be stayed.
Can 1, 2.
Can 1, 2. Both are to be served.
One appellant?
Yes, one. No.
Several. Who are to be served? Check that.
My lord, I am the defendant number 1, 2, and 3.
Suit for?
Suit for, my lord, partition.
Others contested.
The plaintiff is, my lord, respondent number 1.
Seen that, but others have contested in the trial court.
Others have contested.
Then you have to serve.
Yes, I'll do it. Everyone is, my lord, a plaintiff.
Yes. The appellant shall serve copies of Can 1 of 2025 and Can 2. And Can 2 of 2025 on the respondents, indicating that the application shall be listed for hearing on December 15, 2025, when the appellants shall file an affidavit of service to that effect. Thanks.
Grateful. নামটা
স্লিপ দিয়ে দিন।
55 তো বললাম।
50 এটা আগেরটা কোনটা হলো? You are not in 54.
I'm in 55 my lord.
এই অর্ডারটা 55 এ করে দাও, 54 টা নট টুডে করে। নট টুডে কোনো অর্ডার রেকর্ড করতে হবে না, জাস্ট নট টুডে।
55 তো।
What is the party name of the parties of your Chandu Ali Khan?
Chandu Ali Khan is my lord 55, yes.
তাহলে অর্ডারটা 55 এ হবে, আর 54 এ কিছু করতে হবে না, নট টুডে। 54 এ কি হয়েছে? ওরা কোনো অর্ডার পাস করেছিলেন কি? মেয়েটা কিসে? না না, ওটা আগের মতো। 54
53 ছিল দিদি, 52 ও ছিল, 52 ও ছিল, 3 ছিল।
No, let us sort this out first.
52 my lord Mr. Mukherjee appeared.
Yes.
After that 53 my lord someone appeared from the my lord.
No, she was grateful because we must pass some order.
Yes,
So it must have been his
that was
matter.
53. That was also not today my lord.
Also not today.
That was also my lord not today order was passed after that my lord.
তোমার সর্ট আউট হয়ে গেছে কিনা দেখো, তুমি সবচেয়ে ইম্পর্টেন্ট এখানে। ওটা ওটা ইয়ে হলো অসুবিধা। আর এদের গুলো ঠিকঠাক হয়েছে যারা অ্যাপিয়ার করছে তাদের গুলো। You write the item also. Item. Mr. Banerjee, you also write the
Yes,
item.
I have already my lord.
Yes, call on the next one. Not today.
I appear for the respondents. I have instruction to appear for the respondents. my lord.
We are making not right.
Grateful. Okay, for the respondent. Some of the respondents.
Not
Not 69 for the petition. Lord, I am for the petition.
which matter?
59 my lord, tiny mix is not today.
59 we have made not. You are for in 59?
60.
59 we have made not. Yes. 60 you are for, is for the first time?
First time.
Then, fine. রেকর্ড আছে 100টা, কিন্তু কিছুই হয়নি, ওরা মুখ করার কিছু হয়নি। সিভিল ডিভিশন
ঠিক হবে না, একবার বলেছি।
This is against what sort of a degree?
Lord, the by the impugned order, Lord, the matrimonial suit of Lord under section 13B, but that has been dismissed.
Great.
Lord, because the wife.
So what is the scope of an stay?
No.
Injunction.
Injunction, there is no scope for. Lord,
Ask for injunction. So we'll dispose this up by passing the usual special messenger cost and all this.
Lord, the may I do one thing? Lord, the kindly direct me to make a service so that if he comes and the matter can be solved by your lordship, Lord.
No, service.
Yes, Lord.
No, injunction will reject. There is no.
No, I am not asking for injunction. Lord, kindly ask me to
put in postal cost and requisite. That will be service. The present appeal arises out of the present appeal arises out of a decree dismissing the appellant wife's suit for divorce. Full stop, next para, as such, we find no scope of grant of an injunction. Full stop, accordingly, can 1 of 2025 is disposed of by directing the appellant to put in postal cost and requisite for service of notice of the appeal on the respondent within a week from date. Full stop, the trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion as and when the same is ready for hearing. In fact, you have asked for these prayers also in this. For prayers are.
Yes, I have asked for.
Also these call for the Lord.
Yes, yes.
Not really, not today. Same.
So I'm for the opposite party.
We are not recording any order, not today. Yes.
64.
Same.
65.
Not today.
67. 68.
দেখে না লুকিয়ে আছে কেন? আর কোনো আশা নেই। অবস্থা খারাপ হয়ে গেছে, তাড়াতে পারলে মাছের জন্য তাড়াতাড়ি ঘুরে দাঁড়িয়ে গেছে, মাইন্ড চেঞ্জ করলে আউট ক্লোজ।